everyone. The committee will begin its hearing. Thank you. I declare open this hearing of the Senate Legal and Constitutional Affairs Legislation Committee for the Additional Estimates 2024-25. The Senate has referred to the committee the particulars of proposed expenditure for the 2024-25 for the portfolios of Home Affairs and the Attorney General and other related documents. These are additional estimates proceedings, and the outcomes to be heard during today's estimates are from the Attorney General's portfolio. The committee has set Monday the 24th of March 2025 as the date by which answers to questions on notice are to be returned. The committee has also decided that written questions on notice should be provided by the Secretariat by 5 p.m. Thursday the 6th of March 2025. Under Standing Order 26, the committee must take all evidence in public session. This includes answers to questions on notice. I remind all witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to the committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to a committee. Officers and senators are familiar with the rules of the Senate governing estimates hearings. If you need assistance, the Secretariat has copies of the rules. The Senate, by resolution in 1999, endorsed the following test of relevance of questions at estimates hearings. Any question going to the operations or financial positions of the department and agencies which are seeking funds in estimates are relevant questions for the purpose of estimates hearings. I remind officers that the Senate has resolved that there are no areas in connection with the expenditure of public funds where any person has discretion to withhold details or explanations from the Parliament or its committees unless the Parliament has expressly provided otherwise. The Senate has also resolved that an officer of the Department of the Commonwealth shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to a superior officer or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. I particularly draw the attention of witnesses to an order of the Senate of the 13th of May 2009 specifying the process by which a claim of public interest immunity should be raised. Witnesses are specifically reminded that a statement that the information or the document is confidential consists of advice to government is not a statement that meets the requirements of the order. Instead, witnesses are required to provide some specific indication of the harm to public interest that could result from the disclosure of information of the document. I remind senators that their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. Officers called upon for the first time to answer a question should state their full name and the position for Hansard record, and witnesses should speak clearly into the microphones. Mobile phones should now be switched off or turned to silent mode. I now welcome Senator the Honourable Don Farrell, representing the Attorney General. Good morning, Minister.
Good morning,
Minister, would you like to make an opening statement today?
Chair, thank you for the opportunity to make a statement, but on this occasion I'll defer to all of the members of the committee who may wish to ask questions.
Thank you, Minister. I also now call officers from the Attorney General's Department in relation to cross-portfolio corporate and general matters. Ms Jones, although you were here for a brief time last night, would you like to make an opening statement?
Thanks, Chair. No, I have no opening statement.
Great, thank you. Before we go to questions, I think it was remiss of me at 10:30 p.m. last night not to mention that we haven't made any agreement to bring the NAAC back throughout the program today. What I should have said is that they were dismissed because we didn't get to them last night, unfortunately. Whether there's a discussion about additional hearings and spillovers, that's a matter for senators. But those officers, hopefully, can head home. I believe some of them are even interstate, so hopefully they can get on those planes today. Thank you, and apologies again to those officers for not being clearer last night, but it was a pretty long day.
It was, thanks. We appreciate that guidance. Thanks very much.
Thank you. Now I'm going to hand the call to you, Senator Cash. We're in cross-portfolio and corporate and general matters, and as you know, I'm very strict about relevancy in this section. So Ms Jones will also provide direction about appropriate outcomes if there's an issue about where things come up.
Excellent. And just for the benefit of the committee then, I'm just going to table the letter from Senator Paul Scar and myself to the Secretary and the Secretary's response. And so my office, who is here, will have copies of that.
And the committee already has a copy.
Oh, just for the benefit, just to make sure. Could I just ask, no, my office just down there will have it. Thank you so much. Secretary, just some quick dates from you in relation to the Attorney-General's recent visit to Israel. Do you have the dates that the Attorney-General was in Israel?
Thanks, Senator. Yes, I do. If you can just give me 1 minute.
Absolutely, no, not a problem at all.
So the dates of the Attorney-General's visit to Israel was from the 13th to the 20th of January 2025.
13th to the 20th of January. Was he accompanied by departmental officials?
Yes, I accompanied him on that trip.
Yes, Secretary. Anybody else?
His Chief of Staff.
And was the department involved in the planning of the trip?
Yes, we were. In consultation with the Post and DFAT, but yes, we worked closely with the Post in preparing the agenda and the briefing.
Brilliant. Chair and Secretary, I also have some questions about the ICC court arrest warrant. I will take guidance as to where they should be asked. I have down here international and integrity or national security and criminal justice. I will take guidance before I launch.
That would be most appropriate in the national security and criminal justice group.
Excellent. Perfect. Just in terms of the period that the Attorney-General and yourself were in Israel, the 13th to the 20th of January, were acting instructions or arrangements put in place?
Yes, they were, Minister.
Yes, they were.
Senator.
Can I ask who was the acting Attorney-General at the time?
I believe it was the Minister for Finance. Yes, the Minister for Finance was...
The Minister for Finance. Excellent. Okay. You said the Attorney-General 13th to the 20th, and then the acting arrangements were with the Minister for Finance. When did the Attorney-General then resume his duties?
I would need to just check the specifics of the acting, but I think I'm just trying to be honest with you, Senator, I'm trying to remember when we arrived back.
Perhaps just seek guidance, and then we can come back. Oh, is it possible to get the answer? It's for the purposes of questioning later on this evening or this afternoon. Could we get the answer during this morning?
We'll endeavour to do that.
Excellent. Could I just now turn to the questions on notice that we asked at the last estimates hearing in which the department took on notice? I've done a check of the system and they remained, the ones I'm about to go through, remained unanswered as at last night. If I could just go through a number of them, and I think you'll have access to them obviously via your system. You recall that in the last estimates hearings, I tabled a number of tweets by ART Deputy President Claire Thompson, in which she named people using the C word, unfortunately, called them misogynistic toe rags, useless and the like, and called on people to vote at Albo MP. The questions I asked were about the vetting process, and you did state to me that you would take them on notice. In fact, you took 3 separate questions on notice about that issue. They were, and I'll read them out to you. I will table them as well, though, just for the ease of the committee, all of them. They were questions SBE 24006, SBE 2024-008, SBE 24009, SBE 24010, SBE 24011. Could you advise me on the status of those answers, please?
Yes, Senator, I'll need some assistance. I'll ask Mr Gifford to come to the table to assist.
Cameron Gifford, Chief Operating Officer. Good morning, Senator. My understanding as of this morning is that there are only 2 outstanding questions on notice from our last portfolio estimates appearance, one of which does relate to the matter that you're talking to, but I believe it's actually a question directed to the Administrative Review Tribunal. Otherwise, the other outstanding question on notice relates to spit hoods, both of which are currently under consideration with the Attorney's Office.
Okay, so just in terms of my review of the system yesterday, could I just ask, when were SBE 24006, when was that responded to?
Senator, I'll check on that for you this morning, but it could have been in one. There were a number of additional questions on notice which were tabled yesterday, but I'll check about the exact timing of that one.
And at what time yesterday were they tabled?
I'll get that additional information for you this morning, Senator.
Okay, and just in terms of when were they provided the draft answers then to the Attorney-General's Office?
Can I get you to repeat the numbers of the questions, please, Senator?
Yes, absolutely. SBE 24006, SBE 24008, SBE 24009, SBE 24010, SBE 24011.
Thank you, Senator. So I've got 006, 008, 009, 010, 011, and we'll check the timing for those.
Yep, thank you very much. So what time they were uploaded, but more importantly, when drafts from the department were provided to the Attorney-General's Office. The same in relation to SBE 24024. I asked questions about the Attorney-General's decision to grant parole to a terrorist offender. On notice, you declined to provide any information about the terrorist offender who was granted parole due to privacy concerns and to support the safe reintegration and rehabilitation of the terrorist offender into the community. I have to say that answer within itself was of concern to me, but I also asked questions about the advice given to the Attorney-General. That question was specifically taken on notice so that you could consider a public interest immunity claim. Again, as of yesterday, the question about the nature of the departmental advice had not been answered and there was no PII claim. Can I ask, what is now the status of the answer to that question?
Senator, I will have to check. The information before me suggests that actually there was a response table to that particular question on the 7th of January.
7th of January?
And I will confirm that if indeed that's
Would
not
you
the case.
Please? So just again, I've had my office looking for SBE 24006. That's still not available on the committee website.
Again, I will confirm this for you, Senator, but the information in front of me in relation to SBE 24006 is that the response was tabled on the 24th, so yesterday.
So that, yeah, and it's not on the committee's website, so they're not publicly available. That's the...
Yeah, Senator, it's not... the Secretary is responsible for uploading materials onto the committee website. The questions on notice were circulated yesterday. You would have been on that email because you're a participating member in this committee, but they haven't been.
But they haven't been publicly uploaded.
Our Secretariat was quite busy yesterday in Senate estimates.
No, I understand, that's fine.
But I'm not sure whether that's a question that Mr Gifford can answer, given that he's not responsible for uploading them to the website. But I'm sure that our Secretariat will try to do that as quickly as possible. So
just in terms of SBE 2424, could I ask when that response was provided to the AG's office?
Yes, Senator. So SBE 24024, I will check the timing of when that was provided to the Attorney's Office.
Thank you very much. Could I also then go to SBE 24004, and that was in relation to questions I had been asking about the Attorney-General's drafting, which, if you recall at the time, the bill that had been introduced had actually a flaw that had made it impossible to convict pedophiles for certain sexual crimes against children. That question was also taken on notice, 004. Can I just confirm with you when the response was provided?
Yes, Senator, I will check the timing of when that was provided. Again, that was in the batch of questions on notice which were tabled yesterday.
And can I then also when was the draft provided to the Attorney-General's office?
I will check that for you, Senator.
Thank you. When you say check, am I going to get that information today?
We will do our very best to have that information for you today.
What does that actually mean? Can I
check.
have it this morning so I can actually interrogate these matters further?
I understand
During
your question, Senator,
cross-portfolio?
I understand your question, Senator, and we'll do our very best to have that information for you as soon as we can.
Secretary, are you able to give me a guarantee that I will get these answers? I wouldn't have thought that it's
No,
necessarily
Senator Cash,
an issue,
that's not how
so I can interrogate.
Senator Cash, that's not how Senate estimates works. The officials are entitled to take questions on notice if they don't have them at hand. Often, officials in this portfolio do try to get you those answers well before the hearing ends. And Mr Gifford's committed to do that, but no one on at that table is required to give you a guarantee about getting an answer back to you if they don't have it with them right now.
Well, then that does pose a problem, because then, quite frankly, why not just take every question on notice and we could be over by lunchtime?
Well, that's what the coalition used to do. But
we could be over by lunchtime, but move on.
Senator Cash, I think the officials are trying to assist you, and they often do in a very timely manner, but there really is there's no standing order that requires Ms Jones to give you a guarantee of when she'll get that question back to you.
What I'm trying to work through is the delay with the department, or is the delay with the Attorney-General's office, which is why I'm giving the department the benefit of actually providing the answer to me, so I can interrogate where the delay has occurred. There is a pattern of delay. As I said yesterday at 9 a.m, we went online to have a look at what had actually been provided and uploaded, and unfortunately, all the questions in my pack had not been provided. So I'm trying to explore yet again what the delay is, whether or not the delay lies with the department, which I'm sure it doesn't, or with the Attorney-General's office. So I would now go to SBE 034. I asked questions about the significant legal issues that arise when the government grants visas to Palestinians fleeing Gaza, but those visas are subsequently cancelled on security or character grounds, potentially putting us in a situation where, like NZYQ, we have people on our shores who pose a risk to the community who cannot be deported. So in relation to 24034, when was that responded to?
Again, Senator, that was in the batch of questions on notice which were tabled yesterday. I will come back to you to the extent that I am able with information about when that draft was provided to the Attorney-General's office.
Thank you very much. Can I ask, Secretary, why the delay in answering all of these questions and providing them to the committee the day before estimates?
Senator, we do put a lot of effort into trying to ensure that we respond by the requested deadline for all questions on notice. I think in terms of the timing of the tabling, Mr Gifford has already taken it on notice, but he will seek details on that to clarify.
Secretary, do you sign off on the questions that go to the Attorney-General's office?
Not all of them, Senator. Some I may, but given the volume, we share it across myself and relevant senior officials.
Again, another one. SBE 24036. This was in relation to a settlement offer for the Brett cattle dispute. And again, this is something that we have pursued at estimates time and time again. The information that was provided made clear that the Attorney-General had, during his tenure, declined just 3 settlement offers, but you took on notice whether any of those related to Brett cattle. And again, can I ask, in relation to the answer to 036, when was that responded to?
036 again was in the batch of questions on notice tabled yesterday, Senator. Again, I will give you...
As to when the response was provided to the Attorney-General's office?
Indeed.
Again, another one, SBE 24082. And again, I asked a range of questions about the national strategy on counter-terrorism and the apparent breakdown in communications between the Attorney-General and his state and territory counterparts. And again, as of yesterday, when we viewed the system to obviously prepare further questions, there was nothing on the system. Can you give me the status update of 082?
082 was again tabled yesterday, and not wishing to anticipate your next question, but I'll also come back with further details in terms of when a draft was provided.
Your anticipation is very good. In relation to another one, SBE 24081, this was a range of questions about foreign sovereign wealth funds funding class action litigation in Australia for profit or for their own strategic and political ends. The questions I was asking were very much, when we were discussing it at the last estimates, the concern about not only the foreign interference risks, but the potential delay for our judicial system to be abused by a foreign state to cause damage to Australia's economy and to block major projects. Again, 081, could I ask what the status is of this one?
081 response was tabled on the 24th of February.
So that was the 24th of... Yes. Oh, that was yesterday?
Yesterday.
That was part of that batch?
Yes.
That was part of the batch, okay, so the 24th. And again, when were the draft answers provided to the Attorney-General's office?
I will check and return.
Thank you. So the questions that were tabled yesterday, the vetting process for the Deputy President of the ART, the AG granting parole to a terrorist offender, a bill from the department that made it impossible to convict pedophiles. There is also another question in relation to, and we've discussed this at length, the basic information in relation to the production of ministerial submissions, which I still can't get any answers on, the significant legal issues around the grant of visas to Palestinians, the Brett cattle dispute, a breakdown in the negotiations on the national strategy on counter-terrorism, and the foreign interference risk around foreign sovereign wealth fund class actions in Australia. The issue I have is that none of that information was provided on time. All was delayed. For people who actually wanted to see the answers, the information is still not publicly available. Can I just confirm that my summation is correct?
Senator, we took on notice 255 questions from both last estimates appearance, the spillover hearing and a cross-portfolio appearance at the Finance and Public Administration Committee. Of the 255 questions taken on notice, 253 responses, totalling well over 1,000 pages of material, has been tabled.
And that is the normal role of the department at Senate estimates. If you take a question on notice, you are expected, the chair reads out a brief at the very beginning as to what the role of the department is and the responsibilities of the department to actually provide this information on time. And as I said, can I ask Secretary, was this deliberately tabled at the last minute?
Senator, as I said earlier, we work hard to try and ensure that all questions on notice are prepared and ready to be tabled within the timeframes. I acknowledge sometimes we don't always hit those timeframes, particularly with the complex cross-portfolio questions, but certainly as a department and as a secretary, I'm quite committed to progressing questions on notice in a timely way.
And you can see, therefore, why, in relation to when the department provided the answers to the Attorney-General's Office and the Attorney-General's Office gave the go-ahead for them to be released to the committee is so important. So I can understand whether or not the delay was from the department's perspective, or alternatively, whether or not they were sat on in the Attorney-General's Office and conveniently released the day before estimates. Secretary, again, are you concerned that such a delay, and again, they're not publicly available, and I had a number of people who actually wanted to see what the responses to the questions were, so that we could potentially prepare more questions for estimates today. Are you concerned that this taints the perception of your department's role as an impartial, apolitical public service?
Senator, I think we remain committed to what is the responsibility of the department to seek to prepare answers in an appropriate time frame, and that will continue to be our approach.
Secretary, do you have any knowledge in relation to any of these questions? As you said, you actually do settle some of them when they were provided to the Attorney-General's Office.
I don't. I would have to, as Mr. Gifford has done. I would rely on his advice about when they were submitted to the Attorney-General's Office.
And I won't anticipate your response to the question I'm going to ask Mr. Gifford. But do you have any knowledge in relation to any of these questions as to when they were provided to the Attorney-General's Department?
Senator, if it would assist, I think if I could redirect you to the attachment we provided in response to the letter received from opposition senators through the committee prior to this estimates hearing. It does ask for us to also provide when draft questions on notice were provided to the Attorney-General's Office. We have provided a table which provides a list of dates and the number of questions on notice which were provided on any particular day. What it doesn't provide, and what I've taken on notice to check this morning, is when specific questions on notices were drafted and provided to the Attorney-General's Office.
So we still don't have those answers to my questions?
No, Senator, but my team is taking the notes as we speak and checking those as you have requested.
Yep. So again, I've tabled the letter, and unfortunately, when you go to that part, the response, it actually doesn't assist me in terms of the questions that I'm asking. What worries me is the reality is that politically inconvenient questions are delayed and released at the last minute, which again I go to why I want to give the department the benefit of the doubt as to when they provided the answers to the Attorney-General's Office, because I would hate to think that the department is deliberately delaying the answers to these questions, because obviously then I'd have significant concerns there. Chair, unfortunately, given I don't have any further information that I can prosecute, I will turn to another topic.
How about Senator Cash? Yeah, let's do that. I'll essentially give you another block of time. I was going to share the call, but
I'm happy to share the call because this is going to be quite a significant.
Yeah, okay, that's fine.
And so we can share the call there.
We'll do that. Again, same proviso around cross-portfolio, but off you go, Senator Ghosh.
Okay, and thank you, Chair, and to the extent that these need to be answered by other members or in other outcomes, then please just let me know. There's been a deeply concerning rise in anti-Semitism and anti-Semitic incidents in Australia since the attacks of the 7th of October. And I'd like to ask about the response that the Attorney-General's Department has led, both in terms of across the various parts of the department and then also in terms of the Attorney-General's Department's role in a whole-of-government effort to combat this rise in anti-Semitism. May I start with the legislative responses? Are you able to outline those responses since the 7th of October?
Thank you for the question, Senator. And consistent with our role with responsibilities for a range of legislative frameworks that are relevant in this context, the Department's been involved in progressing a number of pieces of legislation that have gone into the Parliament. If you can just bear with me, I'm trying to bring up the list, and I will ask Ms Chidgey to come to the table because it's her area that have been responsible for a lot of these initiatives. So I might hand over to her. Link isn't
Sarah Chidgey, Deputy Secretary, National Security and Criminal Justice Group. Senator, I'd probably highlight 3 pieces of legislation, the most recent being the Hate Crimes Bill, which significantly strengthened and added to offences dealing with advocating or threatening violence against groups or members of groups, and also added new offences for advocating or threatening property damage, including to places of worship and other property owner occupied by Jewish groups, but also a range of other groups. That was passed recently, and they're quite significant new offences to deal with anti-Semitism and hate crimes. We also, the government enacted legislation last year to prohibit the Nazi salute, Nazi symbols, and public display of other terrorist organisation symbols. And later last year as well, legislation was passed to deal with doxing, the malicious distribution of personal information. So those are some of the core legislative measures.
Senator, I would add to that most recently, following the National Cabinet meeting where there was a focused discussion around responses to anti-Semitism, there was a decision taken to develop, ask the Standing Committee of Attorneys General to take work forward on the development of a hate crimes register that this department is leading the work on. The agreement on the process for the development of that and working with jurisdictions was achieved at the Standing Committee of Attorneys General meeting in Sydney on Friday, the 21st of February. So we now have the agreement to work with the states and the territories and their relevant agencies to develop this hate crimes register. In addition to that, the department is also responsible for managing a number of programs and grants that are relevant to supporting Jewish community organisations and institutions with security and other issues. And I'll ask Ms Chidgey just to talk a bit about those programs.
Sure.
There's been a commitment in total of over $78 million to improve safety and security at Australian Jewish community sites. And there was an initial commitment after the 7th of October attacks of $25 million to provide safety and security at Jewish sites across the country through the Executive Council of Australian Jewry. And then that was expanded earlier this year by another $32.5 million, so $57.5 million in total available through the Executive Council of Australian Jewry for security. In addition, there was $21 million that was provided to 57 Jewish schools, preschools, synagogues and community sites under the $50 million Securing Faith-Based Places grant program.
Thank you. Can I delve a little into the discussions at the Standing Committees of Attorneys General on anti-Semitism and ask really, were there certain key elements or outcomes or common patterns across the states that emerged from that discussion in relation to both anti-Semitism incidents and then responses at a state level?
Senator, in addition to the item where the proposal around a hate crimes register was discussed and agreed, there was a separate item that was led by New South Wales and Victoria, recognising that a significant proportion of anti-Semitic acts that have been happening in recent years have been in those states. They led a discussion on best practice, both legislative and program responses around anti-Semitism, which I think all jurisdictions found incredibly helpful to understand the types of legislative reforms that had occurred in those jurisdictions, and a commitment to establish an officials working group that would bring all jurisdictions together to look at options for strengthening legislative frameworks and other measures such as community-focused programs that could seek to address the rise of anti-Semitism. So I think it was clear that there was a very strong message around the heightened that anti-Semitism is aberrant and should be addressed, and all jurisdictions were very committed to that.
Can I ask about the key elements of that best practice that was shared? Are you able to share that with us?
New South Wales and Victoria had led the work to particularly look across all jurisdictions' legislative responses and provided a sort of comprehensive picture of all the measures states and territories and the Commonwealth had in place with the different legislative measures that had been taken. There was discussion about the policing responses, including the AFP's Operation Avalite, that had been put in place, and as the Secretary mentioned, also programs and funding for security arrangements that a number of jurisdictions, obviously I've talked through what the Commonwealth has in that area as well. So those were some of the areas that were discussed in detail.
Is there a place where we can find an aggregated form of that or a summary of that discussion, or was that simply a feature of the discussion itself?
It was a feature of the discussion. There's a communique on the Attorney General's website. It is just a much more high-level outcome that just has that agreement to share best practice and information, but doesn't have all of the detail on existing measures.
In relation to the, I think it was, you said $57.5 million in grants in relation to the protection of sites around the country, are those grants issued to community organisations for them to then secure protection or security, or are they issued directly to the security companies?
So there's $78 million in grants altogether.
Oh, okay. Sorry.
The $57.5 million has been provided to the Executive Council of Australian Jewry, and that organisation, as the kind of prominent peak body for the Jewish community, is then administering. It's got a round that's open at the moment that I think closes on the 19th of March for a second round. So Jewish organisations can seek funding through that process through the Executive Council of Australian Jewry that's administering the more detailed decision making on grants that come through them. In addition to that, I mentioned the $21 million that was provided through the Securing Faith-Based Places grant program, which was more broadly available to different faiths, but the organisations of the Jewish faith, 57 of them, received grants that was administered through the Attorney General's Department with the assistance of the Grants Hub in the Industry Department, and allocated by the Attorney General based on that advice. And then each of the organisations that directly received those grants applies them to the security measures that they sought the funding for, be it a range of security infrastructure, but also guarding and other security services.
Yeah.
Okay. You referred to community-focused programs, and we've touched on the security aspects of those. Are you able to elaborate on what other community-focused programs have been supported by the department or various parts of the government under the department's leadership?
So those are the main ones for safety and security. I'm aware that the Department of Home Affairs administers a number of social cohesion programs as well.
There was a reference to an incidents register or an incidents database. Are you able to tell us a little bit more about that?
Yes, so we have done initial work in the department following National Cabinet's agreement to establish the national database and done some initial work within the Commonwealth with the AFP, the Australian Criminal Intelligence Commission, the Australian Institute of Criminology, Department of Home Affairs and Prime Minister and Cabinet on an understanding of the purpose and scope and what systems particularly and data there might already be available to support that database. And on Monday last week, I met with the Deputy Commissioners from each state and territory police force and the AFP to have an initial discussion about the database as well, particularly focusing on data and systems that could be used to provide a sort of basis for moving quite quickly to set something up. And obviously with the outcome of the Standing Council of Attorneys General on Friday last week, the department started the process of setting up a formal working group with police and justice agency representatives from all jurisdictions that will do more of that work in detail. Also starting a program of consultation with affected community groups as well to understand their expectations. And in some cases, we know that there are a number of existing registers and databases that some of those community organisations maintain. So looking at what exists in that space and how that will fit with a national database.
In terms of those repositories that exist at a government level and then there are some at a community level, are you able to sketch out some of the work that's been done or some of those sources both within government and then what you're receiving from community groups?
We're at an early stage, so some of the initial discussions with police that they do have different levels of information, so there will be some work I think to identify and define sort of common information sets that we can provide on a consistent national basis. And we've also had a look at some of the existing registers, I think particularly that the Jewish community maintain or the Islamic community as well. But we're at the beginning of sort of looking across all of that existing information, identifying what is a reliable, consistent data set that we would provide the basis for an initial database.
In relation to the ongoing maintenance of the database, where do you anticipate information will come from and how do organisations both within government and outside of government contribute to that database?
So that's something we'll need to work through with the states and territories and consult community organisations on. Our expectation is probably the primary contributing agencies will be from government police agencies who obviously receive a lot of hate crime reports and will have that information in their systems. But it is something where we're at the early stages of identifying what information holdings organisations have and having those discussions about the scope of the database and the data sets.
Do you anticipate having a public reporting facility?
we would anticipate making information from the database publicly available to provide a sort of public picture of hate crime and incidents.
Outside of the law enforcement context, how do you anticipate, or are there ways in which you're planning to encourage reporting across other sections of government that might also have access to information about issues that occur, anti-Semitic incidents that occur? And I'm thinking now in terms of social services or education, or how does the rest of government contribute to this database?
That is something we'll be considering in the options for developing the database. I know from speaking to policing agencies, there's a strong interest in being able to use existing information sources and systems as much as possible to set something up quickly. So we'll have a look at across government at what information there might be. I don't want to speculate, but it might be that there's an initial database with certain data sets that can then be expanded and built out over time.
Thank you. Thank you, Chair.
Thanks, Senator Ghosh. Senator Cash, we're coming back to you.
And I'll actually pick up on the line of questioning that Senator Ghosh was pursuing in relation to anti-Semitism. I'm going to table 3 documents for the benefit of the committee and for the department. The first is an email from yesterday to me from psychiatrist Jacqueline Rakov in relation to a letter dated the 26th of October 2023 that was sent to Minister Mark Butler, signed by 235 medical professionals. This has been de-identified just for the benefit of the committee, and it was CC'd to the Attorney-General, Minister O'Neill and Mr Josh Burns. It also has an attachment. Secretary, you might already be aware of the letter, seeing as it was sent on the 26th of October 2023. So psychiatrist Jacqueline Rakov wrote a letter to Minister Mark Butler on this date. It was, as I said, signed by 235 other medical professionals in the wake of Hamas's terrorist attacks in Israel. The letter itself expressed alarm that many doctors were endorsing pro-Hamas views on social media. As I said, the letter was CC'd to the Attorney-General, and in the covering email of yesterday, Ms Rakov says it was also sent to them all again for follow-up on November the 23rd, 2023. She received automated replies from all of their officers, but 0 responses. So it was sent twice to everybody that I said, October the 26th, 2023, November the 23rd, 2023, and it was sent by the group of, a significant group of doctors, 235 plus Ms Rakov, in relation to, or in the wake of, Hamas's terrorist attacks. So, Secretary, can you just take me through the department's knowledge of this letter, please?
Senator, I may need to take that on notice. That I do not recall having seen this myself previously.
Is there anybody here in the room who may be aware of this letter, given, as I said twice, it has been sent? But more than that, it is the very significant issues, and we'll work through them, that it raises. So this is back in 2023, post the Hamas terrorist attacks in Israel. A letter is sent by a group of doctors who are very, very concerned about doctors within the Australian system endorsing pro-Hamas views on social media. This has also been recently reported on in the media. So I just do want to work through what happened to this letter when it went to the Attorney-General.
Senator, I would need to take that on notice. As I
again, is there anyone in the room who could help you?
No. No, we would need to take it on notice. It is, I believe, the first time that I've seen it.
Well, if I could just work through some process questions then in relation to...
Senator Cash, can I just ask from a process in terms of relevancy for this portfolio, we've got the letter but not who it was sent to. I'm not questioning.
We've de-identified it quite deliberately because of we didn't want to expose the doctors who actually signed this.
No.
The original letter does have the names, just so you know, and the covering email I confirmed last night with Dr. Jacqueline Rakov is actually the events that had occurred.
Sure. I guess the question is whether it was sent to the department or to the. It says Mark Dreyfus. It might have gone to his parliamentary address or something like that. So, if you have more information about who the original letter was sent to, we can table that.
I don't have it at this point in time. I can obtain that from the witness. Can I just work through the other process questions then? It just because there is such a significant concern as set out in this letter. Obviously, it's also gone to Minister Butler as the relevant minister. We raised this yesterday in the Department of Prime Minister and Cabinet to ascertain what level of knowledge there was, given the incident that has occurred recently with the 2 nurses in New South Wales and the death threats that they had made to Israeli patients. So in terms of this letter, it raises concerns about, and it's actually stated in the letter, about 3/4 of the way down, quote, systemic problems of anti-Semitism in the medical system. And it expressly raises concerns about discrimination. Just as a matter of course then, the department and obviously the Attorney-General, I'm assuming would be deeply interested in matters of alleged anti-Semitic discrimination, not least because discrimination is one of the portfolio responsibilities of this department and the Attorney-General?
Well, Senator, what I would note is obviously the department has a responsibility around our legislative frameworks and as Ms Shiji explained just a little bit earlier to Senator Gosh, there has been a range of legislative reform that has happened over the last 12 months, specifically to address the rise of anti-Semitism and hate speech. We also have a role administering broadly the Racial Discrimination Act and other anti-discrimination acts. But for matters of if people have complaints in that regard, it's a matter to be referred to the Australian Human Rights Commission. This letter, and I'm just reading it very quickly why it's in front of me, but is obviously raising specific issues in relation to the healthcare sector and has been addressed to the Minister for Health.
No, I understand that. The point being, though, the content of the letter is incredibly disturbing. The survey in the letter is incredibly disturbing. There is an attachment which, because it cannot be identified, I haven't tabled, which is utterly horrific social media and instances of anti-Semitism. So again, the question I have is, if this type of letter, what happens to it when it gets to the department by way of process?
Well, I wouldn't restrict my answer to saying this type of letter. If there's correspondence that's gone to the attorney that is for him to respond to, then he would provide it to the department to assist in the preparation of a response, or alternatively ask the department to respond on his behalf. And that's the process that applies generally in relation to correspondence.
So if the letter has been seen by the department, what would actually the department then do, given the serious nature of what has been, I'm not even going to say alleged, raised in the letter, given the survey results that are attached to it, given, as I said, it is a portfolio responsibility of this department and the Attorney-General in relation to discrimination and these types of issues. What would be the normal process?
Well, Senator, I think, as I said, I need to take on notice whether or not this was sent to the department. Obviously, if correspondence raises an issue that is the responsibility of the Attorney-General or the department, then we would consider the issue. But this has been directed to the Minister for Health and Aged Care.
Yeah, so I have got confirmation now. It was originally sent to Mark Butler at health.gov.au. It was CC'd to Claire O'Neill, Josh Burns and Mark Dreyfus at mp.aph.gov.au. So it was received, as I said, twice, the letter. And if you go to my covering email, dated the 24th of February, because I did confirm this last night, this is from Dr. Jacqueline Rakov. As you know, this letter was sent to Mark Butler and Mark Dreyfus, Josh Burns and Claire O'Neill on October the 26th, 2023. It was also sent to them all for follow-up on November the 23rd, 2023. I got automated replies from all of their officers, but 0 responses, and here we are. I'm happy for this to be tabled at Senate estimates as deemed necessary. So now that we know that, it was sent to mark.dreyfus.mp@aph.gov.au. Did Mr Dreyfus or his office forward this to the department?
Senator, I've taken on notice that we will seek to get an answer on that.
Yeah, are you able to confirm then, your evidence to the committee was that you would normally expect the attorney to pass this on to the department for consideration and response?
Senator, that's a slight variation of what I said. I said the usual process is if correspondence is received by the Attorney-General that relates to his responsibilities, he would refer it to the department for consideration and or response.
Are you able to just check, because I've got a whole other line of questioning that I'll be pursuing, whether or not this was passed on? Because the issue I'm having is this. When I talked to this particular psychiatrist, and a number of the doctors were following up with this yesterday, that they are very concerned that given the issue with the 2 nurses in New South Wales, which I'm sure the department are fully aware of, the fact that post the Hamas terrorist attack in Israel on the 7th of October 2023, 235 plus Dr. Rakov doctors taken upon themselves to write to the government, courtesy of the Health Minister, CCing in particular Mark Dreyfus, the Attorney-General, because of his role as the Attorney-General, and the fact that it is a portfolio responsibility discrimination. And as I said, the officers did receive the letters because on the first occasion there was an automated response. On the second occasion there was an automated response. You're unable to tell me whether or not it was passed on to you, and I actually would have thought a letter of this significance, if it had been passed on, I would have thought you would actually remember it, given, as I said, that it is just terrible what is in this letter. My greatest worry is it was not passed on, it was not actioned, it was not deemed important enough. Jump forward to February 2025, and what we now have is the greatest fears of, in particular, Jewish doctors within Australia who raised this issue in 2023, now coming to light with death threats made by these particular people, the 2 nurses, in relation to Israelis and Jewish patients. Could I ask, what would be the basis for not responding to these very serious allegations if the Attorney-General's office did receive the letter, which we know they did?
Senator, I can't answer that. I'll just repeat, we will take on notice whether or not it was provided to the department and seek to clarify that.
And I'm assuming if it was provided with the department, then a process would have been gone through. Minister, could I ask
to
you...
the break, and we'll, the committee will have its morning tea break now as scheduled, and we'll be back at 10:15. Thank you. will resume its hearing, and we're continuing our questioning of cost portfolio and general matters. Ms Jones, Senator Rennick has some questions, noting that the NAAC we weren't able to get to last night, but you might be able to assist with the direction of questioning. So, Senator Rennick, you have the call.
Thanks, Chair. Look, my question is regarding some correspondence that I wrote that was written to the Attorney-General last year regarding the failure of the head of the NAAC, Commissioner Brereton, to disclose a conflict of interest. And it is our belief and my belief that given that he failed to disclose a conflict of interest, he should have been removed from head of the National Corruption Commission. I'm just wondering whether or not the Attorney-General's office has a position on the fact that Commissioner Brereton didn't actually disclose the conflict of interest and if he should stay in his role.
Senator, I think that's a question for the Minister.
Okay, fine.
Could you repeat the question, please, Senator?
You're welcome, Minister. So effectively, I'll just read some of this out. A NAAC investigation found Commissioner Brereton guilty of misconduct because despite declaring a conflict of interest in relation to robo-debt, the Commissioner stayed comprehensively involved until the decision had been finalised. The investigation found it was due to a mistake in law, but that finding has no credibility whatsoever. Commissioner Brereton is a former Supreme Court judge and the head of the Federal Corruption Watchdog, and conflict declarations are a fundamental part of the judicial process. It is incomprehensible to suggest that the Commissioner made such a basic mistake. Commissioner Brereton was quoted in the media saying, perhaps the most important lesson is that we are not the best person to manage our own conflict of interest. That is an outrageous statement and has no credibility whatsoever.
That's your assertion, Senator?
Yeah. Parts of what I just read was a letter sent to the Attorney-General, but I'd just like to know what the Attorney-General thinks about the fact that we've got the head of a National Corruption Watchdog, former Supreme Court judge, that couldn't disclose a conflict of interest, or did disclose a conflict of interest but stayed in the role anyway, didn't excuse himself.
Well, I mean, the first observation I would make about that is that there has been disclosure of that conflict. It has been examined, and from my understanding, you'll appreciate this is not my portfolio area, Senator, but from what I understand has occurred here is that the matter, so Mr Brereton made a decision not to further investigate a number of people involved in the so-called robo-debt issue. That decision was challenged. An issue had been raised about conflict of interest, and as a result of that determination, the National Anti-Corruption Body is now examining the issue as to whether there was inappropriate behaviour in that robo-debt process. I would have thought that's an acceptable outcome in the circumstances. Mr Brereton may have made the observation, as you've just quoted, that perhaps the individual themselves are not the best persons to make a determination on these sorts of issues. I don't think that's...
But surely if you've got a conflict of interest, you disclose, you step aside.
Senator, I very quietly listened and in fact asked you to repeat your question so that I fully understood what you were asking me. From time to time, in ordinary court proceedings, judges are required to make decisions about whether they should absent themselves from the course of hearings, decisions about conflict of interests. I don't think there's anything particularly unusual about what's gone on here, and I think to the extent the that there may have been issues. Those issues have now been resolved by the processes. So I suppose the main observation I would make is that the processes have been robust enough that the correct outcome has occurred, and the investigations that perhaps should have started earlier are now underway, and at some point into the future we will get a result of whatever inquiries the anti-corruption body has found.
Can you see how
Senator
this...
Rennick, before you continue, I can't vet your questions, but I do have to make sure that they are relevant to the portfolio that we're asking questions about. Senators essentially dismissed the NAAC last night because we weren't able to get to them from the hearing. Questions relating to the NAAC are relevant to when the NAAC is appearing. Other senators won't have the opportunity or wouldn't have had the opportunity to ask questions about the NAAC. I don't want to jump back and forth between our program for an agency that we have dismissed. I'm trying to let you ask questions that are relevant to cross-portfolio. I'd also note that the Minister appearing today comes prepared and briefed to talk to the agencies that are appearing. NAAC was not scheduled for today, so you might need to be mindful of that when you're asking your questions. If you have questions relevant to cross-portfolio, please put them. Otherwise, if there are questions more broadly for NAAC, unfortunately, we don't have an opportunity today to ask those questions.
Okay, thanks, Chair. I'll just finish with one
Chair, just
simple question.
On that, I wouldn't. I appreciate your ruling. I wouldn't want Senator Rennick to think that I in any way don't want to answer his questions. And every question has an answer, and I'm prepared to assist the committee in ensuring that all the questions that the senators have get answered in the appropriate
you're a good man,
way.
Donny.
Thank you, Minister.
But no, seriously, seriously.
But order.
Yeah.
Can I just be clear, though,
serious,
Minister? Thank you for that, and I know that you would be very willing to answer those questions. I am more concerned about the other senators that are not here, who I will hear from shortly if they do not get a chance to ask questions about the NAAC.
I understand, but I just wanted to make it clear the government, will answer every question
Senator
that we're
Rennick,
asked.
You have the call.
Okay, just one, thanks. But I guess it's the perception in the public that we want to make sure we maintain the utmost standards of independence and scrutiny, and we've got our own NAAC commissioner failing to remove himself when he had a conflict of interest. And I guess it's the pub test here. So while we may not know the ins and outs of the details, it's the pub test of the whole point of this National Corruption Commission was to crack down on things like conflicts of interests and little bits of grey areas and things like that. Do you think that it's
with respect, Senator, the whole point of the NAAC was to root out corruption in our public service, in our politicians. And I think that's what it's doing, to be honest with you. I think it's doing exactly the job that we, gave it. I mean, I would remind you that the NAAC got the support of both the government and the opposition when it was established, and I think it's doing its job.
Okay, I'll leave it at that. Thanks, Chair.
Thank you so much, Senator Rennick. Senator Cash, we're going to come back to you again. I understand you've got a few questions in
yes,
this.
thank you very much.
And then I'll hand the call to Senator Polly, I believe.
If I could just go back to the line of questioning that I was pursuing in relation to the letter sent by psychiatrist Jacqueline Rakov to Minister Mark Butler, but CC to others, including the Attorney-General. Secretary, have you been able to confirm whether you received the letter from the Attorney-General in either October of 2023, when it was first sent to his email address, or secondly in November, when it was again sent to his email address?
Senator, I don't have an answer yet. I have requested that inquiry be undertaken.
Thank you very much. I do appreciate that.
I think we just have to, there's a central system where we register any correspondence that comes from the Attorney's Office into the department, and that is being checked.
Yep, thank you. Can you confirm that there's no work from the Attorney-General's department being undertaken in response to the letter from October 2023?
Again, I would like to take that on notice, or try to check and have an answer for you today. Certainly, we would look to assist any department that was working on any issues that were relevant to our responsibilities. So I'm just seeking to get some clarity from colleagues here about what engagement we may be having generally with other portfolios.
It wouldn't even be other portfolios, given the nature of the discriminatory comments. I'm assuming that it would sit squarely in this portfolio, seeing as we deal with discrimination in this portfolio.
Well, I think, as I said earlier, if we received material or information that indicated potential discrimination, it would be a matter for the individuals to make a complaint to the Australian Human Rights Commission. That's the appropriate body to consider complaints around discrimination. Equally, if there was anything to indicate any criminal conduct, then there would be a matter for law enforcement agencies to consider. So it would be a matter for the agencies that have particular responsibilities.
Yeah, I think when you familiarise yourself, unfortunately, with the letter, you will see that it is far more serious than advising people to go and make a claim in the Human Rights Commission. Given in particular, this followed the, as I said, October 7th Hamas attack. The conduct is utterly reprehensible. Comparing Jews to Nazis, categorising the contributions of Jewish colleagues as biased crap, referring to Jewish colleagues in the medical profession as overlords, pro-war players and gronks, referring to Jewish colleagues as embracing victimhood, having been somehow indoctrinated into lacking any basic empathy for Palestinians as human beings, grown up steeped in Zionist propaganda, or victims of one-sided education and media which views Palestinians as less than human, censoring any reference to the word Jew or Jewish, minimising the actions of Hamas, including expressing sympathy and support for Hamas, victim blaming Jewish women who were vilely sexually assaulted by Hamas at a rave, attempts to delegitimise so-called rape allegations, calling the reporting of Hamas murderer of babies a barrage of misinformation and propaganda, becoming irritated at Jewish colleagues who made comments about the traumatising effects of the largest single massacre of Jewish people since the Holocaust. I put it to you that given what the letter contains, that it was signed by 235 doctors who are actually scared, that you would possibly remember had that letter been passed on to you or your department by the Attorney-General. Do you think you would remember, given what I've just read out?
Senator, as I said, we've taken on notice to seek to confirm whether or not the letter was provided to the department.
Are you able to confirm that with me today? Because I will have questions later on in the day in another section then about this. But at this point in time, your evidence is you're still not sure whether Mr Dreyfus ever passed on the letter to you or the department. Is that correct?
I need to check our systems to see if that is the case.
Thank you very much. Could I just move on to a short line of questioning before I pursue another topic? These ones will be for the Minister in the first instance. Minister, we've received some disturbing reports. It is from an anonymous whistleblower about a fundraiser attended by Mr Dreyfus as the Attorney-General, where the Attorney-General reportedly boasted that the government was still planning to go ahead with a version of The Voice, and he then proceeded to outline to those at the event the things the government was doing to get around the referendum result. So my first question is, Minister, has the government truly accepted the 60-40 defeat of the Voice referendum?
Yes.
Thank you. Can you categorically guarantee that if re-elected, the Albanese government will respect the will of the people and will rule out any attempts to try and circumvent the referendum result?
Well, the government has no intentions of circumventing the referendum result, Senator. We took the policy of a voice to Parliament to the electorate at the last election. The government was successful in forming government. We honoured the undertaking that we had made to the Australian people, and we put the referendum to the Australian people year before last, and that referendum was defeated, and the government accepts the result of the referendum. I mean, I make the observation that constitutional change has always been very difficult in this country, and nothing has changed with the vote on the Voice.
Just in terms of, there were three components: Voice, treaty and truth. Can you also rule out attempts in the next Parliament to force treaty and truth on the Australian people?
I don't anticipate, what might occur in the next Parliament, Senator. These are matters for the government of the day. I'm very hopeful and very confident that the good work that this government has done will result in its successful re-election, but I'm not in the business of telling the next Parliament what they should and should not do. We will take our policies to the electorate, and everybody will know exactly what it is that this government, if we are re-elected, will do during the next term. We have, as I said before, we took the policy of a voice to the people at the last election. We were elected with a majority. That majority, very significantly, I might add, came from your home state of Western Australia, Senator Cash. Beg your pardon, Senator? Not from my home state. No, Senator Cash. Senator Cash, home state. I'm referring to all of the seats that switched from Liberal to Labor, and for that matter, Liberal to Teal in Western Australia at the last election. And so we did what we said we were going to do, and the Australian people can have great faith that if we are re-elected, as I hope we are sometime in the next few weeks, that we will do what we say in the next Parliament.
Well, you gave us Senator Payman in the West. How did that work out for you?
I didn't give you Senator Payman. The Western Australian, the Western.
Correct. The Labor Party did. How's that worked out for you? How's that worked out for the people of Western Australia?
Senator, you just had Senator Rennick sitting right next to you. You don't make any reference to him. Look, Could I just confirm then, just in terms of your answer, what type of treaty and truth would you take to the electorate then? Look, this is not my portfolio area, and I don't pretend to speak on behalf of the minister who is responsible for this area. What I do say is that the Australian people will be very clear about what it is that this government, if we are re-elected in the next term, intend to do, and whatever promises we make to the Australian people, we will honour them, and we'll pursue those issues in the next Parliament.
Can I just confirm, though, you're not ruling out a treaty under a re-elected Albanese government.
What I'm saying is that it will be very clear what our policies are in the lead up to the next election, and the Australian people will be under no illusion about what this government will, and for that matter won't do, if we are lucky enough to be re-elected in a few weeks' time.
Well, the concern I have then is, why is Mr Dreyfus allegedly telling people that he wants to go ahead with a version of The Voice and proceeding to outline at this function, according to the whistleblower, things that the government was doing to get around the referendum result?
Senator, look, my understanding, this is an anonymous claim at some.
It's a whistleblower
event.
for obvious reasons. They don't want to be
it's anonymous. It's anonymous.
Attacked.
It's an anonymous accusation. I don't think it's fair on the minister to put to him anonymous allegations. Minister Dreyfus has been doing a terrific job in a difficult portfolio at a very difficult time in history. I don't think it's fair on him to put unnamed and unsourced allegations about things he may or may not have said. And I'm certainly not going to dignify those allegations with a response.
Just in terms of government policy then, yes or no, will you pursue treaty? And it's easy to rule out if you won't.
Look, what the government will take to the next election will be very, very clear. You'll have there will be no doubts about what we will and won't do. This is not my portfolio area as much as I would like it to be.
It's probably also not.
I thought you liked your job.
This portfolio either, Senator.
I do like my job.
Come on, I know you like your job.
The Minister for Indigenous
but there's plenty of other
will
things
appear later this week
that I like as well.
So Senator Farrell, just a simple question then: yes or no? Will you pursue treaty or truth?
Look, you've asked me the same question 3 times.
I'm trying to give you an opportunity to say no.
Well, no,
I can say no on behalf of a future coalition government.
Well, that's very good. That's very good. You are the Shadow Attorney General. I'm not the Attorney General.
But you are a senior cabinet minister.
I am a senior.
Probably one of the most senior
Senator Cash, could you
in the government.
Senator Cash, please.
That's very kind of you to describe me that way.
You are.
Order. Senator Cash, could you please let the Minister answer the question? There's really no need to
complimenting the Minister.
I think I've answered the question. Thank you,
Thanks,
Chair.
Minister. Do you have any more questions relevant to this portfolio?
Yes, I do. I have one more series.
Why don't Senator Ghosh has some follow-up
that's fine.
questions from previous questioning. We'll come back to you.
Yep.
Thank you, Senator Ghosh.
Thank you, Chair. I'd like to pick up where sort of I left off, which is, and Senator Cash has helpfully also traversed a different aspect of this ground, but one of the things that's emerged from both is that we do have this underlying problem with anti-Semitism. It's both insidious and increasingly overt in different parts of our society. There's been reference to it occurring in a healthcare setting. There's also evidence that it occurs in education settings. From a cross-portfolio perspective, how do you see the role of the Attorney-General's anti-discrimination function or the Department's anti-discrimination function as being able to be applied into these different settings or setting up frameworks that will allow us to combat this issue as and when it arises?
Thank you, Senator. I will ask my colleague, Mr Newnham, to provide some additional detail, but I would note that the department, because of its responsibilities, has been working. I'll give the example of the issue of anti-Semitism in universities and the work that we've done with the Department of Education to support the work there, as well as supporting the Australian Human Rights Commission. So I might hand over to Mr Newnham, who can expand on that.
Thanks very much. Simon Newnham, Deputy Secretary, Integrity and International Group. Thanks, Senator. You heard earlier about the sort of multifaceted approach to countering racism, including anti-Semitism, across multiple portfolios that exist in government, and Ms Chidgey ran through a number within the portfolio, federal police, doxing, etc. So that sits at sort of at the headline level overarching points. Underneath that, though, your question goes to education, and particularly I could reference here some of the initiatives that are relevant to university campuses. So here you've seen, for example, the Senate Legal and Constitutional Affairs inquiry into the Commission of Inquiry Bill, which then led to the Parliamentary Joint Committee on Human Rights inquiry into and report on a range of anti-Semitism issues faced at university campuses. They actually came in with their report on the 12th of February, well ahead of the reporting date, and they were asked to cover a wide range of issues. And I'm happy to run through that, Senator. You'd also possibly be aware of the funding to the Australian Human Rights Commission to conduct the Respect at University study, which will be reporting later this year. Senator, you might also be aware of the National Student Ombudsman, which commenced in February of this year, which provides an independent, impartial and trauma-informed complaints mechanism for higher education students. Senator, a sort of fourth area is the ongoing human rights funding for the National Anti-Racism Strategy and the framework that sits underneath that. And finally, whilst not specifically targeted at university campuses, I think it'd be fair to say there's a considerable role played by the special envoys for both anti-racism and Islamophobia, again, highly relevant to some of the developments on university campuses.
Thank you. May I delve a little into the education sector and ask, are there aspects of the strategy that are being rolled out in that space, or some of the findings and recommendations that have emerged from those inquiries in the education space that you think have broader application, or can be, in effect, also provided in other spaces where there's a rise in anti-Semitism?
Senator, I would certainly acknowledge here the leadership of the Department of Education, and so I want to just couch my answer in those terms, in that context, that we are very much supporting their leadership on a range of initiatives, and perhaps that question would be best put to them. What I can say is that, just as I mentioned on the 12th of February, the report from the Parliamentary Joint Committee on Human Rights, 23 recommendations, but I'd draw your attention to the 10 majority recommendations, which very much go to the roles of Vice-Chancellors. For example, meeting with student bodies, making public statements, universities reviewing their complaints procedures, that there be greater transparency about the reports on complaint outcomes, possibly changes to the Fair Work Act, publishing de-identified reports on complaints, increased investment in research and collaboration, ongoing training, and possibly an upgrade in student wellbeing and safety standards. Now, obviously the government response is outstanding to that. It's only landed recently, but we are pushing as hard as we can with to assist Department of Education. I mention those because, and it's for others to judge, there may well be other sectors that draw from those types of recommendations and see value in them, but I probably couldn't speak further to that.
For reasons that surpass my understanding, the Coalition opposed the doxing legislation, but if I can delve a little bit deeper into what sits beneath that legislation and how that's being applied or rolled out across government.
Senator, if it's all right, we might... right, well, I'll let Ms Chidgey answer that as well. Thank you.
Thanks.
Senator, there obviously had been instances of personal information being shared maliciously to target particular groups, Jewish individuals, and the introduction of the doxing offences supplements existing offences for menacing, harassing and offensive conduct online, and particularly applies higher penalties where that conduct involves the misuse of personal information, particularly where that misuse of personal information is targeted at particular groups. members of the Jewish community would be one example, but sort of based on race, ethnicity, gender, etc.
Thank you. Thank you, Chair. Those are my questions.
Thanks.
I just had some quick follow-up questions in relation to the doxing issues Senator Gosh referred to. Secretary, who makes the decision, or who made the decision with respect to the amendments to the Privacy Act, that the doxing provisions, anti-doxing provisions, should be included in the same act that introduced a statutory tort of breach of privacy and also introduced substantive changes to the privacy law regime such that the Coalition was put in a position which I believe was entirely inappropriate, whereby it had to choose whether or not to support the whole package or to vote against the whole package. It was denied the opportunity to vote particularly on the, which we strongly agreed with, the anti-doxing provisions. Who made that decision?
Senator, I think you know, in terms of the development of a legislative package, although the department does a lot of the work in terms of the underlying policy and providing advice and drafting, ultimately what is included in a piece of legislation is a matter for government.
So, Minister, turning to you, why did the government choose, and I understand it's not your portfolio, but why did the government choose to include in the one piece of legislation substantive changes to the privacy regime, which will impose substantial costs, including on small business, introducing a statutory tort of privacy, which has been kicking around for about a dozen years, and then the highly sensitive and bipartisan supported anti-doxing provisions in the one bill? Why didn't the government do the decent thing and put the anti-doxing provisions in a standalone bill, which I presume the entire Parliament would have supported? Why seek to divide the Parliament on this issue?
Thank you, Senator, for your question. I don't see it as seeking to divide the Parliament. The government has been very cognizant of the fact that there have been, terrible events occurred in terms of the Jewish community in this country, very sadly. We have tried to address those. I mean, I suppose the starting point is it would be much better if we had never had to do any of that legislation and that Jewish Australians could feel safe in this country and could be treated with respect. And it's a great disappointment to people who've watched the development of anti-Semitism to see what's going on. But we have tried to address the issues as they arise. As I've said before, Minister Dreyfus has tried to address all of these issues in a comprehensive way, so that the government can make a full response to all of these issues and give confidence to the Jewish community that this government is concerned about what's going on in the community. We do not support the activities of the anti-Semites, and that we will do everything that we can, both in a practical sense but in a legislative sense, to protect the Jewish community, and this is just one part of that.
So, Minister, I deeply respect you and your empathy for the Jewish people. I do, but the particular question I have when dealing with such a sensitive issue, and we are repeatedly hearing this rhetoric that the Coalition voted against the doxing provisions without recognising the fact that the doxing provisions were included in one schedule of a bill, which also included very controversial provisions relating to substantial amendments to the Privacy Act, including imposing obligations upon small businesses, and also introduced a statutory tort of invasion of privacy. In the committee report, in my dissenting report, I pleaded for the government to separate out the anti-doxing provisions, because I'm sure they would have received unanimous support. Why did the minister choose not to do that? Why did the minister choose to avoid a moment of unity where we could have been unified in supporting the anti-doxing provisions?
No, look, I respect your position, Senator Carr. I'm not sure that I would necessarily agree with your assessment that there are opportunities for unity on this issue. I think, regretfully, people have taken the opportunity of these terrible events in the Jewish community to make political points and take political advantage of the situation, and that's a matter of great regret to me and to the government. Look, I can only say what I do in my portfolio areas, Senator Carr, and that is reach out as best as I can to the rest of the Parliament to try and get as much support for pieces of legislation that I bring forward to the Parliament.
And I appreciate that, Minister.
Well,
I do.
But I would say, given Minister Dreyfus's history, I'd have no doubt that he would adopt exactly the same approach as me. But sometimes you find that that isn't possible. Now, as you said, this is not my portfolio area. I'm not in charge of the legislative agenda. Minister Dreyfus is. But I would have thought that, and what I know is that he bends over backwards to try and reach compromise positions, and that he would have done his level best with his responsibilities to try and get to that position. Sometimes that just isn't possible, and the government then has to proceed with legislation if it's got majority support in the Parliament, and that's what's happened on this occasion.
Secretary, can I ask you, when was Schedule 3, the anti-doxing provisions, when was that added to that privacy bill?
I'd have to take that on notice, Senator.
Well, it was added subsequent to Schedules 1 and 2. Can I get some sort of general time frame as to when it was added?
I personally don't know that.
Does anyone at the table aware?
No, we'll take it on notice.
Okay, all right, thanks.
Minister, are you also aware that the Senate specifically agreed to a second reading motion that both the government and the coalition supported doxing reforms, and that this is recorded in the journals of the Senate?
I am now, as a result
Excellent.
of your contribution, Senator Cash.
Thank you. Secretary, just take us through the Attorney-General and the Attorney-General's Department, but more specifically the Attorney-General, is responsible for ASIO, is that correct?
It is a portfolio agency, yes.
Yes, portfolio agency. And the AFP, what is the role there?
The AFP is a portfolio agency.
Again, of this specific department?
Yes.
Yes, okay. Could I now go to documents that I tabled at the very beginning, documents 1 to 4. The first is the letter from Senator Paul Scar and myself to you, and specifically at points 5 and 6. Point 5, information that we are requesting, departmental responses to the Adass synagogue attack. We requested a timeline setting out the department's response to the incident in which the Adass synagogue was firebombed, including the dates of any briefings from the AFP or the Attorney-General, and dates of any meetings of the National Security Committee or Secretary's Committee on National Security at which the incident was discussed. And secondly, point 6, departmental responses to the Dural caravan incident, a timeline setting out the department's responses to the incident in which a caravan containing explosives was discovered in Dural in January, including the date on which the department first became aware of the incident, dates of any briefings from the AFP or to the Attorney-General and other ministers about the incident, and dates of any meetings of the National Security Committee or Secretary's Committee on National Security at which the incident was discussed, please advise the date when you were first informed as Secretary about this incident and when the Attorney-General or his office was briefed. If we then go to page 13 of 17 in relation to the response that you provided to both Senator Scarr and myself, the answer doesn't actually address either of my questions. 5 and 6, they're addressed in the same departmental response to the Adass synagogue attack, and 6, departmental response to the Dural caravan incident. You take us through the fact that you've supported the government to take action to respond to the rise of anti-Semitism, etc. You then say the responses build on other measures. You then say operational responses are a matter for the AFP and ASIO. You then say the department continues to engage with the AFP, State and Territory Police and State and Territory Justice agencies, etc. I'm just not sure, how is that a response to what I asked for and what Senator Scarr asked for?
Thank you, Senator. I think that response outlines the particular responsibilities we have in the department that in the context of work across government responding to the Adass synagogue attack and also recognising that in relation to the Dural caravan incident, guidance that we have been provided by the AFP that as there is an active investigation, it would be inappropriate to disclose any information relating to that matter.
Okay, so let's go back then to the Adass Israel synagogue attack. So in the first instance, I'm sure you are aware that the Prime Minister on the 6th of December 2024 in relation to the Adass Israel synagogue attack said as follows: I have been briefed this morning by the AFP Commissioner Reece Kershaw. On the 11th of December 2024, the Prime Minister said of the Adass synagogue, on Friday morning very early I got a briefing from the AFP Commissioner. On Monday we had the National Security Committee to hear a briefing, and you know I know more about the events there. So if I could turn specifically to the information that Senator Scarr and I requested on the Adass synagogue attack. Let's work through that. A timeline setting out the department's responses to the incident. Is there a timeline? Did the department do anything?
So, Senator, consistently with what I said, as a policy agency with responsibility for legislation, we were involved in whole of government work, but in particular work around developing legislative responses. We are not an operational agency.
I understand that. However, this is the Attorney-General, and as you've said, these departments, and in particular the AFP, they are located in this portfolio. So let's take a step back even further then. When was the Attorney-General first briefed on the Adass synagogue attack?
Senator, I don't have that. That would have
Who
been,
in the room has that?
Well, that would be a matter that he, in terms of any briefing that occurred, it would be the AFP. That would be a matter for the AFP.
So you're saying that as the Secretary of the Department, in relation to the Adass synagogue attack, you have no knowledge of whether or not the Attorney-General A was even briefed, or B, if he was, when?
Well, a briefing on what was a law enforcement matter is a matter for the AFP.
And yes, and I'm talking about the Minister that you report to, the Attorney-General of Australia. Are you saying to the committee you don't know the answer to that question?
I'm saying it's a question to be put to the AFP.
I'm asking you about your knowledge as the Secretary of when the person you report to in this government, the Attorney-General, was briefed. Do you have any knowledge at all in relation to that?
It's
No,
a
you
matter,
don't. Okay, that's fine.
It's a matter for the AFP,
Right, that's
Senator.
fine. Okay. So in terms of the Prime Minister's statement, on the 11th of December 2024, he stated, on Friday morning very early, I got a briefing from the AFP Commissioner. On Monday, we had the National Security Committee to hear a briefing. Were you in attendance at the National Security Committee briefing?
I would need to check that, Senator. I'd need to check the date of that meeting. I know you've mentioned the day of the week. I just need to check the date of that.
Are you able to check that for me? I would have thought you'd remember being at a briefing in relation to the ADAS synagogue firebombing. Are you able to check that?
We can take it on notice. I mean, obviously, I acknowledge the public comments of the Prime Minister, but matters that are discussed at the National Security Cabinet are subject to Cabinet confidentiality.
I didn't ask about anything that was discussed there. The Prime Minister has made it public. He stood up and told the Australian people, and I quote, he was very happy to in this regard. On Friday morning very early, I got a briefing of the AFP Commissioner. On Monday, we had the National Security Committee to hear a briefing, and you know, I know more about the events there. I'm not asking what happened at the National Security Committee. What I'm asking is, were you in attendance?
I will seek to confirm that for you shortly.
Did the Attorney-General attend the NSC meeting on the 9th of December 2024, at which the ADAS synagogue firebombing was discussed, given that the Prime Minister has made that information public himself?
I need to take that on notice.
Okay, I'm going to take that one on notice. So, Secretary, the Attorney-General's website, is that published by your department?
We host the website.
Okay, so who publishes things onto it?
I will ask Cameron Gifford to come forward to explain the process.
Okay, well, let me finish off the question. It might actually not require an answer. The Attorney-General's website carries a transcript of the press conference at which the Attorney-General stood next to the Prime Minister on the 9th of December 2024, and the Prime Minister confirmed that the NSC had discussed the ADAS synagogue attack and that it would be investigated as a terrorist incident. Do you recall that?
I think I have a general recollection of it, yes, Senator.
Right. Does that press conference prejudice ongoing investigations into the ADAS synagogue firebombing?
I don't think that's a judgment I can make, Senator.
Well, have you been given advice, given that this is the Attorney-General's portfolio? He is the Chief Law Officer in Australia. Have you been given advice that the press conference conducted by the Prime Minister, with the Attorney-General standing next to him, prejudices what is being investigated as a terrorist incident, the ADAS synagogue firebombing?
I have not received any advice to that effect.
Did the Attorney-General attend the NSC meeting on the 16th of April 2024, at which the live-streamed stabbing of the bishop in the Christ the Good Shepherd Church in Waitley was discussed?
Senator, I'd need to take that on notice. I think matters going to the Attorney-General's participation in Cabinet meetings is a matter for the Attorney-General to answer.
Yes, and you are Secretary of the Department, and if I recall, you would be aware of when the Attorney-General attends either a National Security Committee meeting or a Cabinet meeting, and you would often be there with the Attorney-General.
That is often a common practice, yes.
Yes, it is. So let's go back to, did the Attorney-General attend the NSC meeting on the 16th of April 2024, at which the live-streamed stabbing of the bishop in the Christ the Good Shepherd Church in Waitley was discussed?
I'd have to take that on notice.
Okay. Do you recall if you attended the National Security Committee meeting on that date?
I will take that on notice.
Okay. Do you recall briefing the Attorney-General or his office prior to the NSC at which the Adas synagogue attack was discussed and then made public by both the Prime Minister and the Attorney-General?
I'd have to take that on notice.
You don't remember. This is your own recollection. Okay, we've got to take a step back here. This is being investigated as a terrorist incident. The Adas Israel synagogue was attacked. The Prime Minister and the Attorney-General both stood up following the NSC to make certain statements. Is it your evidence to the committee that in relation to such a significant event, you need to take on notice your own knowledge of whether or not you briefed the Attorney-General?
To be fair, Senator, I think it's important that I do that to make sure that it's that I was there.
Okay. Can I also just be clear that you're also taking on notice whether you remember going to the NSC meetings at which, in the first instance, the Adas Israel synagogue firebombing was discussed and the Wakely Church terrorist attacks were discussed?
I can take that on notice.
Okay. That is not within your knowledge sitting here at this point in time?
Not specifically, no.
When you say not specifically, what do you mean?
You're talking about meetings in April and December. I think I need to check.
I'm talking
to be
about
accurate.
National Security Committee meetings, which, as you know, do not occur every other day of the week. And normally when a national security meeting is held in relation to such significant events, I would put to you, recall attending them. Are you able to check your Outlook calendar for me?
I have taken on notice and I will check that for you.
So again, I just want to confirm you are taking on notice whether or not you recall attending 2 National Security Committee meetings in relation to 2 significant events, one of which is being treated as investigated as a terrorist incident. Can I just get you to confirm that for the Hansard record?
I confirm I am
yes, thank you
taking
very
that on
much.
notice.
So in relation to the NSC meeting on the 16th of April 2024, as I said, at which the live streamed stabbing of the Bishop in Christ the Good Shepherd in Wakely was discussed. Again, the Prime Minister's website carries a transcript of a press conference he held on the 16th of April 2024, at which he confirmed that the NSC had met that morning and discussed the Wakely church attack, and that 2 agencies that you would be aware of, the AFP and ASIO, were participating in a joint counter-terrorism task force in response. So we know the date of when these things occurred, and we also know what is being done. Can I ask you, do you have any advice that whether or not those public statements made by the Prime Minister compromise either the investigation of the Wakely terrorist attack or by the Prime Minister and the Attorney-General, the Adas synagogue terrorist investigation, when they publicly said that NSC had met to discuss these incidents?
I do not have any specific advice in relation to that event.
Okay.
If I can just, we're straying very much into further portfolio programs. I'm not seeking to close down your line of questioning, but there is a section in National Security and Criminal Justice Group, I think, that might be relevant to these questions. And also, just to remind you and witnesses, questions relating to the Prime Minister, obviously for PMNC, they had a lengthy discussion about this yesterday. There was plenty of opportunity to ask questions there. These questions need to be relevant to the Attorney-General's portfolio.
Well, they are, because the AFP and ASIO were participating in...
I think I've been quite generous on the cross-portfolio purpose of your questions.
This is actually a question in relation to the letter that the Secretary provided, I provided to Senator Scarr.
You can't just put it in a letter and then say it's cross-portfolio. You could put whatever
It's in relation to the responses that were given.
Yeah, that doesn't...
So I can better then
it doesn't change the content
interrogate
of the
them potentially in another
you
part.
You can't just write a letter and then say it's now cross-portfolio because I've written you a letter about all these things that are due to be asked later.
If you want to run a line of interference, that is fine.
You should consider
what we are clearly establishing is the Prime Minister, when it is politically convenient, is happy to provide information to the Australian people. But when he clearly hasn't been briefed on a particular incident,
you are continuing
to
speak over to me. I'm not sure why. You are obviously trying to make political points by speaking over me as chair. I am asking you to put your relevant questions for cross-portfolio to the Secretary, and if you have other relevant questions for other parts of the program, we will need to get there. We are running about an hour behind for your purposes, and questions relating to the Prime Minister are for PMNC.
Again, if I could go back to the response that was given to Senator Scarr and I, can I ask again why you are unable to provide dates of any briefings from the AFP to the Attorney-General, dates of any meetings of the National Security Committee or Secretary's Committee on National Security at which the incident discussed, given that we quite deliberately gave you notice so we could get that information today?
Senator, in terms of any information about briefings from the AFP, I think it's a matter for the AFP to answer. In relation to dates of any meetings of NSC and SCONS, that is not something normally that we have provided to committees.
All because you don't normally provide it does not mean that you just adopt that approach in relation to a request for information. I'm trying to ascertain why you were unable to provide this to us despite being given prior notice that we required this information to conduct a line of questioning.
Well, Senator, you know full well there's no standing orders that requires Secretary to respond to your letter. They do so out of courtesy to you and to the Senate, and she's entitled to take questions on notice.
So dates are not able to be provided, even though the Prime Minister was very happy to stand up and actually provide information in relation to these meetings.
Thank you. Is that the question you're putting to the Secretary?
Yes.
Senator, in terms of information about Cabinet and national security meetings, I would refer to Prime Minister and Cabinet.
That's fine. And just in relation to responses, we've been through this before, so I don't intend on going through it again, but I do recall when we were in opposition or we were in government, it was amazing what Senator Carr at that time could be provided with within 24 hours yesterday. Just in relation to also the response I got from Prime Minister and Cabinet yesterday in relation to the same questions, they actually said it was the responsibility of this portfolio. So I will now need to go back to them and ask why they would provide me with information like that when it's unable to be answered here. I just now have just a set of questions in relation to the Dural Caravan incident, Chair, and then I'm finished in cross-portfolio.
As long as they're relevant to cross-portfolio.
When was the Attorney-General first briefed about the Dural Caravan incident?
Senator, as I've already indicated, we have engaged with the AFP and received advice that in light of the active investigation, it'd be inappropriate to disclose any details. So I'm not in a position to provide that information now.
Just in relation to that response, when did you engage with the AFP?
So Ms Chidgey convened a meeting of the AFP with the AFP on Friday.
On Friday. And can I just ask, what was, can the advice be tabled, please? And when you say Friday...
Sorry.
Friday just been?
Yes, the 21st.
Yep. 21st. Of January. February.
Are you able to table the advice for the benefit of the committee? Because there seems to be some confusion about the fact that we've just gone through a series of questions in relation to the Adass Israel synagogue attack being treated as a terrorist incident, the live streaming of the stabbing of the bishop. And as I said, the Prime Minister was very happy to stand up in relation to those two incidents and make public dates upon which he was briefed, what was actually discussed, etc. So can I just go back and just correct, what Friday did you discuss it with the AFP?
The 21st of February, Friday just passed.
So 21st of February, Friday just passed. Are you able to table that advice?
The advice was provided verbally.
Oh, the advice was provided verbally. Okay, who provided you the advice?
It was Deputy Commissioner Barrett.
So say that again.
It was Deputy Commissioner Barrett.
And did you specifically ask whether or not, given that, I'm assuming you knew questions in relation to the Attorney-General's knowledge of this incident, given he is the Chief Lawmaker, would be asked. Did you specifically ask whether or not disclosing when the Attorney-General was first briefed would prejudice the ongoing investigation?
The AFP was aware of the questions that had been provided to us in the letter from you, Senator Cash and Senator Scarr, and we discussed the ongoing investigation, the sensitivities around that, and the issues of disclosing any briefings.
So when you met with the AFP, was there any discussion, like did you discuss with them, oh, look, we'll take the questions on notice, or would there be any attempt to answer the questions?
We didn't get into the sort of detail of exactly the wording that we would say in that meeting. The AFP's advice was that given it's an ongoing investigation, it's sensitive that disclosure of any details about it could create issues for the investigation.
Did you raise with them the fact that Premier Minns has disclosed publicly when he was first briefed on this issue?
The AFP are obviously aware of that.
Can I just ask, what question in terms of what Senator Scarr and I had sent to you had cause for concern that you met with the AMP, and what question did you ask them that led them to providing this oral advice?
So they were aware of the questions we'd been provided in advance, and the AFP provided advice about disclosing any detail about the operation, including any timing or details of operational briefings.
So sorry, can you just say that again?
So the AFP was aware of the questions we had already been provided in a letter, and they provided advice about the sensitivity of the operation, the fact that it was ongoing, and that disclosure of details could prejudice their ongoing investigation.
So when you say disclosure of details, what I just want to ascertain is we all accept that the disclosure of operational issues could prejudice an ongoing investigation. We all accept that. No one is questioning that. The heart of the issue comes down to nobody, and perhaps the AFP will be able to actually say this date when they meet later on today, and that'll then obviously mean a whole lot of other questions will need to be asked. Did you specifically ask the AFP if you could disclose the date upon which the Attorney-General was briefed or first found out?
We did discuss the issue of disclosing the timing of any briefings.
And what did they say specifically to that?
As I've indicated, they advised that the disclosure of any of those details could potentially be prejudicial, and that all of those things, as the Secretary has said, should be matters that are asked of the AFP so they can make that judgment.
Did they give a reason?
I think it really amounts to the fact that it is an ongoing investigation and that it is sensitive, so that any details about where that investigation is up to could create issues.
Did you raise with them the fact that when it comes to the Adass Israel synagogue and also the live stream stabbing of the bishop in the Christ the Good Church Shepherd in Wakeley, the fact that these are public events, the Prime Minister and the Attorney General in one case have been very open about what happened, that there seems to be a bit of confusion about what you can disclose and when?
I think that they're each separate incidents with their own considerations, Senator, so it's probably a question that will need to be put to the AFP, but we've got that advice from them in relation to the caravan incident.
The issue I have obviously is transparency and the fact that most Australians are now asking when obviously the Prime Minister was briefed and now in this case when the Attorney General was first briefed. Can I just go back to the Attorney General you said was in Israel from the 4th of February.
I think the dates I provided, Senator, were from the 13th of January to the 20th of January.
Sorry, the 13th of January to the 20th of January.
And Senator, you did ask also for me to confirm when he resumed responsibility. I can confirm that was the 21st of January.
So he resumed his responsibilities on the 21st of January. And the Premier of New South Wales disclosed that he was briefed by the New South Wales Police on the caravan incident on the 20th of January. Is there a possibility, and I put this to you as potentially a way of solving this, something just slipped through the cracks? You've got an acting minister, you've got the Premier of New South Wales standing up on the 20th and saying that he's been briefed, and then the Attorney General doesn't resume his duties until the 21st of January, which you've just confirmed. Was there a miscommunication by someone?
I'm not sure I'm not sure I understand the question, Senator. Miscommunication regarding what?
So the Attorney General was overseas when this was discovered by the AFP, is that correct?
Senator, I can't answer that consistently with what we've said. I think I am guided by the advice from the AFP that it would be
how does that affect the investigation? We know Chris Minns stood up and said that he was briefed by the New South Wales Police on the caravan incident on the 20th of January. The AFP clearly knew then. The Attorney General didn't get back until the 20th. So again, I ask, I'm just trying to work through dates here. The Attorney General was overseas on the 20th of January when Mr Minns stood up.
Senator, I would need to check. I think may have been in transit at that.
So still overseas. If he's in transit, technically he's still overseas. So the New South Wales Police have been clear that the caravan was discovered on the 19th of January, that the New South Wales Premier was briefed on the 20th of January, and that the AFP were involved from the beginning. That is all on the public record. The New South Wales Police are very, very open about this. What with these dates we've now just worked out is during this period when all of this was happening, the Attorney General was actually overseas. If he's not resuming his duties until the 21st of January, is that correct?
Well, it's correct in terms of the dates that the Attorney was travelling.
Was Minister Gallagher then briefed as the Acting Attorney General?
Senator, again, consistently with what I've said, we've been advised that it wouldn't be appropriate to disclose any information, so I can't add to that.
Chair, I'll wrap up here for cross-portfolio, but I may have to revisit this in another part of the program, but that way we can move on for you.
Okay, thanks very much. That is all the questions we have for cross-portfolio, corporate and general matters. Thank you very much to all of those officials. We might just suspend the broadcast briefly while we have a changeover of officials in the room. There won't Thank you to broadcasting. And thank you. I now call officers from the Justice and Communities Group of Attorney Generals. I've got that right, I think. 4 questions. Senator Cash, I can come to you. Senator Scarr, we'll start with you with this group, and then Senator Polly has questions.
Thanks very much. Secretary, I want to take you back to some discussions we had last night in relation to the review of the Federal Circuit and Family Court, the statutory review, which is being undertaken now. And I'm aware, Minister, that you weren't here last night, but there was some very serious issues arose as to whether or not and I understand that a submission was made by the Chief Justice of the Federal Court of Australia to the independent review of another court, namely the Federal Circuit and Family Court, that concerns were raised by the Chief Justice of the Federal Circuit and Family Court with respect to that submission that was made by the Chief Justice of another court, the Federal Court, and that submission was actually withdrawn following interaction between the 2 Chief Justices and perhaps others. And I'd like to explore that further. So, Secretary, when I first asked you as to whether or not you were aware that a submission had been made by a judge of the Federal Court of Australia, in the first instance, you didn't have any information to provide me, but then, to your credit, you corrected the record and said that you had in fact become aware that a submission had been made. You've now had an opportunity overnight to reflect on the matter, and I think you could have reasonably suspected that further questions would be asked in relation to this serious matter. Could you now please provide a description of your involvement in relation to this making of a submission by the Chief Justice of the Federal Court in relation to this statutory review of another court?
Thank you, Senator. Yes, I did need to correct my original response, which at the time I thought was accurate, but I did recall that I had a phone conversation, and I checked yesterday or last night. It was on the 19th of December with David Pringle, the Registrar of the FCFCOA. It was a call to discuss, it was basically an end-of-year catch-up call to discuss a range of issues, and in the context of that call, he indicated that there'd been an issue around a submission having been made to the independent review of the FCFCOA, and that had been the subject of discussion between, and then the submission had been made by the Federal Court, and that had been the subject of discussion, but that had the issue about the submission being provided to the reviewers had been resolved.
Okay. So you referred to an issue had been raised in relation to the making of that submission, and we're talking here about a submission that was made by the Chief Justice of the Federal Court, Chief Justice Mortimer?
That's correct.
Right. What was the issue? Was and let me be more blunt,
yeah.
was because there could be a number of issues. There could be an issue with respect to the Chief Justice of a Chapter 3 court making a submission in relation to an independent review of another court, just as a matter of principle, whether or not that's an appropriate cause of action for a Chief Justice to embark upon. I'll pursue that shortly. And secondly, the content of that submission, whatever it said. What was the issue?
I think, to me, it was described as a process issue.
Okay, well, process can encapsulate whether or not it was appropriate in that process for the Chief Justice of a Chapter 3 court to make a submission at all, and I would have thought that would need very careful consideration, and it causes me great concern. Or it could be that it wasn't copied to the Chief Justice of the other court, there wasn't some introductory discussion, or it could be with respect to the content. So what was, you're speaking in generalities at the moment, Secretary. I'm trying to get to some specifics. What was the issue? And I don't think process is a sufficient answer for my purposes at least. Could someone else assist?
Senator, I just want to make sure I'm accurate here. My understanding is it went to the issue of whether or not the reviewers were broadly accepting submissions into the review, but I think I'll need to check that because this was advice from Mr Pringle to me. It was in a phone conversation. It was a brief mention, and he said, "But it's all been resolved." So I didn't get a lot of detail about it because I was told that essentially the issue had been resolved.
Okay. Well, just before, if someone else can provide further information, I would have thought the fact that the Chief Justice of a Chapter 3 court making a submission in relation to an independent review of another court is somewhat different from a question as to whether or not the independent review was accepting submissions from the broader range of stakeholders. It's one thing to receive a submission from the Law Council of Australia. It's another thing to receive a submission from the Chief Justice of another Chapter 3 court. So I suspect there might have been more to it than that. So can someone assist further?
I'll check. I know Ms Harvey can't because she was on leave at the time. So I'll just check if Ms Lineker has anything to add, but our understanding of this came from Mr Pringle, I think, unless there was any other information provided to the department.
Alice Lineker, First Assistant Secretary. No, I've just been reminded by one of my colleagues that I think Mr Pringle also raised it with the Acting Deputy Secretary at the time, and he mentioned it to me, but it was very much similarly a passing comment, as I recall that...
Sorry to interrupt. Who was the Acting Deputy Secretary at the time? Are they here?
Chris Collette, yes.
Is he here?
Yes, he is.
And I have no precise
we'll ask...
I've got my name next to it.
Oh, we know who you are, sir. We've been waiting for you all day.
It's not really for us, it's for our Hansard colleagues, and they do a very good job, so we don't want to make it harder for them.
Thank you, Senator.
Mr Collett, can you please explain to us the content of your discussion with Mr Pringle?
Thank you, Senator. Chris Collett, First Assistant Secretary, Children and Families. At the time of the conversation with Mr Pringle, I was acting for Ms Harvey as Acting Deputy Secretary, Justice and Communities. It was in a broader conversation with Mr Pringle. I recall, I think it was the 13th of December, but I'm happy to confirm that. In a discussion that covered a wide range of issues between the Department and the Court, Mr Pringle raised it at the end. He was very clear that he simply wanted me to be aware of it. He was conscious that the review was independent of the Department. And then, as he advised the Secretary shortly afterwards, we understand the submission was withdrawn.
Okay, you used the phrase aware of it. What was it?
That the Federal Court had made a submission.
That the Chief Justice had made a submission?
I recall him using the phrase the Federal Court.
Did he provide any more colour with respect to the submission, or was it?
As per Ms Lineker's comments, the comment was around whether or not the independent review was seeking submissions.
Secretary, do you consider it appropriate for the Chief Justice of a Chapter 3 court under the Constitution to make a submission to an independent review initiated by the Executive into the operation of the functioning of another court in the context where the establishment of that court was a highly politically charged matter subject to great debate? The existing attorney was a critic in relation to that merger. Do you think it's appropriate that the Chief Justice of a Chapter 3 court should make a submission in relation to the independent review of another court in those circumstances?
Senator, I obviously highly respect the Chief Justice of all the Chief Justices of all the federal courts and their knowledge and understanding of federal jurisdiction, obviously there are multiple touch points between the FCOA and the federal court, including the fact that there's shared administrative arrangements. So I think generally there would be an interest of either Chief Justice in terms of issues relevant to the court. So I would personally, as Secretary of the Department, not have a view that a Chief Justice shouldn't provide input into discussions. I think it's a matter for the Chief Justice, and I respect that.
Okay, well, I respect deeply all of our Chief Justices as well, as we all do here, and this is a question about process and sensitivity around that process. This is not simply a case of a discussion between Chief Justices with respect to administrative engagement between courts. This is with respect to an independent review going to the very essence of another court and whether or not it should continue to exist in the form in which it exists. It is of a level of magnitude, of seriousness, of gravity that I would have thought the question as to whether or not a submission should be made by the Chief Justice of another court in those circumstances should be the subject of great and deep reflection and consideration, and should involve, at the very least, raising whether or not it was appropriate for such a submission to be made with respect to, at least as a matter of courtesy, with the Chief Justice of the other court. Would you agree with that?
Sorry, Senator Sky, I think the issue is that you're asking the Secretary for an opinion, not a process question about when and how and all the things that happen. I understand the line of questioning, I do, but I think that's why we're going to maybe have a bit of a back and forth about the appropriateness or otherwise. Understand your views, I'm sure people share them, but it's maybe not a question the Secretary can answer.
No, fair enough.
Yeah.
I'll put it to the Minister. Minister, your deeply aware of issues in relation to separation of the executive from the judiciary, separation of the legislature from judiciary.
I wouldn't say I'm deeply aware.
Well, I'm trying to give you some credit, Minister.
1972 was the last time I did constitutional law,
right.
Senator Scarr, and
right.
It hasn't changed much.
Well,
nor have I, Senator Shoebridge.
Can I say this to you, Minister? Clearly, based on all of your experience, you would recognise, wouldn't you, that it would be highly controversial for a Chief Justice of one court to make a submission to an independent review with respect to whether or not another Chapter 3 court should continue in existence in its current form, that would be a matter which could well be thought to lead to some controversy and would require deep reflection and consideration with respect to both process and whether or not it should be made.
Well, Senator Scarr, the first time I've heard about this controversy is, you raising it here this morning, so I can't say it has been that controversial in the wider community.
Well, we only became aware of it yesterday afternoon.
There you go. Look, to be honest with you, don't know enough about the issues at hand. I will try and apprise myself of those issues and come back to you either in a formal response or in a private response. But I would need to know more about the circumstances to know for sure.
Well, if you can take that on notice, yeah. I'm not, to be fair, I'm not looking for a private response. It should be a public response.
Then I shall come back publicly and respond to the issues.
Okay. Secretary, we've spoken about the deep respect we have for our Chief Justices. In that context, last night we heard from the Registrar, Registrar Pringle, that the Chief Justice of the Federal Circuit and Family Court was concerned and dissatisfied with the process of the independent review, in particular around the lack of transparency and visibility with respect to the independent review. What action are you going to take as Secretary of the Department, given that concern has been raised by the Chief Justice with respect to lack of visibility around the independent review?
Senator, obviously I heard Mr Pringle's evidence last night. I would say that my understanding is through the course of the last several months there has been significant engagement with the FCFCOA by the independent reviewers, and that is appropriate. I would have to take on notice what that was like, because the review is independent from the department, and I don't think I can add anything further than that. But I do understand there has been engagement.
Well, Secretary, you said my understanding is, that was the phrase you used, is that there'd been a process with engagement. We've now heard evidence last night from the Registrar of the court that is the subject to the independent review, saying that the Chief Justice of that court is concerned that there's been a lack of visibility. Hence, that would indicate that your understanding, albeit no doubt held in good faith, is incorrect insofar as the Chief Justice is concerned about lack of visibility and is concerned about the process. So again, I ask, what steps are you going to initiate in order to address that lack of visibility, using the words of the Chief Justice of the Federal Circuit and Family Court?
I just have to clarify, because it wasn't the words of the Chief Justice, it was Mr Pringle. I spoke as recently as last week or the week before with the Chief Justice, and he didn't raise any concerns directly with me in regard to the review. The conversation that we had wasn't regarding the review, it was a different matter. But in that conversation, he didn't raise anything directly with me that would require me to take action.
Well, the registrar was conveying to us last night the concerns that had been raised with the registrar by the Chief Justice, that it's appropriate that you should consider those substantial concerns. Do you agree with that?
Well, I note those concerns, but as I said, my direct engagement with the Chief Justice, he didn't raise anything with me.
But you sorry, Secretary, you said your direct engagement with the Chief Justice last week or whenever it wasn't to discuss the independent review. Is that correct?
No, that's absolutely correct.
So to me, it doesn't really engage with the question. The question I have of you now is, having heard the evidence last night from the registrar about the concerns raised by the Chief Justice of the court that is the subject of this independent review, what are you going to do?
Senator, obviously I can engage further with both Mr Pringle and the Chief Justice to hear, but I would want to hear directly from the Chief Justice, so I can follow up directly with the Chief Justice.
So are you saying you are going to follow up directly with the Chief Justice of the Federal Circuit and Family Court to obtain a better understanding of any concerns he has with respect to the independent review as conveyed to us by the registrar?
I would be happy to do that, yes.
Well,
I agree it's appropriate to do that.
And you will do that?
I will do that.
Okay. Minister, we heard evidence last night that the registrar of the Federal Court had been informed by the Chief Justice of the Federal Circuit and Family Court that Chief Justice was concerned. The Chief Justice is concerned with the lack of visibility around the independent review into the merger of the courts that resulted in the Federal Circuit and Family Court. Is that a cause of concern to you?
Senator Carr, look,
Sorry, Senator Carr was a good friend of mine, but his spirit lingers, but he's no longer in this room.
We were talking about this because you raised the letter.
I know, and I just kept saying him.
Sorry, you're right. Go on.
We need to get you a vest.
Senator Scarr, look, I think in my earlier answer I indicated to you I would want to know a lot more about the circumstances here before I started giving advice to registrars or the Chief Justice on decisions that they may or may not have made. I'm happy to do what I said I would do before, which is apprise myself as best I can of the circumstances of the situation that you are questioning me about, and I will come back to you with a formal response.
Okay. What's the...
Scott, I will have to share the call. I'm just trying to get you,
one last question. Yeah. Just one last question. Where is the independent review up to in terms of timeline, and when? What's the process from here?
Deputy Secretary, Justice and Communities Group. So the statutory deadline for the independent review is for it to be finalised by the 1st of March, which is Saturday. So.
Goodness. And that's the sorry, just a supplementary. So that's the statutory deadline. What happens then? So the process from there on?
So it will be provided to the Attorney General and then considered by government.
Okay. There's no tabling date to go before Parliament?
Is 15 sitting days, Senator?
15 sitting days. Okay. All right. Thank you, Chair.
Thanks, Senator Scarr. Senator Ghosh, we're coming back to you, and then Senator Shoebridge will hand you a call after that.
Thank you, Chair. My questions relate to the Legal Assistance Branch and the National Access to Justice Partnership. We've got everyone.
The
National Access to Justice Partnership.
Yep, we'll just get the relevant officers.
Yeah, thank you. The National Legal Assistance Partnership will end on the 30th of June 2025. Can I just confirm, have all Attorneys General signed the new National Access to Justice Partnership?
Yes, Senator.
And when was that signed in total, or when were all those signatures achieved?
I'm just trying to find the date, Senator. There was a meeting of the Standing Council of Attorneys General at the end of November last year, and then the agreement was signed, I think, over a period of about a week by all attorneys. So I can get the precise date. One of my colleagues might have it, but it was the end of November last year.
Thank you. What's the initial feedback been from the sector, particularly community legal centres?
Do you want to?
Certainly. Thank you, Senator. Esther Bogart, First Assistant Secretary of the First Nations and Justice Policy Division. Feedback from the sector has been, there's been a variety of feedback from the sector in different subsectors. So, of course, there are now 5 quarantined streams of funding under the new National Access to Justice Partnership, or there will be from the 1st of July. And there were various increases in funding across all of those subsectors, with more funding in some than others, but generally people are pleased to have funding certainty. The funding is ongoing, which it wasn't under the current national, the NLAP, National Legal Assistance Partnership, and people are generally pleased about that.
Now, I understand that this is the largest ever funding investment, that is $3.9 billion under the National Access to Justice Partnership. Will all parts of the sector gain additional funding under this agreement?
Yes, Senator, that's correct. So all parts of the sector will receive additional funding. For example, family violence prevention and legal services have an increase of 112%. In comparison to their ANLAP funding over the 5 previous years. Sorry, they didn't get ANLAP funding. They're funding under the Indigenous Advancement Strategy. Over the previous 5 years, community legal centres, including women's legal services, will have an increase of 74% compared to ANLAP funding, 64% for Aboriginal legal services and 24% for legal aid commissions.
It's perhaps an illuminating slip there. How is Indigenous legal funding going to be treated under this agreement as opposed to under the NLAP? Are there any changes?
The main change is that the family violence and prevention legal services will come into the National Partnership Agreement for the first time. So they were previously administered by the National Indigenous Australians Agency under the IAS, as I mentioned previously. So they will come under this agreement to be administered by states and territories, which brings the whole sector together. Aboriginal and Torres Strait Islander legal services were previously under the NLAP.
And will each provider within those streams that you referred to know how much funding they will be getting under the agreement?
So, Senator, the providers have the universal amount in each state and territory for each funding stream. The states and territories are working with providers at the moment to settle their final funding agreements for the next period of time under the new NAJP. Some have been provided certainty, some are still working with the state and territory government. States and territories have their own sort of procurement and grants rules that they have to comply with, but all providers have been given certainty for at least the first year that they will receive at least the minimum Commonwealth funding they're receiving now. But the states and territories have provided those assurances just so services know that they can retain existing staff and keep their leases and things like that.
Do you anticipate that certainty of funding and the ongoing funding will assist community legal centres and family violence prevention legal centres with staff retention?
Senator, I think that's sort of something that I can't necessarily answer whether staff will remain, but I think the certainty will certainly help with the ability for providers to give those staff certainty around the retention of their contracts. Yes.
So in March last year, there was a review of National Legal Assistance Partnership released by, or that was conducted by Dr. Mundy, and the report was released. One of the observations in that report was that there is no, or the reviewer was unaware of any current measure of unmet legal need against which funding levels can be benchmarked or tested. Is the department addressing this gap, or how is the department proposing, if it is, to measure unmet legal need on an ongoing basis?
Lee Swan, Senator, Assistant Secretary of Justice Agreement Task Force. We're aware of Dr. Mundy's review around measuring the unmet legal needs, and I would like to mention there is a long-term reforms and established under the National Access to Justice Partnership Agreement. One of them is in developing a data strategies within the first 12 months of the next agreement. After that, develop the outcome framework within the 2 years of the next agreement. The data strategy is aimed at to produce more evidence and quality data to make an evidence-based policy decisions, and part of that is to better measure the unmet demand as well as inform how the response should be.
You referred a couple of times to the next agreement. When will that commence?
It will commence the 1st of July 2025.
Okay. I think Dr. Mundy's report referred to a Productivity Commission report or analysis that had previously recommended that the ABS be tasked with undertaking a legal needs survey. Will that form part of the data collection or the new data steps that you've referred to?
Senator, I want to mention the ABS currently already undertaking collections for the legal assistance sectors, and that is established under the current National Legal Assistance Partnership and NAAC, and that arrangement and it will be strengthened and continued under the next agreement, and the government has appropriate fundings for that publication to continue. In relation to the survey you mentioned, as I referred to my previous answers, and I think that is the survey or the other ways to measure the unmet legal needs will be considered holistically in the data strategy.
Are you able to just clarify that for me? I'm not sure I quite followed. So it's under consideration, or there will be a legal needs survey requested from the ABS, or I didn't understand.
There will be a data strategy, developing a data strategy, and the government and the sector will develop that strategy together, and that strategy will inform the actions and could be taken or should be undertaken. And how to understand the data and unmet legal needs, and I expect there will be a core consideration in developing that strategy.
Senator, I'll just add to that. There is no additional funding for a legal needs survey. However, that will be considered as part of the data strategy what the best way to measure legal need is. It's not. There is debate amongst the sector, states and territories as to the best way to measure that. It's a tricky thing to measure.
And Senator, sorry to interrupt, I got the dates when all the AGs signed the agreement. Commonwealth, New South Wales, South Australia, ACT, Victoria and Western Australia signed on the 22nd of November. Northern Territories AG signed on the 25th of November. Queensland AG signed on the 27th of November, and the Tasmania's AG signed on the 28th of November.
In relation to the approach to indexation under the National Access to Justice Partnership, can I ask why the decision was made to index for unit cost growth only and not demand growth in the sector, as I understand or as I've read Dr. Mundy's review suggesting?
So the legal assistance program and this particular national agreement is indexed quite consistently with how the government index other national agreements for service provisions and the funding for service provisions. So I won't speak for finance, how they constructed those indexes. So we used one of the standard indexation developed by finance, which is called Wage and Cost Index number 1.
One of the other recommendations in that review was that when government institutes law reforms, particularly relevant to the sector, it should undertake a legal assistance impact assessment. Is this mechanism or some equivalent included in the processes of the National Access to Justice Partnership or the related reforms?
Senator, there isn't a specific just sort of assessment tool in the Access to Justice Partnership. I understand that many states and territories have their own tools to measure that, and we of course always consider implications, downstream effects of various government policy and legislation on the justice system more broadly. That's part of our role in the department.
One of the issues that's been raised, certainly with me from the sector, is that the funding under the NLAP agreement and relevant state policies meant that legal funding was not able to be spent on associated or wraparound services provided by the legal service. And given that many of the clients that use Commonwealth funded legal services face multiple barriers and vulnerabilities and have, I think it's fair to say, multifaceted needs and face a number of challenges. Does the National Access to Justice Partnership or the agreements reached with the states address that concern? That is to say that these funds can be used by legal services, community legal services among others, to provide associated or wraparound services in addition to legal services?
Thanks, Senator. I will just start by saying that the NLAP that's currently in place has a range of different wraparound services already specifically funded, so the family advocacy and support services, domestic violence units, health justice partnerships already bring together that wraparound service. Our expectation is that or our understanding is that obviously legal assistance clients do have multiple problems, not always specifically legal, and that's why those particular programs have been designed over the years. What we did under the NAJP was clarify that funding could be used for wraparound service as well as specifically legal services. Different states and territories had interpreted the current NLAP slightly differently. So the purpose of the new clause, which Ms Wong may have, 56 of the NAJP, just clarifies that funding can be used for both legal and wraparound services related to a person's legal problem.
And you've had discussions with the states indicating that that interpretation or the old interpretation is corrected or revised with this new provision?
Then it was subject to the negotiations with states and territories that we make it very clear in the next agreement.
Okay.
Yeah, I do have to share a call. Thanks, Senator Ghosh. Senator Shoebridge, you have the call.
Thanks, Chair. Thanks for your attendance. Just to go back quickly to the federal court submission, Secretary, the concern in the legal fraternity is about ensuring that our courts, particularly our Commonwealth courts in this case, remain above the political fray. And you agree that should be an overarching objective of your government and your department and this Parliament?
Senator, I can't speak for the government, but obviously strong regard for and respect for the independence of the judiciary and the federal courts.
Well, I mean, Minister, you would agree, wouldn't you? We want the courts to be above the political fray. You don't want them to engage in political argy-bargy, our federal courts?
Well, Senator Scarr pointed out the separation of powers.
But I'm asking you. It's a simple proposition, isn't it? We don't want our courts to be engaged in political frays.
Do you want your question answered, Senator Shoebridge, or do you want to just talk over me?
Keen for an answer.
I've given you the courtesy of answering your question, and you respond in that way. It's quite inappropriate, I think, Senator Shoebridge.
Well,
I don't talk over you. Please don't talk over me. Senator Scarr pointed out the separation of powers. I indicated that I learnt about that many years ago, and had I responded a bit more fulsomely, I would have said I support the separation of powers.
All right. And Secretary, when there's a statutory review about the structure of one court, and in this case it's a court within the federal court within the Commonwealth's judicial structure, it is surely inappropriate for another separate court, entirely separate court, to start making suggestions or submissions about how an independent court should be structured. Because if any of those submissions are taken on board, it will inevitably involve a pretty brutal political decision about how two independent courts should be structured. You've been asked about whether that was appropriate, but I might ask you whether or not it's consistent with any history. Is there any history that you're aware of one federal court making a submission about how another independent federal court should be structured?
Senator, perhaps I could say I have a history of over 25 years spanning with a few breaks in the Attorney-General's Department, and during that time there have been a range of reforms to the federal court responsibilities. What engagement the existing courts had over that time in the reform processes, I couldn't say. It may be possible that submissions were called upon in relation to the various other major reform processes that have happened.
Well, I mean, it's one thing for the federal court. If there's a review of the federal court, we'd like to hear from the federal court. If there's a review of the Federal Circuit and Family Court, we'd like to hear from those two courts that constitute the Federal Circuit and Family Court. But, you know, if there's a review of the High Court, for example, about statutory structures for the High Court, it would be deeply inappropriate for the federal court to be dipping its oar in, just like it's deeply inappropriate for the federal court to be dipping its oar in to a review of the independent Federal Circuit and Family Courts. That's a pretty simple proposition, isn't it?
You're going to opinions again, Senator Shoebridge, which is where
well, it's never happened before, to your knowledge. It's one thing for courts to make submissions about their own structure, but can you recall an instance in your 25 years of experience where one court has made a submission about how another court should be structured?
Off the top of my head, I cannot, but having been involved in a number of these processes over the years, they have involved engagement with the existing courts as they were structured at the time, but I couldn't definitively answer your question one way or the other.
I mean, amongst the many problems is if the review decides to restructure the Federal Circuit and Family Courts, that may consider the appellate jurisdiction of the federal court, expanding it or decreasing it. It may consider potentially moving the circuit court to be associated with the federal court rather than the family court, all of which involve resources, potential expansion of the jurisdiction of the federal court, which is incredibly political. Those are political questions, not legal questions, aren't they?
I think they go to issues around the jurisdiction of both courts and the operations of both courts. Ultimately, wherever the independent reviewers land in terms of recommendations, then it's a matter for government to consider whether or not they accept those recommendations. And I do note that following, well, my understanding is the submission was not ultimately retained by or considered by the independent reviewers.
All right. Well, how do you know that?
From Mr. Pringle.
But have you spoken to the independent reviewers?
I have not, no.
So we don't really know what the independent reviewers have done with the submission, do we?
No, I don't know specifically. I just am going from the advice of Mr. Pringle to me that the issue had been resolved. So I took that to mean that it had been resolved to their satisfaction.
But we won't know until you get the report on the 1st of March what, if anything, they've done with that submission, will we? Because they're independent.
Correct.
And that's a problem, isn't it?
I think that the independent review will operate consistent with its terms of reference, and then government will have an opportunity to consider the recommendations in due course.
All right. And will there be a commitment? Is there a commitment to make the independent review publicly available, including any submissions to the public review?
Now, I'll need to check. I think there is a statutory requirement.
Requirement to table it within 15 sitting days, Senator.
Within
15 sitting days.
Okay, but it's coming into an election period.
Those statutory requirements still hold.
True.
Just because we go through a caretaker period doesn't mean that the requirement to table.
But it means a lot less sitting days is the key point,
Correct.
Secretary. I understand
Correct.
that.
Yes.
And it could be tabled at any time up to 15 sitting days.
I don't have the provision in front of me, but I'm pretty sure it's not prescriptive about.
You don't have to wait
about that.
Yep. And Secretary, could you, if you know, could you answer? But otherwise, is there any commitment made to the publishing of the submissions?
I'd need to take that on notice as to whether the formal submissions were made. I'm not aware, but I'm happy to take that on notice.
All right. Could I go to the recommendation from the Parliamentary Joint Committee on Human Rights? On the 30th of May 2024, it made a 30th of May 2024, it made a recommendation for the next Parliament to legislate a Human Rights Act, and indeed...
Senator, that's in the next group.
Is it?
In the Integrity and International group.
All right. Well, I'm happy to move that to the next group.
Getting the schedule here.
I thought our advice was it was in this group.
Yeah, so that would be a matter for the Integrity and International group that are scheduled this afternoon.
All right. What about the legal costs in the McBride and Boyle matters?
That is a matter in the National Security Criminal Justice Group.
All righty. What about closing the gap targets?
That's this group.
Good. Is your department monitoring developments in justice outcomes for First Nations people in the Northern Territory and Queensland since the changing governments and the raft of aggressive changes that have been made, particularly to youth justice laws in both of those jurisdictions?
Senator, I'll give a bit of context, then I'll ask my colleagues to assist. Engagement with the states and the territories around justice issues happens on a range of levels. In the context of closing the gap, the Standing Committee of Attorneys General and the Police Ministers' Council both have closing the gap justice targets as a standing item for discussion, and it was discussed at the meeting on Friday the 21st in Sydney. We have engagement through the Justice Policy Partnership under the Closing the Gap framework. Ms Harvey is a co-chair of that Justice Policy Partnership. It involves a coalition of the peaks plus representatives from each state and territory. And we have bilateral engagement with relevant jurisdictions, and probably, I think it's fair to say, we have a significant level of bilateral engagement with the Northern Territory.
Yeah, so I've read the Justice Policy Partnership agreements, and I've seen the targets for closing the gap. They look nice on paper, but the reality is, far from closing the gap is widening. And I'll give you just one statistic from the Northern Territory that has come to me from NAAC. Their analysis says, and it comes from the NT government figures, that there are an average of 44.8 Aboriginal people being taken into custody every day in the Northern Territory since those changes. It's a record rate of incarceration. And within that, we could break it down to a record rate of incarceration of young people, Aboriginal young people in the Northern Territory. That is directly contrary to the closing the gap goals, isn't it, Secretary? Directly contrary.
It is certainly contributing to a deterioration in the justice targets, both for adult and youth in the Northern Territory.
And it's in breach of pretty much all the agreements that the NT government signed up to when they signed on to the Justice Policy Partnership too, isn't it?
So, Senator, the outcomes 10 and 11 are both to reduce the rate of over-incarceration of adults and youth.
So we have meetings that don't produce any outcomes. We have partnership documents that have been routinely and flagrantly breached. And we have, in the case of the Northern Territory, a government that is aggressively increasing the number of First Nations peoples in jail. And what is your department doing about it?
There are a range of matters that I can refer to in terms of working with NAAC, supporting NAAC to strengthen its capability. It's had a challenging period over the last couple of years, but encouragingly, it is now in a better place in terms of being able to meet service demands.
So just before we move off NAAC has been overwhelmed by the demand on its services. Have you met with and spoken with NAAC this year?
I haven't personally, but my colleagues have both on a regular basis, and Ms Bogart can talk to that. We certainly engage very closely with NAAC.
Well, I mean, just to give you some indication,
I have to share the call.
The notifications they were getting per month in January 2020 of Aboriginal people being taken into custody was around about 20, dropping down to 18 a day in January and March of 2020, and it's now 44 a day, a doubling of the pressure on their services, which were already stretched in 2020.
Senator, I can assure you that we meet with NAAC regularly and check in on all of this. So I meet with them monthly, along with the Northern Territory Government and the National Indigenous Australians Agency. So we have a regular meeting, and I know NIAA and NTG are meeting with them even more regularly because they have a physical presence there. It's being reported back to us how they're going. We are absolutely measuring the demand or monitoring the demand. NAAC has assured us that they are continuing to be able to meet the demand at this stage, but we know that there are significant pressures being put on the system, and that's why we're continuing to monitor and continuing to actively ensure that they have sufficient funding and resources to meet the demand that we know is being created by those changes in the system.
Okay. Thanks, Senator Shoebridge. I do need to share the call. We can come back to you after the break. Senator Cash.
I have no further questions in this outcome.
Senator Scarr.
Just one follow-up question.
We'll come back to you even sooner.
Secretary, do you know, or does anyone in your department know, whether or not the submission from Chief Justice Mortimer of the Federal Court advocated for the demerger of the Federal Circuit and Family Court?
No, I don't have that level of... in fact, I wasn't advised around the content of the draft submission. I think that's probably the most accurate way to describe it, but no, I'm not aware of that.
Can we just ask if anyone else is aware?
Senator, I have no awareness of what is in the submission at all. I will confirm with my colleagues, but certainly the conversation I've had with them, we weren't aware of this submission until after the fact through Mr Pringle, and I will confirm, and I will come back if it's any different, but I understand that they don't have any knowledge of what's in there.
Do you know why the submission was withdrawn?
I heard the evidence last night of Mr Pringle that there was some engagement between the courts about this, but Senator, I don't have any independent knowledge of this.
Right, because it's one thing to make a submission, then for that submission to actually be formally withdrawn is quite a step. So I'm just exploring whether or not there's any knowledge in the department amongst any of the officers here as to why the submission was withdrawn. I've got a view that it shouldn't have been made in the first place, but why was it withdrawn? Was there a recognition that it was inappropriate to make the submission?
I have no... I wasn't involved in those discussions, and neither the Chief Justice of the FCFCOA or the Chief Justice of the Federal Court have advised me about that.
We heard from Mr Pringle that that the Chief Justice had concerns around the lack of visibility around process. In terms of process, Secretary, do you know whether or not the Federal Circuit and Family Court, and in particular the Chief Justice and Register, have been provided with all the submissions or any submissions that have been made to the independent reviewers so that they have a reasonable opportunity to respond to those submissions, to clarify information in those submissions, to provide perhaps the other side of the argument, which is a typical process, at least in my experience, with respect to effective independent reviews?
I don't have any direct knowledge of that. I'll see if my colleagues can assist.
Senator, we don't have any knowledge of any submissions that have been provided or any process that was followed through there.
It's an independent statutory review.
Yes,
I acknowledge that, but at the same time, isn't it important for you as a department to be across the processes so that you know it's a fair review, so that there are appropriate processes, that there is a process by which the court that is the subject of the inquiry, there is a process for that court to respond to any submissions, to any information which is being considered by the independent reviewers, for the simple fact that unless they have an opportunity to consider the information upon which the independent reviewers are coming to a decision, it could well be that the independent reviewers come to a decision based on incorrect information or without all the information. Isn't it important for you to be across the process of the independent review?
So, Senator, the process of the review is in the terms of reference, and sorry, I've changed folders. It is an independent review, and those reviewers are operating that way. So
it's independent. It's independent with respect to process as well. Is that what you're saying? You've got no say with respect to the process.
Senator, the department has supported the review by providing a small secretariat, and that secretariat has access to all the standard procedures around publication of the surveys on our consultation website, all of those normal processes. The terms of reference specifically draw out the expectation that the review will consult as widely as reviewers consider necessary, including with the FCFCOA, Family Court of WA, government-funded legal assistance providers, the legal profession more broadly, including peak representative bodies, and the community. So in that regard, they have received instructions as to how to consult and conduct their review, and the department has provided them with secretariat support to ensure they have access to processes to do that.
Right, so I'm sure those are very professional, that support is being provided in the usual professional way.
Yes.
And as part of the provision of that support, because you're providing it, you should therefore be aware as to whether or not all of the submissions which are being received by the independent reviewers or the information upon which they're conducting their review is being provided to the Federal Circuit and Family Court so they have an opportunity to respond. Is that occurring?
That's a matter for the independent reviewers.
Sorry, it's information which is in the knowledge of the Secretariat providing support to the independent review. So are there officers here who are involved in the Secretariat providing support to the independent reviewers?
Senator, no, there are not. They're relatively junior officers that provide the Secretariat support. I'm happy to take that on notice in terms of what information we have around the independent reviewers' engagement with the court in relation to submissions. Obviously, Mr Pringle would have had knowledge of that as well.
Well, Mr Pringle told us last night that the Chief Justice is concerned about lack of visibility, which is why I'm asking these questions, because lack of visibility in the context of an independent review suggests to me that the Chief Justice of the court that is the subject of the review is concerned that he does not have visibility. The Chief Justice doesn't have visibility with respect to the process and or the submissions which are being made, and that causes me grave concern because I want to make sure that the independent review is conducted on the basis of all the available information and of the views of the court, which is the subject of the review. So if you could take that on notice. Yes. And last question, do you know whether or not the submissions made to the independent review are actually going to be made public?
I took that on notice. Senator Shoebridge asked that question. I will take that on notice.
Can I also ask you to take on notice whether or not you can provide or the independent reviewers can provide through your department a copy of the submission that was made by the Chief Justice? Mortimer.
I'll take that on notice.
Thanks.
Thanks, Senator Scott. Senator Waters, we have a few minutes before our break.
That's great. That's all I need. Thank you very much, Chair. Good morning. Good afternoon, everyone. Just a few quick questions about the ALRC Sexual Violence Review Report.
We'll just get some different officers to the table, Senator.
Thank you. Hi there. I understand the attorney received a copy of that report from the ALRC on the 22nd of January, and I think that it's required to be tabled within 14 sitting days. Can I just ask, is there an intended tabling date for that report?
Sorry, Senator. I didn't quite hear the question because my colleague was shuffling papers. Did you ask if there was a set?
Yeah, and is there an intended tabling date?
Settled. I know that there is that statutory tabling date, and beyond that, I don't know that one has been set.
No. So as you noted in your question, Senator, I think it's up to 15 days under the ALRC Act, and the precise tabling date's a matter for government.
I see. Is there? I'm not sure whether the minister would be across this, given these repping in this portfolio. Is there an intention to table the ALRC Sexual Violence Review Report prior to an election being called?
You're asking me, Senator?
I don't mind who answers. I'd just like to know.
I don't know the answer to that question, but if somebody else does, I'd be very happy if they answered the question.
Sorry, my colleague just noted that it's a matter for the Attorney-General in terms of that decision.
Okay.
Right.
Minister, do you...
I shall make an inquiry with the Attorney-General and come back to you, Senator Waters.
Thanks very much. Has the department considered the report yet? Are you doing any policy work on what it says? And
certainly, having received the report, my colleagues particularly have been working through it and considering it.
Okay. Can you just run me through what that entails? Will you work first on crafting the proposed government response to the report before you think about implementation? What's the normal course of action here?
I'm not sure I distinguish between the two. Obviously, it's a matter for government in finalising a response. The department is and will provide advice to government on that. The implementation of the response and the response I would see as obviously intertwined. It's also important in any of these sorts of inquiries, and particularly on this sort of subject matter, that there's appropriate consultation. And you'd recall, Senator, that there is an expert advisory group of people with experience that was established both to advise the Commission in their review and then to continue to advise government and the department in dealing with the response to the inquiry.
Have you begun those consultations with them yet?
Well, the consultations with the expert advisory group ran for last year. We're not in a position to continue them until the tabling of the report, of course.
Oh, so you won't engage with them in the course of formulating the government's response to the report, but you might engage with them thereafter?
I'm not sure I could speculate on the precise details until government
sorry,
tables.
You just mentioned them. So what is their role?
So their role will be to advise government going forward, but the precise nature of that depends on the timing of the government in tabling the report.
Okay, great. And is that at the top of your work priorities?
It's an incredibly important issue, Senator.
It is indeed, but in terms of whether you're working on it right now, are we to expect a response approximately?
I can only
or-
repeat my previous comment. The timing of the tabling is a matter for government, and of course a response is tied to the tabling of a report.
Okay.
Senator, I would say it's a wide-ranging and comprehensive report. I think I can say that. The Law Reform Commission has done an extraordinary job in a short period of time, relatively speaking. So there's a lot there in terms of ideas around strengthening existing responses and new responses, and we're working through that as a matter of priority.
Great. I really can't wait to see what it says.
Yeah.
Thanks very much. Thanks, Chair. That's all I've
Thank
got
you.
because that's all they can tell me for now.
Thanks, Senator Waters. That takes us to the break. So the committee will suspend until 1:15 and we'll return to the Justice and Communities group. Thanks, everyone.
No.
Just give the Secretary one moment. Thank you. Now, we are still in questions for Justice and Communities Group. I'm hopeful that we don't have too many more questions for this section, and then we can move on to National Security and Criminal Justice. But before we do, Senator Ghosh, you have the call.
Thank you. I've got questions again on legal assistance and then some on justice reinvestment, please. Ms Bogarts, can I ask you to... I'll go back to an answer you gave earlier, which was in relation to there being multiple different views on the appropriate ways to measure legal need emerging from the sector. Are you able to outline, just in a very brief sketch form, what those different measurements are, or what those views are, and then whether the department has a view or is doing work on which is preferable?
So I might answer your first question, your last question first, and then I'll hand over to my colleague, Ms Wong, on the different ways of measuring it.
Sure.
So what Ms Wong's evidence earlier was that we are not doing work on a legal needs survey. We are instead looking at developing a data strategy in consultation with the sector and the states and territories on how data can contribute to measuring various different things.
So I understood the answer about the legal needs survey, but what are the methods, or what are the data that are going to be plugged in or analysed in order to assess what legal need is and what unmet legal need is?
So, Senator, at this stage, we haven't started the work on the data strategy, so we've got multiple different long-term reform pieces of work that will start from the 1st of July in consultation with the states and the sector. So that work hasn't been done.
Okay, is there an existing view on that measurement exercise, or that's just not something the department is doing at all?
Senator, as Ms Bogart said, the data strategy work is still yet to commence to develop, so I can answer the questions probably in more general terms. There are a range of data existing, both administrative collections and, for example, the data collected under the NLAP and also the data collected by the providers. There are surveys not done at national level. For example, Victoria Law Foundations has conducted a Parole survey. Sorry, I can't remember the full name. I only remember the acronym of it. And look at the legal needs in Victoria. Also, I previously mentioned the ABS data collections. Through that, and the ABS also provide expertise around how to utilise the data as existing and how to continue to build upon from this evidence and better so the governments and the sectors can be better informed about the gaps and how to respond to those gaps. Sorry, I only can provide an answer in the general sense. So there are existing data evidence available, and certainly the data strategy is looking to strengthen them and extending or enhance the evidence. And then also after that is the how to better utilise the evidence we already know and to answer that questions you raised.
Thank you. Turning to justice reinvestment, the package that was announced, I think a couple of years ago, in relation to justice reinvestment involved a process by which people could apply or propose programs and then be funded federally. To date, as I understand, 27 organisations have been funded to deliver these initiatives. Is that still right?
That's correct, Senator.
Wonderful. And I understand in Western Australia there are 4 that have been funded. Is that's right?
In Western Australia, there are 6 initiatives. Yes.
Okay. Are you able to just briefly outline what those 6 initiatives are? And I do mean briefly, just in terms of timing.
Just who's receiving the funding?
Who's receiving it, and if it's possible to give a précis of what they're doing or what the program relates to, that would be fantastic.
Thank you, Senator. So there is the Imama Nuda Aboriginal Corporation is providing a youth-focused initiative in Derby in WA. Ebenezer Aboriginal Corporation in the area of Balga in Perth is also working with young people, particularly to maintain their school retention program, as well as supporting young people and adults exiting prison. There is Gascoyne Development Commission in Carnarvon in WA is developing a strategy. They will be specifically working on circuit breakers focused on youth. The Shire of Halls Creek is establishing community justice groups and also doing some work around youth and transition to employment programs. The Aboriginal Legal Service of Western Australia is running a program in a consortium of other Aboriginal community-controlled organisations, again focusing on at-risk youth, supporting young people with education on country healing and caring for country camps. And I think that's final one is the Aboriginal Male Healing Centre Strong Spirit, Strong Families, Strong Culture Incorporated in Newman, East Pilbara and Port Hedland is also doing an initiative again with a youth focus.
In terms of these grants, is there a standard duration of the funding is provided for, or is it based on the programs proposed?
There's been multiple different cycles, but the general time frame is 3-year grant agreements under the current grant opportunity guidelines. There are some for 2, but the funding is actually ongoing, so there will be an opportunity for all of the funded organisations to apply for additional funding under another grants program, which will open later this year.
Wonderful. I think that's all I've got. Thanks, Chair.
Yeah, thank you, Senator Ghosh. Senator Shoebridge, I'm going to hand the call to you, and Senator Cox is also on video conference, so we'll get to her after you've had a block of 1 or 2 questions, like 1 or 2 topics.
If Senator Cox is ready to go, I know she's...
Yes, Minister.
Senator Shoebridge and Senator Scarr asked some questions previously about the review of the Federal Court and Circuit Family Court of Australia. I'd like to put on the record a few comments in respect to that, out of courtesy to both of them. So the terms of reference for the review were published on the 21st of October 2024. As this committee has discussed previously, the terms of reference were provided to the Chief Justice of the Federal Circuit and the Family Court of Australia before they were published, and the final version includes input from the Chief Justice. The independent reviewers were asked to consult as widely as the reviewers considered necessary. And in quotes it says, including with the Federal Circuit and the Family Court of Australia, the Family Court of Western Australia, government-funded legal assistance providers, the legal profession more broadly, including peak representative bodies and the community. It would be unsurprising that the Federal Court of Australia would be interested in the review of the Federal Circuit and the Family Courts of Australia. The Federal Court and the Federal Circuit and the Family Court of Australia share a single administrative entity. The Commonwealth Courts Portal is a joint initiative of the Federal Court of Australia and the Federal Circuit and the Family Court of Australia, which provides web-based access to information about cases before each court. The appeals in matters of the Federal Circuit and the Family Court of Australia that do not involve family law are to the Federal Court of Australia.
Thank you, Minister. Senator Shoebridge, you have the call.
I think Senator Cox is ready to go.
Oh, okay.
And if we
I'm very happy to move you around. Senator Cox, are you there with you? Okay.
I've got some questions of the native title branch, if I can.
Yep. Right, they're just coming to the table, Senator.
Thank you. Thanks, Chair.
should be good to go.
Great, thank you. Several media outlets have reported that the WA government have written to Canberra regarding some changes to the National Native Title Act. Can you confirm whether either the Attorney-General or the Department has spoken to anyone from the West Australian Government?
Thank you, Senator. So the Commonwealth officials have been engaging with officials from the WA Department of Mines, Industry, Regulation and Safety on this issue for a number of years, as the reporting notes.
Sorry to interrupt you.
Yes.
It doesn't say there are a number of years. How long's the period been for?
Senator, I would suggest since the decision in Forest and Forest in 2017. I don't know the exact dates. I can take that on notice though.
Okay, great, thank you. Sorry to interrupt.
So there has been correspondence and discussions. The Commonwealth has always said that it's willing to work on a way forward with Western Australia. We are awaiting some further confirmation from Western Australia about the approach that it is wanting to take, and we will work with them at that time.
Is there any specifics within that correspondence that relate directly to native title and directly to the changes which are proposed by the WA State Government to the Mining Act?
So WA has shared the changes that they're proposing through their legislation and potential interactions of that with the Native Title Act, and we will continue to talk to Western Australia about how their legislation, which I understand has now lapsed with their caretaker period, how that might interact with the Native Title Act.
Okay, so 85% of Western Australia is covered by native title and nobody is talking to the traditional owner groups. Why is the Native Title branch in the Attorney General's Department and the WA Government not alerting traditional owners that these changes will remove their right to negotiate provisions within the Native Title Act? Why are you not doing that?
Senator, we're not at this time in a position where we're talking with the WA government about how their legislation might interact with the Native Title Act. We're not at a stage where we're making amendments to the Native Title Act, at which time, of course, we would speak with lots of relevant people in the context of changes to the Native Title Act, but it is a matter for the WA government to be speaking to their relevant stakeholders on their legislation.
So, Ms Bogart, is the government doing its due diligence in a signatory to the Closing the Gap agreement in good faith of the right to negotiate, the rights for First Nations people to continue to have those rights within the federal legislation for the right to negotiate the terms and conditions of Indigenous land use agreements in this country? The Commonwealth is sitting idle while they're letting a state be rogue after they've shared amendments with you which will have a direct impact on Pilbara communities and McKimberley, in Nyungar country. 85% of our state is covered by native title. And does the Commonwealth not think that we deserve to know as traditional owners any proposed changes that will impact on the national native title legislation? We deserve to know that. Why is the government not being transparent about this?
Senator, I think what I can say is that we work quite closely with the National Native Title Council as a peak body. We discuss a range of matters with them. We've had some very preliminary conversations with WA. We're not in any advanced stage in these discussions that it would warrant speaking to other stakeholders at this time, but we will when it comes to that time, we will consider which stakeholders need to be engaged on any proposed amendments, but we're not at that stage yet, Senator.
Okay, Ms Bogart, can you tell me how the recommendation from the Way Forward report in relation to native title and the Future Act regime is being taken forward by your department that does not and will not be impacted by these changes that the government in Western Australia will try and take forward post the election in a few weeks in Western Australia and before the election in the federal government? How are you considering that this government accepted those recommendations of the Duke and Gorge report to protect the cultural heritage being led by First Nations people, traditional owners in Western Australia? Is the government walking back that commitment?
Senator Bridie McCasey, Assistant Secretary for the Native Title and Priority Reforms Branch. To your question about the response to the Way Forward report, you may be aware that a referral has been made to the Australian Law Reform Commission for review into the future acts regime under the Native Title Act, and that is a direct response to, I believe it's recommendation 4 in the Way Forward report.
Okay, so I'm also aware that the West Australian Government have made a submission to the Australian Law Reform Commission, and I'll ask them the same question this afternoon. But what is the department doing to ensure that there is transparency for traditional owners across the country who are watching with great intent the Gumarch case of just terms compensation in the Northern Territory, the Yinjabandi case in the Federal Court of Western Australia? All of these have direct impact on our native title rights. What is the department doing to ensure that you are playing an independent role to ensure that there's consistency in this and that you learn from the past mistakes after you've accepted recommendations of the inquiry?
Just so, in terms of the Australian Law Reform Commission's inquiry, it would be normal practice for those submissions to be made public. So, in terms of transparency in relation to that inquiry, that will be an avenue for that. Ms Bogart has already talked about our work with the National Native Title Council. I would note also that we have an ongoing working relationship and partnership with them. But also, whenever we are contemplating changes to the Native Title Act, there's a group called the Expert Technical Advisory Group that we stand up when those changes or any changes are contemplated. And that group is actually chaired by the CEO of the National Native Title Council. So that's just one of the avenues that we have to work with First Nations people in relation to changes to the Native Title Act. So, yeah, hopefully that addresses your question.
Ms McCasey, were they advised around these proposed changes that the West Australian Government were trying to make?
I can't speak, Senator, to whether or not the Western Australian Government has engaged with the National Native Title Council. As Ms Bogart... I'm
asking with the department. They've shared them with you since, and you've been working with them since 2017. Have you alerted the Native Title Tribunal that these are afoot, or the Council, sorry, that these proposed changes are afoot, and actually given them an opportunity to go out to their stakeholders, all of the PPCs, all of the land councils in the country, to do their own consultation on whether this will have a direct impact? With what we know by removing the right to negotiate, it will, because this compels, as is written in one of the in the end of last year, one of the articles, this compels First Nations traditional owners to have to negotiate with a mining company for 6 months. Well, why would government return us to mission management and put this in legislation to stitch us to a mining company for 6 months to negotiate? This cannot happen, and the government are sitting idle waiting for that to happen without any consultation.
So, Senator, we can't speak for the WA government, obviously, in relation to legislative changes that they might be proposing, but in relation to any changes that may, in the future occur to the Native Title Act, I would just clarify that there are no proposed changes at this stage, as Ms Bogart has explained. There has been engagement between the WA government and the Commonwealth in relation to an issue that arises out of the High Court's decision in Forest and Forest, which was handed down in 2017, but there is not at this stage any proposed changes to the Native Title Act. That would be putting it too highly. Yeah. But I would also note that we have had a preliminary discussion with the National Native Title Council about this issue and what's happening around it. So there has been some engagement, yes.
Okay, thank you. I'll hand the call back. Thanks, Jeff.
Yeah, thanks, Chair. I was asking some questions earlier about closing the gap. And asking questions about what, if any, response your department was was crafting or considering in relation to what happened in the Northern Territory. But Secretary, it's not limited to the Northern Territory. We're seeing today yet more allegations of appalling abuse of children, almost all First Nations children in Queensland police watchhouses. The most recent utterly distressing details are of a 12-year-old boy being allegedly instructed to drink urine, physically assault himself, vomit, make sexually explicit remarks over the intercom and be abused for an hour, all on CCTV, including in the middle of it being visited by a Queensland police officer. What's your department doing about what's happening in Queensland?
In response to the specific example that you've referenced there, obviously that would be a matter for relevant Queensland oversight agencies to investigate any type of allegations like that. In terms of the work on First Nations justice and youth justice, I've already referenced the engagement with jurisdictions through SCAG and through the Justice Policy Partnership. We've referenced some of the work that we're doing in justice reinvestment and obviously wanting to continue to engage with our counterparts in the states and the territories around issues of First Nations incarceration and continue to raise concerns. Obviously, we also do provide increased funding to the ATSLs that will be flowing through the new National Access to Justice Partnership Agreement to play that critical role of providing support. But there's a lot more to do.
Well, despite the Justice Policy Partnership, despite the meeting last Friday and whatever other meetings have happened, Queensland is thumbing its nose at the national targets on closing the gap. In fact, last time I checked, there are as many children, almost all First Nations children, in jail in Queensland as there are in New South Wales and Victoria combined. And it's getting worse on a daily basis. Is there any actual concrete pressure, fiscal or otherwise, that the Commonwealth's applying to Queensland to get it to meet its commitments under the Justice Policy Partnership or even pretend to be closing the gap?
Senator, as you would be aware, the Closing the Gap architecture has the Joint Council as the key meeting between Coalition of PEGs and states and territories, and that was last November. The Joint Council, raised youth justice with all ministers at that meeting. They've subsequently written to all state and territory attorneys seeking information about how they're addressing Target 11. So certainly through the Joint Council, the work of the Justice Policy Partnership continues, and as you'll be aware, a large number of children and adults who are in incarceration are actually on remand, and so there's important work that we're doing collectively around bail and remand, and those recommendations will go to SCAG in the middle of the year. And we continue to very much work collectively, recognising that the justice systems across the country are the responsibility of the states and territories, but also that bringing together First Nations experts, First Nations people, government is a really important piece in actually finding ways forward. So minimum age of criminal responsibility report that was done through Standing Council of Attorneys General and Justice Policy Partnership sets out things that governments can do around service system responses to children who are perhaps having contact with the justice system. So that, there are a range of things that we are continuing to do. In the non-First Nations space, there are also grant programs that the Commonwealth is funding through, I think they're under 25 Go in the Youth Empowerment Program, additional funding, as Ms Jones pointed out, to ATSLs and also Family Violence Prevention Legal Services. So we absolutely continue to work closely and collectively to address the drivers of over-incarceration of adults and children.
You see, Secretary, a 12-year-old disabled boy was just tortured in a Queensland watch house while on CCTV. And the federal government says to him and his family that they're writing a letter. That is not a response. It does not meet the gravity of the situation, does it?
Senator, without knowing the specifics of the matter that you've raised, but I would note that is for relevant oversight mechanisms in Queensland to consider. That doesn't take away from our strong interest in broader issues around addressing First Nations incarceration rates.
Well, you see, the Commonwealth convenes these meetings, these SCAG meetings, these justice policy partnerships, and brings state and territory ministers to a table. And then, particularly in the case of the NT and Queensland, they laugh at you. They laugh at the targets, they dismiss the targets, and they go back into their jurisdictions, and instead of raising the age, they lower the age in NT. Instead of putting in place measures to protect First Nations children's rights, they reinstitute spithoods in breach of human rights. And in Queensland, they changed the bail laws expressly to make them harsher for kids than for adults. These jurisdictions are laughing at the inaction in the Commonwealth, and the federal government is letting them get away with it. It's not working what your department is doing, is it? It's just not working.
I don't agree with the characterisation, and there are a range of things that are working, and I hope will over time make a difference. But in terms of decision making around criminal justice legislation and policies that relate to bail and other issues, they are matters for the state and territory governments.
This is because the Commonwealth chooses not to act. It's not a lack of legislative remit or constitutional power. The external affairs power is well exercised by the Commonwealth entering into international agreements on the rights of children, civil and political rights, the UN Declaration on the Rights of Indigenous Peoples. This is a choice by the Commonwealth, isn't it? To leave it to states and territories, knowing full well that incidents like I described to you then of systemic abuse are happening in Queensland watch houses, in WA youth prisons and in the Northern Territory. It's a choice, isn't it?
Senator, I think we've obviously had this discussion over a number of estimates hearings, but a core responsibility of every state and territory is the criminal justice system and the justice system. The Commonwealth can't take over their systems.
No, but you can institute minimum standards, you can use fiscal power, and you can force better outcomes. But your department, perhaps at the direction of the attorney, is choosing not to. That's the sort of brutal, hard truth that 12-year-old boy is learning, isn't it?
I disagree with that characterisation, Senator.
Could I ask about the funding for the Community Legal Services Program?
Yes.
Is that you?
Yes, that's us.
Yep. So services funded under the CLSP have been told that they're only going to receive next financial year the same sum of money in nominal dollar terms that they received this financial year. So that assumes no adjustment for pay parity, indexation, or any funding uplift. They're also being told that they can compete in an application process for a tiny pot of additional funding, but the selection and eligibility criteria and the amount of funding haven't yet been formalised. Well, what's going on here?
Senator, it is the Community Legal Services Program, CLSP, is currently providers are funded for a 5-year term until the 30th of June, which aligns with the same funding for the National Legal Assistance Partnership. Providers were provided at the start of this year with advice that to give them funding certainty that for at least the next year they will get the same amount that they get from the Commonwealth plus indexation, so it will include indexation on top of that amount, and that there will be a grants program run this year before the end of the financial year to allow them to not only apply for a further 5 years funding but also for some additional funding. So there is some additional funding for those providers to seek, and that's a very standard process where a grant agreement ends at the end of a 5-year term to do another approach to markets, and it is actually a positive for these providers as they won't just get necessarily the minimum. We've given them certainty about the minimum, but they will have the opportunity to apply for additional funding for the next 5 years.
When you say the funds are being indexed, what's the indexation rate that's been applied to the funding for next year?
Senator, it will be similar to the NAJP, so it's an annual indexation rate, so I don't have that answer right now. I can take it on notice, but I'm not sure we know it until closer to the financial year.
So you don't know? They haven't been told what the indexation rate is?
Indexation is managed by the Department of Finance, and we are provided with the indexation rate.
But you're saying that next year's funding will be indexed. Is that a clear commitment? Because it's not what the sector's saying that they've heard from you.
Senator, the letter that was sent to, or email that was sent to each of the providers on the 22nd of January advised that they would have at least the minimum funding they get from the Commonwealth this financial year plus indexation. It was very clear.
Why was there a decision to make no adjustment for pay parity, given they're competing in the same market with other providers that are getting that?
Senator, the CLSP is slightly different. So the NAJP hadn't been indexed, or it had been indexed on that 1.5% rate, the NLAP that we've talked about in various Senate estimates hearings over the years. The CLSP did receive indexation and also extra loading over different budgets through a community services additional funding amounts, so they weren't at the same starting position as the NLAP providers were. They were in a better position, but the pay parity funding was for NLAP providers, not for the CLSP.
Will you be sitting down with the sector to help work out what the selection and eligibility criteria will be for the additional funding? And will it include, for example, them being able to meet pay parity, or then being able to extend essential services? What's the criteria for the additional funding?
Senator, that will be contained in the grant opportunity guidelines that haven't yet been released.
What's the amount of additional funding available for the whole of the CLSP?
That will also be in the grant opportunity guidelines, but do you have the...
There must have been a decision, Secretary, about the amount?
There will be a $67.5 million grant opportunity from 25-26 to 29-30.
Sorry, so that'll be over how many years?
5 years.
All right. Yes, I have a bunch of other points. Sorry.
Well, it's sort of time for me to share the call. The person I will share it with your colleague, Senator Waters. If you've got a couple on this,
Senator Waters snuck in there. Yeah. Oh, I don't mind if you want to be quick. Okay.
Yeah. Just in terms of managing the time, we're a bit over time now.
I know that Senator Gosh asked some questions about the NAJP funding allocation. The sector is asking what the evidence base was used in determining the funding allocation, particularly by jurisdiction or by part or by sector. What was the evidence base that the department used when working out the allocation?
Senator, I will answer that. I'm just finding the brief.
Senator, sorry. I'm just trying to work out
you work
the
out
best position to answer questions.
Do a tag team, I don't mind.
Yeah. Sorry about that. So you asked about how the $3.9 billion in NAJP funding has been allocated across jurisdiction and the sectors. So the distribution of that funding consider a number of principles and the factors. So you're probably aware the first principles we considered is for all providers, and they will not receive less funding than the last year for 24-25 NLAP. The second consideration is, and there are a number of our program has been transitioned from into the NAJP, which currently sits outside NAJP. The footprint of those programs has been reflected in the distribution of the funding across jurisdictions and the sectors. And the distribution also considered the varying needs and the cost of delivering legal assistance services in different regions. And we all know some jurisdictions are vastly vast than comparing to other jurisdictions, and some jurisdictions have a higher proportion of Aboriginal, Torres Strait Islander clients. So last principles, you're probably also aware that NAJP included 2 quarantined streams in women's legal services and FEPLS. So the distribution of the $3.9 billion to jurisdiction and sectors and consider all those factors.
All right. I mean, the sector simply doesn't understand the basis upon which these determinations were made, why Service A got an uplift, Service B didn't. I think they understand small elements of it, such as prioritising domestic violence and family violence services. But for the rest of it, they're just mystified why Service A got a bump, Service B didn't. Is the department going to issue some kind of clarification setting out these principles in detail that at least the sector can then say, well, actually now I have some understanding about why I'm here?
Senator, the NLAP currently, the funding is distributed under a funding distribution model that was designed under the National Partnership Agreement, which takes into account a range of different factors, including different priority groups, the cost of administering an organisation, etc. That the majority of the $3.9 billion was allocated based on an updated version of that funding distribution model, and the sector has had plenty of information over the years about what is included in that funding distribution model. The Commonwealth's also been clear, and it's in the NAJP itself, that NAJP funding is administered in accordance with Commonwealth priorities, which include family law, combating gender-based violence against women and children, particularly Aboriginal and Torres Strait Islander women and children, alleviating cost of living pressures such as employment, welfare, housing and financial disputes, and closing the gap and reducing incarceration rates for Aboriginal and Torres Strait Islander adults and youth, and that's in NAJP Clause 16. So those kinds of things were factored into the distribution, and that's been quite transparent across the sector, and we did work with the states and territories to work through the best way for funding to be distributed as well across those priorities.
I think there's $300 million for workforce and organisation sustainability, is that right?
Approximately.
Yeah. And over how many years is that?
Everything's over 5 years, Senator.
And there's another $500 million for assisting frontline service delivery, including those priorities and their reasonable priorities of domestic and family violence. Is about $500 million for that?
Yes, Senator, that's
yep. What measurement tools is the AG going to use to ensure that say that $500 million is meaning women and kids in the NT will be safer at the end of it, for example? What are the measurement tools?
Yeah, so Senator, there is a range of obviously reporting so that we can know what the service service delivery, both to priority clients as well as the types of services that are being provided. And we actually have quite a long-term view now of what those services look like. There's always work to be done around the data, but one of the commitments under the NAJP is the development of an outcomes framework in consultation with the sector and the states and territories to really be able to measure the outcomes that this funding does deliver upon, and I think that's due to be done in the first 2 years of the NAJP.
So currently there's reporting about what services are provided, how funds are accounted for, and that's similar to the reporting that was done under NLAP, I assume. Is that right?
That's correct, Senator. We have made a decision to continue the current reporting while we develop the outcomes framework and the data strategy that we mentioned earlier.
Well, those measures, those outcomes against which services will be measured, they won't be in place for another 2 years. Is that right? On what you've just said?
We'll receive the standard reporting as usual, but the outcomes measurement will happen in the first 2 years, and we're consulting with the sector on the best way to measure outcomes.
Given we're in this space where states and territories are often changing the law directly contrary to what the Commonwealth's goals are, how will that factor in to the outcomes framework? If you're trying to reduce the level of family and domestic violence in the NT, and you have the NT government pulling kids and First Nations communities into jails at record rates, not providing services in jails, and then sending people out even more damaged by the criminal justice system, how is that going to factor into measuring the outcomes on domestic and family violence?
I think there is work that will need to be done to reconcile, I'm not sure that's the right word actually, but to capture how the funding allocated under the NJAP is contributing to the desired Commonwealth outcomes, but recognising that that we don't own the whole ecosystem within which that funding is applied. So I take your point. It's going to be something that we will need to work through with the states and the territories when we're designing the data strategy and the evaluation. And I would say I don't understate the importance of the data strategy and the work around outcomes evaluation, because I don't think it's been perfect in the past, and we need to improve it.
And is it the intent that states and territories will be bound by targets and bound by a national framework, including for their funding, in a similar way which the Commonwealth binds states and territories in, say, education and health funding? Is that the intent?
I don't think we're at a point of determining that. I mean, obviously we've allocated Commonwealth funding. We will once the partnership commences. And we will seek to do the data and evaluation framework collaboratively with the states and the territories.
Well, of course, when it comes to youth justice, which cuts across all of these pools of funding, a big chunk of your work has already been done for you in terms of what reforms could be done at national level with the Help Way Earlier report from the National Children's Commissioner. Is the Commonwealth going to respond to that report?
Senator, obviously we have received the report, considered it. The government doesn't generally formally respond to reports of the Human Rights Commission. That's been a traditional position, but obviously we want to engage with the content. Many of the issues that are raised in that report are matters for state and territory governments as well as Commonwealth, and I think we will draw on it as we do work not only in the legal assistance space but in other spaces.
Well, this isn't just any report. It's a report from the National Children's Commission that I think for the first time I've ever seen has been unanimously endorsed by children's commissioners of every state and territory, including First Nations children's commissioners from across the country. It elevates it, I think, to a different level in terms of driving what should be the Commonwealth Government's national response to the youth justice crisis. Will it be just treated as just another report from the Commission, or is it being centred in the work being done by the department?
Certainly, we see it as providing a serious contribution, and picking up on your point that it's been endorsed by all state and territory children's commissioners. If that is the case, then that is another mechanism for us to collaborate with the states and the territories and draw in their children's commissioners as appropriate.
Right. I'm moving to a different thing. So, Senator Waters.
Senator Waters, you have the call, and I think during your block, I hope you don't mind, but we'll do a bit of chattering about the program while you're asking questions, because we're running quite far behind now, and we will need to make a decision about agencies this evening. But I'll have
depending on answers, I think I have about another 10 minutes.
Okay. Thank you. Senator Waters, you have the call.
Thanks very much, Chair. Hello again, folks. I've got some questions about non-disclosure agreements and about workplace sexual assault and harassment. And I've had 2 lots of advice so far, one of which was that this was on later, and the second of which was that this was on now.
I think it's on later.
So non-disclosure agreements will be
in relation to sexual assault in particular.
Yeah, I think that would still be there, yeah. It would be in the later group.
I beg your pardon?
It's in the Integrity and International group.
Okay, so I was just advised like 45 minutes ago that it was here, and yet this morning advised it was integrity. Why don't I have a go at the questions and answer what you can, and we'll work out where they do best belong. Thank you.
Happy to do that.
Doing my best here. Okay, firstly, I want to start off asking about parliamentary workplace settlements, in particular in relation to sexual assault, sexual harassment, bullying and discrimination. So this is just in the parliamentary setting. What is the current policy in relation to those settlements, and has it changed recently?
That is definitely in the Integrity and International group, which is 2 more groups on from where we're at the moment.
Okay. Last estimates, we had some good detailed exchange about workplace sexual harassment claims against the Commonwealth, for which your department had some oversight when they were considered significant matters. I've got a number of follow-up questions in that chunk.
So again, that's the Office of Legal Services Coordination, which is in the Integrity and International group.
Okay, thank you. We have sought clarity now 3 times on this, and we've gotten a different answer each time, so I will come back then, and I would like my questions responded to at that point. Thank you very much. Thank you, Chair.
Sorry, Senator, I don't know who provided you with that guidance, but...
All I know is that it was the department. Anyway, it doesn't matter. I'm sure it's nobody's particular fault, but this is an ongoing issue across all estimates, and we shall see each other this afternoon.
Thank you, Senator Waters. Now, Senator Shoebridge, we're handing back the call. We're still in Justice and Communities, and I think you might be able to take us to the next group.
That is the plan. What is the status of the proposed Judicial Commission, Commonwealth Judicial Commission? And I ask this because I think submissions, or the review reported in August of 2023. I don't know, that feels about right, August of 2023? 2022, 2021, sometime. The parchment is yellow. I don't know exactly that. The parchment is yellowing.
Senator, I'm happy to commence, and then my colleagues who might have a little bit more detail at their fingertips will respond. But there was a task force formed in the department to scope a federal judicial commission. There was a significant amount of work undertaken to do that, which did involve a range of consultations, and I think a public consultation paper as well. Then that work, we kind of pulled together all the consultation work and provided advice to government on it. And the task force was disbanded early last year, and that work kind of folded back into the courts branch. Sorry, I was trying to remember the name of the branch. And any decisions about taking forward that work are with government.
I mean, Secretary, this is the department all over. You make an announcement, create a task force, do some scoping, do some consultation, apparently provide some advice, you disband the task force and nothing changes. That's what we have for the Judicial Commission, isn't it? That's the arc. Am I wrong?
I think the critical thing is it's under consideration by government.
Well,
so all that work has been done, the policy work, the consultation.
But what's happened? Do we have a Judicial Commission?
No, we don't.
Are we going to get a Judicial Commission?
It's a matter for government.
Is it a good idea to have a Judicial Commission? Everyone else has a Judicial Commission. The Commonwealth doesn't have a Judicial Commission. No one knows where to go to complain about judges. Everyone wants a Judicial Commission. And we've got a task force. Well, no, we had a task force. Minister, is the government committed to doing something with that, I don't know, countless tens of thousands of hours of Commonwealth bureaucrats' work?
Well, all these matters are matters that the Attorney-General is giving deep thought to, and at the appropriate time, Senator Shoebriggs, he will make an announcement about what the government's response is.
So at the appropriate time, in the fullness of time, at the appropriate juncture, at some point, we may get a response.
Well, I've answered the question, Senator.
Is the government committed to delivering a Judicial Commission?
I've just answered your question, Senator. The issue is under consideration by the Attorney-General, and he will make an announcement at the appropriate time.
When was the advice given to the Attorney-General, Secretary? When did it land on his table?
I'd need to take that on notice, Senator.
All right. Could I ask you about the Commonwealth's action plan to prevent and respond to child sexual abuse? Who's best to deal with that?
Yep. Yes. Yep. I'll just get some additional officers at the table.
That's okay. We'll get started, Ms Harvey, because we're running late. The first action plan to prevent and respond to child sexual abuse has a range of measures and services that are funded up until the 30th of June of this year.
Yes.
My office has been approached by people in the sector deeply uncertain about what's happening from 1 July onwards. Can you provide us what the plan is for from 1 July and if there is going to be a second action plan?
I might get my colleague, Mr Collette, to talk to this. Thank you.
Thank you, Ms Harvey. Thank you, Senator, for your question. We have started a range of consultations with the sector, with states and territories, with other experts working in this complex and important space with a view to developing a second action plan. Issues around funding are, of course, a matter for government when it comes to decisions and announcements, but these are issues we are working through.
Yeah, but it's the 25th of February and the first action plan expires on the 30th of June. There's a little thing called the federal election in the middle. What about those services? What about those measures that are funded up until the 30th of June? Is there a commitment to continue the funding after the 30th of June?
Funding decisions, Senator, are a matter for government.
Well, yes, it is a matter for the government. To your knowledge, has there been any commitment to fund those services from 1 July onwards?
I'm not in a position to make any specific comments at this time.
Well, I'm not asking you to commit to the funding if it hasn't been committed to. I'm not asking you, definitely not asking you to withdraw the funding. I'm just asking you whether or not you're aware if a decision has been made about the funding and whether or not those services will continue.
These are issues we're actively working on, both in providing advice to government and in consultation with the sector.
So would it be fair to say a decision hasn't yet been made, so far as you're aware, as to what will happen with that funding?
Well, decisions are a matter for government to announce. But.
All right. If a decision has been made, it hasn't been announced. So I want to know, has a decision been made and not announced? Is there no decision? Should these services be knocking on the doors, asking for a decision, or should they be knocking on doors, asking to be told about a decision that's already been made?
These are issues that we are working on now and are still under consideration.
Well, I'll give you one example. The Youth Law Australia's Australian Maltreatment Legal Service. It's funded under the First Action Plan. From what I can tell, it's the only legal service in Australia that operates nationally, dedicated to assisting children and young people under 25 who are experiencing all forms of maltreatment. Now, is their funding going to continue from 1 July onwards?
Senator, I can't make a further specific comment. I do note that Youth Law Australia provides an incredibly important service.
Which may end on 1 July, you see. It may end on 1 July. Will it end on 1 July because the Commonwealth withdraws the funding?
Senator, I think Mr Collett has indicated that issues around ongoing funding of the program are still under consideration. And Mr Collett and his team are working with colleagues across government on that issue.
But Secretary, you know you can't run a legal service effectively. You can't keep your key staff. You can't keep your committed, often young lawyers. If you may have to shut up shop in 2.5 months' time or 3.5 months' time because your funding's pulled. These services need this information urgently. Otherwise, they're going to be letting the solicitors go. They're going to be letting the counsellors go. They're going to be shutting down their premises. You do know that's the effect of not making an announcement in a timely manner, don't you, Secretary?
I understand the desire for certainty from the organisations that we fund. One of the significant things that happened in the National Access to Justice Partnership was the ongoing funding certainty that's been provided there. So I acknowledge that point.
Well, can you give any indication about when a decision's going to be made, either about a second action plan with funding or some other announcement about funding, continued funding for the services under the first action plan? Is there any time frame they can look to?
Senator, that's subject to government consideration and budget processes.
All right. Secretary, are you aware of an approach that's been made to your department by a survivor of abuse asking for a task force to look into the Jehovah's Witnesses, concerned about their continued failure to respond to child sexual abuse claims and forced labour in the organisation, and their concerns that despite notionally being part of the redress scheme, I think they've paid out on only 2 claims. Are you aware of that approach to the department?
Senator, I don't believe I'm directly, it doesn't ring a bell with me, but can I ask Mr Collett to respond?
Yeah, Senator, citizens do contact the department through the National Office for Child Safety, given its responsibilities on a range of issues that certainly go to the sorts of matters that you've just described. I can't be certain based on the comments you've made, but that would be the sort of thing that from time to time we do receive correspondence about.
Could you take it on notice? And I raise it not just because I think these matters are raised in my office, perhaps other senators as well, but it was also explicitly dealt with in the Royal Commission into institutional abuse. A series of commitments were made from the leadership of the Jehovah's Witnesses to reform the organisation's child protection policies, and the information provided to my office is that those commitments have been breached. So could I ask you to take on notice if you're aware of these concerns and what, if anything, has been done in response to them?
Yeah, certainly happy to take that on notice, Senator. And I'm conscious that while estimates occurs in the public domain, if there was specific information you wanted to provide to us, we're happy to receive that.
I understand. And my final question in this space is about AI and copyright.
I'll just get some additional...
you just need to swap out some offices.
That's okay. Well, while people are coming forward, I'll just get the question out. Are there any plans or consideration to amend the Copyright Act to remove what's now being called the copyright removal hack in AI circles, where the fair use entitlement is being abused to feed a copyrighted work into an AI, allegedly as fair use, but then effectively own the intellectual property and the copyright thereon by having it fed into an AI model and then constantly, repeatedly used to generate content. Is there any reform looking to shut down that copyright removal hack?
Senator, so the Attorney General announced that copyright and AI would be a review undertaken over the next 12 months, so some funding was provided last year. As you know, the Copyright and AI Reference Group is a stakeholder consultation group. I'm not sure specifically in respect of the issues you raise. I think that fair use is a concept that is very prevalent in the US copyright space and is something that is frequently discussed in terms of inputs and outputs that go to copyright and go into AI, and the copyright treatment of those inputs and outputs. They are part of the conversation with the KEG.
All right. It's a concern, I think, for most creatives across the board, but it's a particular concern, I think, as well for First Nations people who are having their cultural knowledge being fed into these AI platforms and expropriated. I think I've asked before about the engagement with First Nations peoples in that copyright review. Have you uplifted your engagement with First Nations peoples? Are there more First Nations voices at the table?
So, Senator, the KEG is an open forum. It has particular focuses and calls for expertise. First Nations expertise and knowledge is one of those items. Anyone can be part of that consultation process, and we have a number of people that have both expertise in and knowledge of First Nations intellectual property matters, and they are engaged in the KEG.
Yeah. I mean, I'm sure the department has done consultation before, and just simply saying, well, it's a level playing field and it's open to all people from across society to engage, and then the assumption that First Nations groups, community groups, traditional owners will have a level cultural or material platform to engage with is plainly false. Just opening it up neutrally to First Nations groups is not actually doing the job that's needed to reach out to First Nations knowledge holders and bring them in. What are you doing to fix that?
So, Senator, across government, the KEG is focused particularly on AI and copyright, and as I said, we have people representing those particular areas within that consultation. But there is also the Indigenous Cultural and Intellectual Property, or ISIP, process, which is undertaken by the Department of Infrastructure, Transport, Regional Development, Communications and the Arts, and they are leading that work, and that, of course, has a particular and specialised focus on Indigenous knowledge and intellectual property, and we work very closely to understand issues that may arise in the context of that work. There are members of that expert group who also participate in the copyright consultation and conversations.
All right. Perhaps on notice you could give me details of those structures and the meetings, and if there are First Nations reps, their involvement in whatever meetings or consultations there have been, if you could do that on notice.
Yes, Senator.
All right. Thanks, Chair.
Thank you, Senator Shoebridge. I believe that's all the questions we have for the Justice and Communities Group, which means that I'm now able to call officers from the National Security and Criminal Justice Group. Perhaps if we have a very short suspension to allow those officials to come forward. From a broadcast point of view, thank you. We'll return to our hearing, and I now call officers from the National Security and Criminal Justice Group of the Attorney General's Department. Senator Cash, I believe you have questions.
I do. Thank you very much. And this is where I was directed this morning in relation to the ICC warrants and Prime Minister Benjamin Netanyahu. Secretary, is Israeli Prime Minister Benjamin Netanyahu welcome on Australian soil?
Senator, I think that's a question outside the remit of the Secretary of the Attorney General's Department.
Well, then I'll ask Minister, is Prime Minister Benjamin Netanyahu welcome on Australian soil?
Well, Senator, we have had a very long and close relationship with the State of Israel over a very long period of time. As you know, it was Minister Evatt who ushered through the creation of Israel in the 1940s. To the best of my knowledge, we've not had any request from Mr Netanyahu to come to Australia, so it's something of a hypothetical question.
Well, perhaps, Minister, the reason we haven't had a request from Prime Minister Netanyahu to come to Australia is because your government, and in particular the Prime Minister, has failed to rule out whether Mr Netanyahu would be arrested if he sets foot in Australia, as requested by the International Criminal Court. The Coalition has a very clear position on this. Mr Netanyahu is welcome in Australia and he would not be arrested. Will Prime Minister Netanyahu be arrested if he sets foot in Australia under this government, as requested by the International Criminal Court?
Consistent with long-standing practices of successive Australian governments, including your own, Senator Cash, Australia respects the independence of the ICC and its important role in upholding international law. As I said, to the best of my knowledge, we have not had a request from Prime Minister Netanyahu to come to Australia, so it's a hypothetical question.
Again, with all due respect, perhaps you have not had a request because you have not been clear, unlike the Coalition, that Mr Netanyahu is welcome in Australia and he would not be arrested. Secretary, have you had any discussions with the Attorney General or the Attorney General's office in relation to the ICC warrants that have been issued against Mr Netanyahu?
I do not believe I've had a discussion with the Attorney or his office. Okay,
so you haven't provided any advice to the government?
Now that I would need to take on notice.
Yes, we'll take that on notice. We know that the Attorney General's office is obviously aware of the ICC warrants.
And how do you know that they're aware?
Because it's a matter of public knowledge and we've had some communication about that fact.
What communications have you had and when?
We need to take that on notice for further detail.
Well, you're the one who raised it, so I'm assuming you have some form of knowledge in your mind. So what knowledge do you possess in relation to the statement you've just made?
I won't be able to add to the detail. I just know that we have had contact with the office, but in terms of the specifics of that, we'll take that on notice.
When you say we have had contact, who is we?
The International Crime Cooperation Area.
Is there anybody here from that area?
Yes, my colleagues are here.
Excellent. Perhaps I could then direct the question to you. In relation to the evidence that has just been given, what contact has been had with the Attorney General or his office?
Senator Susie Williamson de Vries, Assistant Secretary for the International Cooperation Unit. As Ms Chidgey said, there has been contact. I have personally had contact, but I'd need to take dates and details on notice. I don't have them with me.
So you have personally had contact with the Attorney-General or his office or both?
The office.
The office. What was the nature of that contact?
Just discussing information that's in the public about the arrest warrants.
Okay. Have you provided any advice to the Attorney-General?
I believe we'll have to take that on notice.
Why would you need
certainly.
to take it on notice? You're the one who's been having the contact.
I'm just, I personally have not provided any advice to the Attorney.
Do you know if any advice has been provided?
I believe it may have, yes.
Okay, by whom?
I'll just need to confirm that.
By whom?
It will be by our Office of International Law.
Okay. You seem to possess knowledge, but you're not sure of the knowledge that you possess, which does worry me sometimes. In particular, when a question was about to be taken on notice, but there was someone at the end of the table and nobody jumped in to say, I actually have this information that you, Senator, are requesting. Are you in charge of the team?
Yes, I am.
Right. In terms of advice that's provided to the Attorney-General or his office, do you sign off on that advice?
Oh, it depends on the advice.
Sorry, Tara Inverarity, First Assistant Secretary, International and Security Cooperation Division. I think it's just important to reflect there's a few different areas of the department with responsibilities relating to the International Criminal Court. Ms Williamson de Vries' unit is responsible for providing advice on the aspects of the International Criminal Court Act relating to extradition. The Office of International Law, which is in the Integrity and International Group, has a broader remit in relation to the International Criminal Court and other aspects of this matter. So I think Ms Williamson de Vries is recalling advice that may have been provided by the Office of International Law, which we were involved in but not directly responsible for, which is why we'd like to take it on notice to be able to confirm across the groups.
Is there anybody else from the groups who might be able to assist us in this matter who is here today with us in the room?
Senator, the Office of International Law is represented here. It's in the Integrity and International Group that's appearing next.
Okay. I was told to ask the questions here, though, this morning. I did seek directions as to...
I think as Ms Inverarity just explained, there are two parts of the department that have relevant responsibilities.
That's fine. Minister, are you aware that the incoming German Chancellor Friedrich Merz has said that Mr Netanyahu would be welcome in Germany, and in fact he has been reported as saying overnight, in the event that Netanyahu plans to visit Germany, I have promised myself that we will make a way to ensure that he can visit Germany and leave again without being arrested. I think it's a really absurd idea that an Israeli Prime Minister can't visit the Federal Republic of Germany. He will be able to visit Germany. As a senior Cabinet Minister in the Albanese government, why can't the Attorney-General Mark Dreyfus make that same commitment?
Look, I haven't been following the
You are a
elections.
senior Cabinet Minister in this government.
No, but you wanted to know whether I'd seen the comments of the potential incoming Chancellor of Germany, and I simply responding to your question, Senator, to say that no, I haven't seen his comments. I was at estimates until very late last night, and I've started again very early this morning. I will take it upon myself to catch up with what the new incoming German government is saying, because I think it's obviously an important change in Europe. But as I said before, to the best of my knowledge, we have not ever had a request under this government from Mr Netanyahu to come to Australia, so it's simply a hypothetical question.
Well, again, with all due respect, as has been raised by so many in the Jewish community, perhaps the reason there has been no request is because this government has made it clear that they don't have a position, or worse still, that they may well exercise those arrest warrants, whereas we have made it very clear, just like the incoming German Chancellor, that he would be able to visit Australia. Again, the USA And in fact, both former President Biden and President Trump have both made their positions clear. President Biden called the ICC arrest warrants outrageous. President Trump hosted President Netanyahu at the White House, as I'm sure you are aware.
Yes, I'm aware of that.
It was a sensible, clear, bipartisan commitment by our most significant friend and military ally in relation to Mr Netanyahu, or Prime Minister Netanyahu, being welcomed, whether it's under the Democrats or the Republicans in the USA. Can I ask again, why can't this government, the Albanese government, give the same clarity to Mr Netanyahu, but in particular the Jewish people in Australia?
Well, I am aware of Mr Netanyahu's recent visit to the United States and his meeting with President Trump, but as I said now 2 or 3 times, I'm unaware of any request by Mr Netanyahu to come to Australia, and it's simply a hypothetical question.
And again, with all due respect, the incoming German Chancellor has had no issues in relation to making a statement. President Trump had no issues in making a statement. President Biden was the president and has had no issue in calling out this. Minister, you said that we respect the independence of the ICC. On that basis, the ICC, as you'd therefore be aware, have independently said that they want Prime Minister Netanyahu arrested. If you therefore do respect the independence of the ICC, is it the government's position that Mr Netanyahu would be arrested if he comes to Australia?
No, that's not what I said at all, Senator.
Well, what do you mean when you say
well,
you respect the independence
I say what I've
of
said.
the ICC?
Senator Cash, just let the Minister answer, please.
Yes, thank you, Chair. Thank you for that protection. My answer is what I've said to all of your questions, and will be the same answer I give to all of your questions if you continue asking the same question. These are hypothetical issues, and I'm not going to speculate on hypothetical issues as to whether or not there may or may not be a future request by Mr Netanyahu to come to Australia.
Well, again, the Coalition has been able to make its position very, very clear in relation to, as what you are saying, is a hypothetical. But it is not a hypothetical policy. It is actually, Minister, with all due respect, a question of government policy. You are unable to rule out that you would arrest the Israeli Prime Minister if he came to Australia.
Senator Cash, please.
Do you perhaps think the reason that Prime Minister Netanyahu and Minister Albanese haven't spoken, we learnt this yesterday, in almost a year, is because Mr Albanese cannot guarantee that the Prime Minister of Israel, well, he can't guarantee his continued freedom if he was to visit Australia?
Well, Senator Cash, you were asking some questions earlier today about the Attorney-General's recent visit to Israel. That is not a sign to me of hostility between Australia and Israel.
Did you see the comments coming out of the Deputy Foreign Minister in relation to the Attorney-General?
Yes, I did hear those comments, but you know, Israel is a democracy, just like Australia. People can make comments, but the distinct impression I got from the Attorney-General was that his visit was well received, and of course he visited some of the places where the terrible atrocities occurred almost 18 months ago now. I'm not going to speculate on what may or may not happen in the event of a request by the Israeli government to send Mr Netanyahu to Australia. These are hypothetical questions. You may wish to preempt those issues. The government is not going to preempt those issues.
Well, that's fine. As I said...
Senator Cash, I have to share the call if you've got one more question.
I do.
A different one,
Secretary,
perhaps?
the Minister has just referred to the recent time spent by the Attorney-General in Israel. You gave evidence this morning that you accompanied the Attorney-General. Did the Attorney-General at any point assure the Israeli government that their Prime Minister is welcome in Australia and that he would not be arrested?
Senator, I'm not going to go into the details of the conversations that the Attorney-General had with Israeli government counterparts. He met with numerous ministers, including the President, but I don't think it's appropriate for me to go into the details of those conversations.
Well, again, it's a very simple question. Did the Attorney-General provide the assurance to Israelis?
Senator Cash, I did let you know you had one more question in this block. I'm going to share the call now. Senator Polly, I believe you have questions, and then I'll come to you, Senator Shoebridge, and I'll come back.
Thank you very much. How does the money laundering enable crime in Australia? If I can go to that area and get some advice, be great. Thank you.
Mr. Engel will take that question.
Yes, can I just ask if you can speak into the microphone a little bit more? I'm finding it hard to hear. Thanks.
Alex Engel, Assistant Secretary, Transnational Crime. Apologies, Senator, what was the question again?
I asked how does money laundering enable crime in Australia?
No worries. Yes. So money laundering, of course, is a crime in and of itself under the Criminal Code. But more importantly for us, particularly when we look at transnational, serious and organised crime, it's a key enabler as well. It's one of the key drivers to a lot of the serious and organised crime that we see in Australia. So when you think of drug trafficking, cybercrime, scams, even when it comes to child exploitation, other forms of serious crime, a huge motivator here is the funding, is the money. And then what they need to do with that is that they obviously need to clean the money so they can either enjoy it or parlay that back into further crimes to continue their organisation's work. So the money laundering regime that we have here in Australia obviously tries to go after that enabler, goes after the money, and then hopefully has an outsized effect on impacting serious and organised crime.
So what would be the estimated financial cost and the impact of organised crime in the Australian community?
Thanks, Senator. Andrew Warnes, First Assistant Secretary, Criminal Justice Division. So I think the latest estimate, I'm just going to get Mr Engel to check it, I think it was $67.8 billion.
Yeah, 68.7.
68.7, sorry, numbers backwards there, in terms of the cost of organised crime. And as Mr Engel said, obviously that money is money that can be laundered and reinvested into further crime, so it has a compounding impact.
So the Financial Action Task Force, the global financial watchdog, conducted a mutual evaluation of Australia in 2015.
That's correct.
What was the outcome in 2015 of the mutual evaluation?
Yep. So Australia, what they call enhanced follow-up. So in terms of that's how the FATF describes various levels of meeting the global standards. So obviously there's passing with flying colours. Enhanced follow-up means that based on our scoring or our evaluation, we're not passing with flying colours, but then there's also a further impact of how the FATF works, which is a grey listing and then a black listing below that. So Australia is currently not grey listed, but we are in a group of countries that has an enhanced follow-up due to our current effectiveness of our current regime.
Senator, Senator, just to add to Mr Engel's answer, so some of the key findings of the 2015 report I think are quite important. So overall, Australian authorities were shown to have a really good understanding of most of Australia's money laundering risks, but needed to develop understanding in further areas. There was demonstrated coordination in money laundering and terrorist financing, but there were some key risks that remain addressed. We had a good understanding of our terrorism financing risks, and that nationally AML-CTF coordination was very comprehensive. There was a recognition from the FATF that Australia disseminates and develops good quality financial intelligence, and so that's AUSTRAC through the Financial Intelligence Unit there at AUSTRAC. There was also some findings around the need to improve our regime, particularly around what are known as DNFPBs, so designated financial non-business sectors. So that was the accountants, lawyers and real estate agents that we've spoken about previously. So it is a very, very long document, so I won't take you through kind of the 2015 findings in full, but a lot of findings, as a lot of countries have, around ways in which we can meet the 40 recommendations of the FATF, which are quite comprehensive and set out a really detailed view across all of kind of Australia's regime in terms of money laundering.
So from 2015, with all the recommendations, what reform was undertaken to address their recommendations from 2015? When did the reform start?
Senator, when it comes to money laundering, that's a long question. The reforms have sort of been ongoing, I think, since 2005, and we've been working on various reforms for a while. I don't know if Mr Engel wants to speak specifically. There were reforms, I want to say around 2020-21 to address some of the recommendations. Mr Engel, do you want to go to those?
Yeah, so the reform, there were some changes to the AML-CTF regime in 2017, and then some further changes in 2020 that went to some of the FATF recommendations, but there were also some key recommendations around what we call the tranche 2 entities, so the lawyers, accountants.
But isn't it true to say, though, that no major reform had been undertaken by the former government over that 9 long years that they were in government until late in 2024, for which this government has taken action because it had reached a critical stage? And when you think that somewhere like Norway was far ahead of us, and it was pretty embarrassing at an international stage, I would have thought. So can you now talk us through what's happening going forward with compliance? And are we meeting the standards that is required of us? Are we catching up to other countries like Norway?
Senator, I think it's fair to say we're certainly catching up. Australia will be assessed. Documents for assessment are going to be due in 2026 with an on-site visit potentially late in 2026 by the FATF, and we'll discuss the report of Australia's mutual evaluation in 2027. So that's kind of the timeline that we are on. We've certainly, as you know, the government passed legislation late in 2024 which addresses some of the key deficiencies that were identified in that 2015 report. So we're certainly catching up in that sense, Senator. But as I said, there is a lot of recommendations, 40 recommendations. There's other areas where we'll continue to need to improve. The department's focus now in terms of the legislative reforms going forward is working with AUSTRAC, who are working on rules and guidance material for those sectors that have been brought into the regime, remembering that they won't actually face some of those obligations until mid-2026 is when they kick into effect. So we're working through with industry, co-designing some of those rules and guidance material, continuing to work towards making sure that we can lessen the burden as much as possible and that industry is able to understand their obligations so they can comply easily and quickly when those obligations commence.
But if you take from 2015 up to 2024, did the failure to implement these standards make Australia more attractive for organised crime, terrorists, crimes such as child exploitation?
So it's an incredibly difficult question to answer, Senator. I think what I'd say is anything we can do to harden our regime and make sure that it's not a destination for illicit funds or that illicit funds can't flow to things like real estate or to be reinvested in crime is a positive thing.
But there had to be an impact. I mean, that was a long lag time before any real reform happened. So money laundering, organised crime, it was much easier. That's why it was attractive, Australia as a destination and a target.
I think as Mr Engel kind of set out to you, that money laundering in and of itself is very attractive because people want to reinvest their illicit finances. They want to hide those illicit gotten gains from things like drug sales and other things. The focus of the department is to make sure that in the policy sense, we've got the best possible settings to detect and disrupt and deter that illicit financing.
So can you then step us through with the consultation into these sectors that this legislation change and reform needs to address? What consultation has happened? Is there areas like accountants, real estate agents? Is there any pushback?
Get Mr Engel to go through that for you.
Yeah, no, right. So there was two, in the lead up to the legislation that passed last year, there were two major public consultations that had consultation papers that went with them. So I think in total there was probably roughly over 200 different engagements with the affected sectors. So that's the existing regulated population like banks, but also the planned new sectors that are now will be brought into the regime now that the legislation has passed. So yeah, two formal rounds of consultation, many roundtables conducted by the department and AUSTRAC to make sure that we got the settings right to balance having an effective regime from a crime fighting point of view, as well as making sure that we are not overburdening industry as far as we possibly can. Now that the legislation has passed, a bit of that AUSTRAC is now leading on consultations around the rules. So the legislation, the Act itself, is sort of describes or has the obligations based on the outcomes that we want the regulated population to achieve. The rules provides a little bit more detail on how that gets carried out on a day-to-day basis. So AUSTRAC's going through a co-design process with industry now on that, and hope to have those rules finalised by mid-year, well before the Act comes into play for the new sectors. And then with that, a range of practical guidance, especially for small business, will be a part of that work.
Senator, you asked, I think as well, is there any pushback? I think what I can say from my understanding of the consultations and speaking to AUSTRAC is that industry is well engaged and engaging in those consultations that Mr Engel spoke about, and working constructively with AUSTRAC in the co-design of those rules and guidance materials.
So that consultation that was considered in drafting the legislation, and the sector had input into that, is that correct?
I think that's right. The one thing I wanted to add that I, having spoken to the CEO of AUSTRAC, is they are very much minded to look at existing obligations that small business in particular have in terms of reporting and being able to use or adapt that, as opposed to adding additional reporting or other obligations. So that's a really significant focus. And linking to your subsequent question about consultation, obviously that's something that came up through the consultation process.
And has there been any engagement with other countries that have been more advanced, that 9 years of wasted opportunity, that are more advanced? Are we engaging with them and learning from their consultation processes that they went through?
Yeah, absolutely, Senator. So, I think the FATF clearly told us with our deficiencies, pointed to some of the countries that were able to do these things. So we got some pretty frank direction while I've been at FATF meetings. We also engage really closely with the United Kingdom and New Zealand around how they went through the implementation of these reforms. So we were able to draw out some of the lessons learned, and particularly some of the consultation lessons around that co-design process were really important and borne out. And it's been really pleasing to see at the most recent FATF meeting, for example, Mexico, who also were struggling with some of these regulations, asked for some of the Australian experience around regulating and the legislative reform that we've done. So now we're able to share some of what we've done in terms of reform as well, to help other countries that may be trying to get up to the mark.
Well, that's what a good global citizens do, because organised crime, there's no fences, there's no boundaries, so we can learn from each other. What's the next step in transitioning businesses to have an understanding and compliance?
Yep. So as mentioned, we'll hopefully have the rules finalised by about mid-year. That will give clarity to industry. So for what we call the existing Tranche 1 entities that are already regulated, a lot of these changes will come in March 2026. And then in 1 July 2026, it'll come into effect for the new sectors, so those Tranche 2 sectors, accountants, real estate, lawyer, etc. So the rules will be aimed to be finalised by mid-year, and then on top of that will be a guidance process. So that's practical guidance day to day for industry about how to implement the changes. On top of that, AUSTRAC has received funding as well, which will partly go towards beefing up their education side of the house. So they'll be working closely with industry as they come into the regime to make sure that they understand what they need to do and how to practically implement it.
I was going to go to the question of funding for AUSTRAC. I don't suppose you would have the figure that the government invested to ensure that this work is undertaken?
Yeah, there was 166.36 million over 4 years from 24-25. So that figure includes 5.36 million over 4 years from 24-25 for AGD. AUSTRAC got 166.79 million over 2 years for that, and yep, I think that's the key figures there, 166.79 million for AUSTRAC.
So my quick calculations, what's 20% of that? And do you believe that would, if there was a cut of 20% of even just that funding that went to AUSTRAC to do this important work, that will have a significant impact, would it not?
Sorry,
I don't think I can answer.
Point of order, Chair. Senator Polly's putting forward a hypothetical. We covered this ground yesterday. I think it's extremely unfair to the First Assistant Secretary, who does a wonderful job, to put him in that difficult political position.
Well, thank you, Senator. I think we had hypotheticals from Senator Cash this morning about what would happen after the next election. The reality is we know that you cut 20% of a budget. It will have an impact on this important work.
Senator
But thank
Polly.
you, Chair.
Thanks, Senator Polly. You still have the call. I will hand it over in a moment.
I defer to my colleague.
I'm going to hand the call then to Senator Shoebridge. Thanks.
Thanks very much, Chair. Talking about hypotheticals, I have some questions about the National Firearms Registry. Please tell me it's not hypothetical. When are we going to get one?
It's a 4-year project, Senator, that commenced in July this year. Last year, sorry. I'm still stuck into it. Last year.
All right. I'm not much of a fan of John Howard, but he managed to deliver national firearms reforms.
Yours either.
Yeah, we don't send each other end-of-year cards. He managed to deliver national firearm reforms across the entire country, state and territories changing their legislation, federal actions and federal funding in about 6 months following the appalling violence of Port Arthur. And yet we're told that in 2025 it's going to take 4 years to institute a national database. How is that the case? We had actual substantive national firearms reforms done in 6 months, but we're told it takes, 4 years to get a database going?
Senator, they're not the same. The National Firearms Registry is a significant national project that will require changes to every state and territory's data collection systems and the connection of all of those systems with real-time data to a central registry that the Australian Criminal Intelligence Commission will have. All of that work is very significant in terms of the practical implementation and the systems and data changes that will need to take place in every jurisdiction.
Yes, they're not the same. One had 650,000 guns actually bought back and destroyed. One had every state and territory actually change their laws and agree to a set of changes laws which made Australia safer. And the other one's about a database. How does it take 4 years to get a database, just to get states and territories to agree on common data points?
Senator, 4 years is incredibly ambitious for a project of this scale. It will require a significant amount of work, in some cases uplifting paper-based registries to a digital one, so in building registries from scratch in a number of jurisdictions, changing all of the data standards for collection. At the moment, there is no real-time availability of this data. And so there is enormous work across 6 streams: systems work, data work, legislation, governance, to enable all of this. And having myself met with counterparts across all states and territories, there is a very high level of commitment and a lot of work that has started, but it is a very significant project.
Well, there are now, I think, more than 4 million guns in the hands of civilians across the country, some people having hundreds of guns. And just in the last week, we've had the ASIO threat assessment state that, and I quote, "Our greatest threat remains a lone actor using an easily obtained weapon." Even to address that threat, surely we can achieve a national gun registry in less than 4 years. It's an urgent threat.
Senator, I've explained what is involved. So there are systems and data sharing in place to a degree at the moment, but this is a complete redesign of existing systems across all jurisdictions.
You know, I don't think there would be a corporate entity that said we've got a tricky IT project and it's going to be ambitious to land it in 4 years. Like no NGO would say we've got a tricky IT project that would be ambitious. Well,
talk to the ASX.
It would be ambitious to land it in 4 years. Nobody talks about a 4-year IT project as ambitious, apart from the Commonwealth Attorney General's Department.
Senator, I'm sorry, that's just not fair. In terms of this project, the work that we have to do with every state and territory, with their systems, to uplift that, to build the system at the Commonwealth level that will connect, integrate their systems together. I want to build on what Ms Chidgey said, because there is great cooperation on this, more than I've seen on a lot of federal projects over a long period of time. But the reality is multi-dimensional IT build like this is complex and takes time. We are driving it as fast as is reasonably possible for the complexity and size of this. We've got a dedicated team who are working extremely well. Every police organisation around the country is very committed to this, and we will continue to drive it at pace.
You talk about a multi-dimensional IT build. We're talking about a database that is going to be covering 4 million weapons, right? And that's, for me, way too many guns in a nation of our country. But a database of 4 million firearms, it is hardly the most complicated database. There'd be local councils that had databases with more data points in it than the National Firearms Registry. You know, Wingecarribee Council's probably got a bigger database than 4 million data points. And you're telling me it's ambitious to do it in 4 years, while the ASIO director is saying that one of our greatest threats is a lone actor obtaining, and I quote, an easily obtained weapon.
So I don't think it's accurate just to say it's just a database. It's much more complex than that.
Well, describe to me why it takes 4 years to do a database covering 4 million items.
Senator, as we've said, it connects every state and territory and 5 Commonwealth agencies with near real-time provision of data in a whole range of areas. And I think we've been very clear that in some cases, for some jurisdictions, the information they've got at the moment is on paper. So as a starting point, even to digitise some of those jurisdictional holdings is required, let alone moving this information, including information coming from dealers and importers and manufacturers, into the system in real time is a profound change.
Look, providing real-time access to data is hardly a unique challenge. Like, Coles online shopping provides real access to data. Endless platforms, let me finish, endless platforms provide real-time access to data. Once you set the database up, you provide real-time access to data. That's not a reason to take 4 years.
It doesn't do that across 8 states and territories and 5 different Commonwealth agencies.
Well, I think it works in Tasmania as well as New South Wales.
Stop. Please let the official answer the question. If you want an answer to the question, let her finish. It would also be helpful if you would ask a different question, because you tend to be asking the same one over and over again. Ms. Chidgley, do you have something to add to that answer?
I think that it's probably everything we need to say about why it is a project of this size, scale and complexity.
Right. So it commenced in July of last year. What's actually been achieved so far?
I'll get my colleagues to talk through that in detail. We have Federation funding agreements with milestones in place with every state and territory. I chair a senior officials group where we meet every 3 months and map progress. And there's been a significant gateway review of progress for the project as a whole as well. But I'll get my colleague, Mr. Engel, to talk about some more of the detail.
Yeah. In terms of as mentioned, a lot of the key governance structures have been set up. So there's 13 agencies across the Commonwealth and states and territories, so that had to get put in place. Each state and territory is also finalising their project plans and their procurement for the project. They've all also had to, within their own governments, figure out their own funding profiles. So obviously us through the Commonwealth have received funding for our Commonwealth agencies as well as contributions to the states and territories. Each state and territory had to go through their own budget processes as well. The key plank of it is what we call the national data standards. So the National Firearms Agreement obviously had high-level commitments for each state and territory. So I think over the intervening decades, there's been slight variations in how each state and territory set up their registries and how they record the data. So once we agree to the national data standards, that will then allow for the building of the actual systems once that's agreed. So we are close to agreement on a national standard with the states and territories is probably the key piece.
I think, sorry, Senator, just to add to the other thing that we've been working on since that July date is getting the federated funding agreements in place. And so that was key to have all the states and territories sign up. So they started coming online from August all the way through to December. We had federated funding agreements for each state and territory jurisdiction signed. And the department's already started dispersing money in accordance with the agreements with the states and territories. So over $6 million, $6.2 million has been paid to state and territory governments as of the 7th of February 2025 in accordance with their respective federated funding agreements.
So the primary achievement for the first 8 months has been to finalise state and federal funding contributions.
And I think you've heard from Mr. Engel about everything he just set out about the data standards, working through the different groups, setting up the governance for the project. There's been significant work undertaken in the first 8 months.
Has there been any consultancies engaged?
Senator, I might just note that the Australian Criminal Intelligence Commission is responsible for the build of the system, the central register. Obviously, each state and territory are undertaking their own work on the changes needed to their registries. We can't answer that across the whole of the project.
So you don't know whether or not the ACIC has engaged consultants?
I think that would need to be put to the ACIC on notice.
Could I go to whether the issue of federal parole? It's true that legislation still makes the Federal Attorney-General responsible, subject to delegation for parole decisions for federal criminal matters, is that right?
That's correct.
When was federal parole legislation last reviewed?
There was a review undertaken by the Australian Law Reform Commission, I think in around about 2006. And after that, I think it was in the early 2010s, there were some significant reforms undertaken to federal parole arrangements. Since then, there hasn't been any major changes to federal sentencing.
I think it's true that every state and territory has a parole board, an independent parole board. Is that right?
Yes. That is correct, yeah.
That's correct.
And
I did want to note, because I know this is an area of particular interest for you, there has been an announcement about proceeding with a federal parole board, a Commonwealth Parole Board.
Okay. Do you want to put some detail to that?
I'll ask Ms Enverarity to talk to it.
Thank you. Yes. We are proceeding with the establishment of an independent Commonwealth Parole Board. It was announced by the Attorney-General on the 6th of February 2025. The government's committed $21 million over 3 years from 2025-26 through to 2027-28, and then $7.3 million per year ongoing from 28-29 to establish and operate the board. The board will require legislation to establish it, so we are in the process of developing that legislation, but what we are sure is that it will be comprised of experts with relevant experience in law enforcement, rehabilitation, victim perspectives, among other expertise, to make parole decisions for federal offenders. We've commenced consultations with some key stakeholders about the design for the legislation for the board. Ultimately, the timing for the establishment of the board will be subject to the passage of that legislation in the future.
And does the department have a timetable for an optimal time? Defence would call it an optimal pathway to put in place a parole board?
I think it's dependent on the legislative program in terms of that, but we have commenced the work to do the policy design and began the consultation, as I said.
Yeah. Is that going to look at is it going to address some of the inequities in the current system where, for example, people who've been convicted of a federal offence aren't given the same opportunity as many in states and territories to obtain, to have home detention during a non-parole period?
It will not change sentencing options available to courts. So in some instances, the availability of alternative sentencing options, such as home detention or other types of orders, is dependent on what is in place in the relevant state or territory. So this wouldn't change sentencing decisions by a court. It would change parole decision-making at the expiry of a non-parole period.
Yeah, it's been brought to my attention there are a number of people who've been convicted of federal offences who have been refused parole by the Commonwealth because, for example, they haven't been able to complete therapeutic offender programs when they haven't been eligible for them at a state level. An example would be somebody who had been convicted of a drug supply offence, had no history of drug use, and was refused parole because they hadn't gone to an addiction course, and they were refused eligibility to the addiction course because they were never an addict. Are these matters being addressed at all in this review?
So I think that's a slightly different issue to the establishment of an independent Commonwealth Parole Board. As you would be aware, federal offenders are housed in state and territory prisons in accordance with Section 120 of the Constitution, and states and territories are responsible for things like access to treatment programs. We are certainly aware that there are some circumstances where federal offenders are unable to access treatment while in custody, and that can affect the risk judgments that are made at the time they are being considered for parole. It's probably an issue we encounter more with child sex offenders than drug offenders, I think it's fair to say, and we have been engaging with states and territories to see what can be done to allow for access to treatment programs so that offenders can have the benefit of treatment while in custody, which flows through to be a relevant consideration at the time they're considered for parole.
Right. But those barriers to parole that currently exist for Commonwealth offenders aren't part of the scope of works for the parole board. Is that what you're telling me?
The establishment of an independent Commonwealth Parole Board will not necessarily make any changes to the treatment of options available. However, we would hope that in the future, if an independent parole board is established, that it would continue the interaction with state and territory corrective services to seek to ensure that federal offenders can have access to appropriate treatment while in custody.
Bridge, we're due to go to a break.
All right.
So I was trying to.
All right, just my last question is that part, is the ability to do that included in the proposed funding envelope?
The proposed funding we believe to be sufficient for the board to conduct all of its relevant operations, including engagement and liaison with a whole range of stakeholders, including a very key stakeholder being corrective services.
Thanks.
Thank you. Just before we do go to the break, we can let the Office of the Commonwealth Ombudsman be dismissed from the hearing, which is unfortunate because I think the National Student Ombudsman was going to appear as part of that, but we'll get to ask them questions at another estimates, I'm sure. Obviously, we will have to let other agencies go, but I'm still negotiating with my colleagues. So we will dismiss the Office of Commonwealth Ombudsman and go to a break until...
Sorry, I wasn't... is that a discussion with...
sorry, Senator Scott, I know you've got an interest in that area as well, but we have agreed to let them go. Thank you. So we will return at 3:30 after the tea break. Thank you. resume its hearing. We were still with the National Security and Criminal Justice Group. There are no more questions from the senators in the room, so that means we will just finish with that outcome and move on to the Integrity and International Group, which I think is probably for the best given the timing of the program. And for all our fans of the Director General of ASIO, i.e. the media, who are following along, we're probably still an hour away. Thanks, guys.
I thought he was here for us.
No. No. Senator Cash, you'll have the call once the officials are settled in. So
I'm happy to not ask any questions to move the program on.
No questions.
For this one, I think Senator Polly has a few questions for this part of the program. Just give us 1 second. There we go. Have you got those questions there? Thanks, Senator Polly.
Thank you. What did the Royal Commission recommend in relation to legislative frameworks for automated decision-making in government service delivery?
Senator, if it's all right, Simon Newnham, Deputy Secretary, Integrity and International Group. I'm going to ask a couple of colleagues to come to the table to take that question. I might need to get you to repeat it, but I'll just wait till they arrive.
No, that would be helpful. Thank you.
Senator, the colleagues who were just swapping over from the previous groups have arrived now, but could we ask you to repeat the question so that they can provide the answer?
Yes, thank you. What did the Royal Commission recommend in relation to legislative frameworks for automated decision-making in government service delivery?
Thank you, Senator. I'm Catherine Haig, First Assistant Secretary, Public Law and Modern Slavery Division. The Royal Commission made a number of recommendations in relation to automated decision-making as it relates to the delivery of government services. And those recommendations can be found in 17.1 of the Royal Commission report.
So, what were those recommendations and what were the reasons behind it? Can you just explain that, please?
Certainly. There were two recommendations. The first recommendation was to develop and implement a consistent framework to enable the lawful and appropriate use of automated decision-making in the delivery of government services. The second
what does that actually mean?
That means developing a consistent legal framework so that all agencies and departments that deliver government services have a consistent approach to administrative decisions that engage automated decision-making.
And what was behind that recommendation? Can you explain that?
Yes, certainly. That recommendation was intended to address some of the issues that arose and were explored in depth in the Robodebt Royal Commission around the issues that arose in that inquiry around the use of decision-making through rules-based decision-making.
And so the second recommendation?
The second recommendation, Senator, that related to the establishment of an automated decision-making body, and in particular the specifics of the recommendation were that the Commonwealth consider establishing a body or expanding an existing body with the power to monitor and audit automated decision-making processes with regard to their technical aspects and their impact in respect of fairness and the avoiding of bias and client usability. And this department will work closely with other relevant government stakeholders, including DISA, the DTA and the Department of Finance, to implement this recommendation.
So what advancements have been made to fully implement those recommendations?
So in relation to the first recommendation, a lot of initial scoping work and engagement with stakeholders has occurred. And we are engaging with those stakeholders to work through a range of issues. There's been project planning, stakeholder mapping, as I said, engaging with key stakeholders, research and analysis, and a public consultation on the development of the framework. That public consultation process recently concluded, and the team is now in the process of analysing the submissions received.
So how many submissions did the department receive?
I might see if my colleague, Ms McMichael, has that figure.
Hi, Teresa McMichael, Acting Assistant Secretary of the Administrative Law Branch. The department received 41 submissions, public submissions, and 20 survey responses. And then we've also had a separate internal to government consultation process, so we've received submissions from other Commonwealth agencies.
So what safeguards did the department consult stakeholders on as part of that consultation process?
The consultation paper was broad and just, it wasn't a sort of a set safeguards. It just talked about transparency and safeguards in general, and
Senator, the consultation paper at a general level is looking to explore how good principles of administrative decision-making can be incorporated in a transparent way into the use of automated decision-making by government departments and agencies.
So what are the key issues that came out of that consultation from the stakeholders? There must be at least some that you know without wanting to analyse all the submissions.
Certainly, Senator. What I can do is, at a high level, describe the key themes that have emerged from that stakeholder consultation. So what has become apparent that is key for the stakeholders is the importance of mandatory safeguards in developing any automated decision-making framework, the need to consider and manage risks around the ADM framework, and in particular, and this ties back to what we learnt from the Robo-Debt Royal Commission, the impact of automated decision-making on vulnerable cohorts of the community, the importance of monitoring and reviewing decisions made by an automated system, that information published about the automated system or the decision should be fit for purpose. I think what that means is so people can understand how the automated decision-making process works. And finally, that with the correct design, automated decision-making can bring about efficiencies and consistency for the delivery of government services for the benefit of the community.
Well, Robo-Debt and the Royal Commission into it has left, to say the very least, a scourge on the Australian community. So with these recommendations, are you confident that you can communicate to the Australian people that those safeguards are going to be put in place and they can have confidence going forward that there won't be a repeat of the Robo-Debt fiasco?
Senator, what I would say is that we're at the very early stages of this project. There's been funding provided for over 4 years, and that we are working very hard to develop and implement a consistent framework to enable the lawful and appropriate use of automated decision-making in the delivery of government services in the future.
Well, I will continue investigating this at the next round of estimates, because there's a lot of interest, as you'd be fully aware, of regaining the confidence. Have I got some more time?
You do have a little bit more time, yes.
Okay, I want to go to privacy reform, if I can. Do we need other officers, or you'll take it, Secretary? Thank you. On the Privacy and Other Legislation Amendment Bill, I just want to check that this includes most of the proposals from the government's response to the Privacy Act review. Is that correct?
Senator Simon Newnham, Deputy Secretary. Senator, it includes 23 proposals from the Privacy Act review. You might be aware there were 116 total recommendations in the review. 106 of those were agreed or agreed in principle, and this implements 23. I can certainly acknowledge that it does include the Children's Online Privacy Code, increased enforcement powers for the OAIC, new civil penalties, increased transparency for automated decision-making, which you've just been asking about, the criminalisation of doxing and the new statutory tort, amongst others.
So I was going to go there. The recommendation in the report that a statutory tort for serious invasions of privacy, what was the rationale behind the creation of such a tort? Can you step us through that?
Senator, I'm certainly happy to start, and colleagues can certainly come in behind that. The rationale is that it is a statutory tort that fills a legislative gap and applies in a more widespread way than the current scope of the Privacy Act, and in particular it offers protections to everyone, including, for example, women, where information is released in the context of domestic harm. It also provides for redress, but it'd be important to add there are high legislative thresholds there as well, and there are a series of defences available as well. So it seeks to strike a balance between broadening out the availability of that tort, but also recognising the need for certain safeguards and protections built into it.
Can you step us through the opportunities, or at least the potential avenue for Australians to sue where they've been seriously invaded their privacy, and how that will impact particularly on women?
Senator Catherine Fitch, Assistant Secretary, Privacy Reform Task Force. We're quite aware that women and individuals experiencing family violence are increasingly subject to technology-facilitated privacy invasions, such as cyber stalking and doxing, and there's awareness around that the law's struggled to keep pace with addressing that, and the tort will give victims of serious, as Mr Newnham has said, serious privacy invasions greater agency to protect their privacy by providing a clear path for them to take action and a wide range of remedies. And as Mr Newnham has suggested, the statutory tort for serious invasions of privacy applies to a broader range of entities and individuals than the regulatory regime in the Privacy Act itself does.
So with this bill that went to Parliament in October, my understanding is this is only the first tranche. So what work has been done to build on that going forward? Will there be other tranches as part of this reform? What's the next step in consultation with stakeholders?
Senator, thank you. The government has, is on the record publicly as having committed to tranches of privacy reforms. I'd reference the 2022 reforms that were made in the wake of some of the major privacy breaches we saw in that year. I'd also reference tranche 1 reforms, which we've just been discussing, and there is a commitment to so-called tranche 2 reforms. That will be involve the department working with key stakeholders, particularly industry, small business, the tech sector, representatives, civil society, academics, media reps and experts such as the Law Council. The timing, of course, for that is a matter for government. The department intends to begin consulting on draft provisions as soon as practicable. Obviously, the timing for introduction of a reform package will be informed by those consultations, as will the content of further reforms, and striking that balance between protecting personal information but also allowing sharing of data to the benefit of individuals and society and the economy, frankly.
Thank you, Chair. I know. That's it. Thank you.
Thank you very much for putting those two packs together in one block to allow us to get through this as soon as possible. Senator Shoebridge, you have the call now. We're in Integrity and International.
Yeah, thanks, Chair. I think I asked questions earlier about the government's response to the Parliamentary Joint Committee on Human Rights recommendations for a Human Rights Act. I checked since I started asking that question. The recommendations were delivered in May. There's meant to be a government response within at least 6 months. What is the government's response to the recommendations from that committee that the next Parliament get together and legislate a Human Rights Act?
Senator, I'm happy to commence, but again, colleagues may wish to come in on this. Maybe just to say up front, very much acknowledge the significant body of work and outreach that went into both the Human Rights Commission's Free and Equal project, which informed the Parliamentary Joint Committee on Human Rights report, which itself was comprehensive in the review of its scope and effectiveness with 17 recommendations. What I can say, Senator, is the government is giving careful consideration to that report. It is voluminous, and I take the point about the timing, but there is a great deal of material there. Obviously, the matter of an act, creation of a Human Rights Act, which was one of the centrepiece recommendations, is a matter for government.
But the good news, Mr Newman, is there's a nice act annexed to it. You don't have to draft it. You can just give it a big tick.
Senator, I note that. Obviously, these are matters for government. I would just say, though, in the interim, we obviously have laws in all jurisdictions that go to anti-discrimination. We have common law protections. We have monitoring of our progress in various UN fora. We have the statements of compatibility for all bills and instruments provided by the Parliamentary Joint Committee in the near term. So, but that's the status of where it is, Senator.
But the government was obliged, at least under the Senate standing orders, to have a response in by November. Is there an explanation for not having that done?
Thanks, Senator. Anne Sheehan, First Assistant Secretary, International Law and Human Rights Division. The timing of a government response is a matter for government. We have been working with the Attorney General's office on a government response.
Have you provided your work to the Attorney? And is it sitting with the Attorney or is it still sitting with the Department?
We have been working with the office on the content of a government response.
So your work hasn't yet completed? You're still working on it? Yes? Yes? No?
I would say it's a work in progress. We've been working with the office on what the content of a response could be.
All right. What are the blocking issues? What is it that is, meaning that the Parliament's required timetable has not been addressed?
Well, Senator, I would acknowledge the point I made earlier about the various components of existing frameworks that operate in that space as a first point. And a second point would be there has been a number of recent reforms progressed by government, so related reforms. For example, in merit-based appointment processes in the Human Rights Commission, the funding of the National Anti-Racism Strategy, significant increases in the funding to the Australian Human Rights Commission, the review of the Disability Discrimination Act, and the actioning of all of the respected work recommendations. So in addition to Ms Sheehan's outlining of that interaction with the Attorney in his office, in addition to the existing framework that's in place, there is also that point about the series of reforms that have been made in related areas.
Well, last time I checked, the projected income for the Australian Human Rights Commission is projected to decrease by some $10 million over the forward estimates. Has that changed?
Senator, I will get somebody to give the precise figures, but what I can say about the funding for the Australian Human Rights Commission is that in the 24-25 budget period, it's at $46,101,000, an increase of $4 million on the year before. It's the highest ever funding for the Australian Human Rights Commission.
That simply, at best, catches up to the cuts in real funding provided by this and previous governments, and it goes nowhere near making up the loss in other sources of funding that the Australian Human Rights Commission is receiving. At the end of this year, the Australian Human Rights Commission is going to have significantly less money than it had at the end of last year.
Well, Senator, I would note that the funding for the Australian Human Rights Commission, like other agencies, is made up of annual appropriation, so-called core funding, as well as project-based funding, and deliberately so, because project-based funding is for distinct, discrete projects over a period of time. It doesn't mean that the entity needs that core ongoing funding forevermore. But on both fronts, on the core funding and on the project-based funding, there have been significant increases in recent years. It is the case that in the out years, regularly you will see predicted drops, but of course additional project-based funding can come on at short notice depending on the nature of demands on the Human Rights Commission from various government and non-government sources.
The fact that the Australian Human Rights Commission still has to seek external funding just to keep the lights on should be a concern to you, shouldn't it, Minister? We're meant to have an independent Australian Human Rights Commission, yet their basic functions are in part funded by them going out to corporate Australia and government agencies to do project work. And the fact that that's been constrained in the future means that they're literally running out of funds. You don't think that's a problem, Minister?
Well, I don't think your assessment is accurate. We've just heard from the witness that, in fact, funding is increasing under this government, and I would have thought that was something that was positive and that you would applaud, Senator Shoebury.
Minister, the total funding available to the Human Rights Commission is projected to decrease significantly over the forward estimates. You don't think that's a problem?
Well, I think the evidence of the previous witness suggests that we're heading in the right direction here, and that under this government, unlike previous governments, then people should be confident that the task that we've set the organisation will be successfully completed within the economic framework that we have provided for them.
Secretary, to go back to where we were on the Human Rights Committee, and I know we've heard from the officers who are directly involved, but it's not the suggestion from your department that patchwork of responses is an alternative to a Human Rights Act, is it? That's not been put forward as an alternative, an equal set of actions to actually implementing a Human Rights Act, is it?
No, Senator. Obviously, the significant issue around the Human Rights Act and the legislative reform involved in that is, in a sense, a much more complex, longer-term issue to address. But I think it's important to note the significant measures that are happening to strengthen our human rights and anti-discrimination frameworks. whilst consideration is given to the recommendations of the committee and the work of the Australian Human Rights Commission.
I might just delve into tranche 2 then. These matters are related but distinct. Will PID Act reform be part of the tranche 2 of the privacy reforms?
Oh, sorry, you've gone to privacy reform.
I
just
have.
gets different people here.
Unless there are multiple tranches in other parts of your department? I know the attorney doesn't like the use of the term tranche, but it's stuck. It's tranche 2.
We'll have officers here in a moment that can assist.
Whilst they're coming forward, I'm going to be asking about PID Act reform and Whistleblower Protection Authority for starters.
Okay.
Would you mind repeating? Thanks, Senator, for foreshadowing.
Will PID Act reform, public interest disclosure reform, be part of tranche 2? And if so, will it pick up the lessons that we've seen, for example, in the Boyle case?
Just to be clear, are you meaning will whistleblower reform be part of privacy tranche 2?
Yes.
Well, Senator, that's not been...
Okay.
That's not been the way in which the government has considered that.
Well, then why don't we just go to PID Act reform by itself?
Sure.
Let's go to PID Act reform by itself. Where's PID Act reform up to?
Senator, what I can say is, of course, since the stage 1 reforms, which were put into place ahead of the creation of the National Anti-Corruption Commission, there has been a body of work on stage 2. As you know, these are issues that are more complex, but there is a government commitment to strengthening the framework, as I said, through staged reforms. There has been a consultation paper which you're across, Senator, with the 5 key issues. 50 submissions received, many of them published in April last year, a range of difficult and complex issues that exist underneath that. The timing and nature of those reforms are, of course, like all issues, a matter for government. And we are contemplating too this second tranche and how it interacts with a series of other reforms across the portfolio.
All right, but that process, at least the public part of it, ended almost, 10 months ago in April. Has the department concluded its work on that consultation? Has that bit concluded?
Senator Celeste Moran, First Assistant Secretary, Integrity Frameworks Division. Senator, I think I'd just add to what Mr Noonan said, which is that we received quite a lot of input through that consultation process, and I think he's made the point that they are complex issues that we're working through, and so we're continuing to work through those policy issues.
All right, so there's I assume the end of this is that there's no timetable for actual statutory reform, and we shouldn't be holding our breath waiting for some of the sort of now notorious problems in the PID Act that have become clear in the Boyle case, for example, being actually fixed. Is that right? It's a complex, long process that is nowhere near completed. Is that how I hear?
Senator, I think we would just add to that, and it's already been said, but the government has committed to this second tranche of reforms, and it remains committed to delivering strong, effective and accessible protections for whistleblowers, and that's part of the work that we are doing as part of the second stage of reforms.
But Secretary, meanwhile, whistleblowers are going to jail because of the gaps in the existing statutory protection. Poor Richard Boyle's been told that any gathering of evidence that he has for the purposes of making a protected disclosure is not itself protected, and that's meant for most whistleblowers looking at the space that the PID Act is no protection at all. If you can't gather your evidence together to make a disclosure, then it neuters the PID Act, doesn't it?
I'm not sure I'd completely agree with that description, but I think as my colleagues have set out, the next tranche of reform is obviously, we've had a lot of work, a lot of consultation, and we continue to progress it. Clearly, it's more likely to be a matter for the next Parliament, but we continue to do the work on that.
While this potential reform is grinding through so slowly, Richard Boyle is still being prosecuted by the Commonwealth. David McBride is in jail and his appeal is due to be heard next year. How much has the Commonwealth spent in trying to keep those two, try to keep David in jail and try to put Richard in jail? How much has been spent on each of those two cases, David's appeal and Richard's trial?
Senator, I would need to defer to colleagues who you've just heard from on Mr McBride, and the costs associated with Mr Boyle are really matters for the CDPP. I would note, Senator, though, that whilst we await that deliberate staged reform of the framework continues to operate. All 9 jurisdictions have frameworks in place. We have seen the establishment of the National Anti-Corruption Commission and the PWSS, the Parliamentary Workplace Support Service. We have done the Stage 1 reforms ahead of the NAAC and the Stage 2 ahead. And meanwhile, Senator, of course, the Ombudsman report annually goes to the number of matters that are brought forward each year. So in the most recent reporting period, there were 687 disclosures received across the public service. There were 35 complaints to the Ombudsman. A large number of investigations are finalised by agencies any given year, and they go to findings of contravention of the law, maladministration, conduct that may result in disciplinary action, and a range of actions are taken by agencies. So, Senator, I'm not for a moment brushing over the nature of your question or the concerns you've raised. What I am suggesting, though, is there has been staged reforms. There is a framework in place, and it continues to operate. There are further reforms ahead, and they are substantial, and they go to a number of the MOS recommendations, which we are quite seized of, but they are quite complex and go to some big fundamental elements of the framework.
Well, the MOS recommendations are so old that MOS has grown over them. MOS by name, MOS by nature. Can I get the number? Do we have the number? Do we have the number for the amount of money spent on David McBride's appeal, defending that appeal to try and keep a whistleblower in jail?
Senator, that was part of the previous group, but I think I can probably get my hands on that number for you as quickly as possible.
Because I did ask earlier.
Yep.
But
we'll get it.
Time.
So I will get that figure for you.
All right. No, that's okay. Thanks, Chair.
Thank you, Senator Pocock.
Thank you, Chair. Thank you for your response. I understand the NAAC was meant to be preparing last night. Yet again, didn't get to them due to lack of time. And I've got some questions about the robo-debt scandal. Minister, this morning you told Senator Rennick that a NAAC investigation into the scandal is the right outcome, and I wholeheartedly agree. My questions go to risks if the current Commissioner or Deputy Commissioners were to investigate the robo-debt scandal in light of the NAAC's original decision not to investigate, and I obviously accept that the Commissioner and Deputy Commissioners who directly made that decision will not conduct the investigation. But I think the public will be concerned that a Deputy Commissioner who sits under a Commissioner and alongside other Deputy Commissioners who decided not to investigate may not be impartial. Is this concern shared by your government?
No, Senator Pocock. I think we have to work on the basis that the people that we have appointed to these positions will do the job that is required to make the right choices and right decisions about what should happen in respect of this issue of the robo-debt. I don't believe we have any concerns about the appropriateness of these individuals hearing this case and providing a fair outcome for the Australian people. This will obviously be an important set of proceedings, perhaps the most high-profile set of proceedings that have been conducted since the NAAC was introduced, so it's an important issue. There have been some stumbling blocks along the way, and we talked about them earlier today. But I'm very confident that the community should not have anything to worry about in the way in which this investigation will now be investigated and completed and a report be handed down.
Thank you, Mr. And I'd ordinarily agree with you, but this seems like we're in pretty extraordinary circumstance where the Commissioner has been found of officer misconduct. Huge public outcry. And essentially they're being, they've now decided by an eminent person to investigate this, but it's going through the same process, the same people who are working with this Commissioner who sees no need to sort of step aside after such a huge failure. And my concern is that we're at a point now that, say they go through the right process and do all the right things, and there's no findings against individuals, perception matters. And the fact that you have commissioners, deputy commissioners, who are still under the Commissioner who made that decision, do you not see that as a problem? That even if they go through the right process, there's a whole bunch of Australians out there, given how egregious Robodebt was, who are going to say, well, the NAAC's done, shut it down at a time where we desperately need to build trust or rebuild trust in this institution.
Well, I agree that trust is an important issue, Senator Pocock, but I wouldn't have thought that this was any different than, say, you have a Chief Justice of the High Court and then you have other judges. I think we have to work on the assumption, and this is certainly the assumption I would make, that if somebody's been appointed to a Deputy Commissioner's role, then we should rightly say this person is capable of making decisions on their own behalf without reference to somebody more senior, and we have to trust the process to get the right result. Sure, there's been some hiccups along the way in this process, but I think we have to trust the decision-making processes from the start, that we've picked the right people who are going to make the right decisions in terms of corruption issues, and we should entrust the job to them now and let them do their job. I don't.
And what about public perception? I guess that's my concern here.
Well, I guess public perception will be judged by the final outcome of the proceedings, but I think we have to, we appoint people to these positions. When we appoint them, we work on the basis that they're the right people to do this job, and I think we have to entrust them to do it. And I think that's what we should do, and I'm not sure that ongoing public commentary about the matter, particularly in the Parliament, questioning the ability of these people to act impartially, actually adds to the ability of these people to do their job. I think we should let them do their job. We've appointed them to the positions, and now we should await their consideration.
I was just, if I could add, the NAAC legislation envisaged the Commission and the Inspector to provide oversight. The Inspector, based on receiving a range of complaints, conducted her inquiry and made some recommendations. They were accepted by the NAAC in order to reconsider the question of whether the Robodebt referrals should be subject to an investigation. In order to do that, they appointed an independent person, a former High Court Justice, to look at that. And I refer to that just because I think it provides a model for the fact that the Commission has available to it some mechanisms that can ensure that any future decision-making will be will ensure that it's appropriate and independent and the right frameworks are put around it.
Thank you, Ms Jones. And I want to ask about another thing that is in the legislation to do with this. I have an opinion here from the Honourable Dr Margaret White, AO, and the Honourable Michael Barker, KC, two senior former judges, and I'm happy to send it through to be tabled. The opinion finds that under Section 243 of the NAAC Act, the Attorney-General could appoint an acting commissioner for the limited purpose of investigating something like the Robodebt scandal. This would mean that the investigation would be untainted by any apprehension of bias or undue influence from the Commission or other Deputy Commissioners. Does the Department agree that the Attorney could appoint an acting commissioner to undertake the Robodebt scandal investigation?
Senator, thanks very much for the questions. Before I get to that, I would just, circling back to the...
I'm going to run out of time here, though.
All right, fine.
Sorry.
Well, Senator, what I would say is we're very mindful of the independence of the National Anti-Corruption Commission and its handling of this investigation. So in terms of being the accountable authority for the advice it seeks, the safeguards it implements, the decision maker, the staffing of the team, getting external advice, they are matters for the Commission, but we note, of course, the points you've made about the previous conflict of interest. As to the provisions of the Act, there are a number of provisions there. There's 243 and there's 276. We wouldn't give an opinion about the application of those particular provisions to these circumstances, but what we would say is that the Commission will need to consider the circumstances of these referrals and compliance with the legislative framework and the options for the optimal handling, including for the reasons you've mentioned a moment ago. So as with any investigation, it will rest on the relevant facts and circumstances. Deliberately, they are outside our knowledge. But as I mentioned a moment ago, the Commission, of course, can seek legal advice regarding the handling of this, can implement safeguards, and I'd note the appointment of Mr Nettle for his role in reassessing the decision that the inspector asked be remade was an example of some of those safeguards that can be put in place.
Okay, so I accept you maybe can't offer an opinion, but it seems to me, based on what you've said and this opinion, that the Attorney-General could actually appoint someone like Mr Nettle to undertake the investigation into Robodebt. Minister, is this an option that the government has considered?
Well, I'm not the Minister. I'd have to ask him,
maybe just on notice,
Senator, and I'd be very happy to do so, and I'll come back to you as quickly as possible.
Thank you.
If I can get an answer today, I will.
Thank you very much, Minister. And Minister, earlier again, referring to your exchange with Senator Rennick.
It was only a very brief exchange. A lot of questions seem to have arisen out of this.
I was listening carefully. You said that the process has been robust and has delivered the correct outcome. Can I take it that you agree it would have been better for public trust in the NAAC if the outcome from the start was an investigation into Robodebt?
Oh, I'm not one for looking back into the past. Senator Pocock, I think I did deliberately use the word robust. I think this is a good example of how all of the checks and balances that were set in place for the establishment of the NAAC have worked on this occasion. I assume you voted for that legislation. Is that a fair assessment? So all of these checks, I think the Attorney-General has to be congratulated because in a lot of the states, of course, these corruption bodies have been extremely controversial and have resulted in significant controversial reforms to the way in which they operated. I think the fact that the system worked on this occasion in difficult circumstances, I think is a very, very positive sign for the future of the National Corruption Body, and I think the attorney should be congratulated.
Former Senator Linda White, who presided over the Joint Standing Committee looking into the legislation.
And yes, that's a very fair point, Senator Scarr. She put a lot of work into this, and I think a lot of valuable work that she put into it. And I whatever the difficulties that have arisen that have got us to this point, I think it shows that the legislation was good legislation. It has those checks and balances, and those checks and balances have resulted in the correct decision being made. And we should now leave it and trust that, having got to this point, that we should leave it to the the people that have been appointed to these jobs. I've used this term a few times before to you, Senator Pocock. You don't buy a dog and bark yourself. We've appointed people to this position. We have to entrust them with making the right decisions to ensure that the integrity of the Australian political system works as it should.
Thank you, Minister. And I ask these questions because I get a huge amount of correspondence from Canberrans basically saying, like, burn this thing down and start again. Like, it's clearly failed. I think it's so important that we ensure that it has integrity, and so I'm trying to work out how do we do that. And to that end,
I'm
I'd
happy
like
to draft a letter for you to send to these constituents, Senator Pocock, and
send it through.
Okay.
Thank you, Minister. But
haven't you got enough on your plate?
No.
It's very helpful.
I've just got one more
Yeah, I do need to share
question,
the call in a minute.
Chair. And I guess while we're sort of mentioning people, I really want to mention Dr. Helen Haynes and Senator Shoebridge, who I know pushed hard and got the inspector, and Senator Waters here, the inspector component, and clearly very valuable and much needed. And so, to that end, you mentioned it going through in the votes that happened, I'd like to ask the department whether it is possible to make a legislative amendment to Section 73 of the NAAC Act to require public hearing if it is in the public interest.
Senator, obviously, in terms of drafting a provision like that, it's a matter of a policy decision of government as to whether it would want to make that change.
I'm just asking if it's possible.
I think in terms of technical drafting, I'd need to check, but obviously in terms of reform of any piece of legislation, if there's an intent to expand the scope of the way that an entity operates, that's technically possible, or in principle possible.
Okay, so it would be possible.
Senator Pocock, I need to share the call.
That's my last one.
Respond.
Minister, has that?
Sorry, the Minister's going to answer.
Has that been under consideration by government?
The issue of public disclosure, and there is a certain trigger point for public disclosure in the legislation, I think. It's a little while since I've read it, but what you've got to be careful here, Senator Pocock, is that in some of these state-based NAACs, the use of public hearings has resulted in people being found guilty before the trial has been completed, and so that by the time that the investigation is completed,
isn't that how courts work,
the community has come to the conclusion that the person is guilty, even though they may not have been guilty. And you've got to get that balance right, that people have got some rights in the process before a public examination of the issues. And I think time will tell, but I think we've managed to get the balance right in this piece of legislation, and that we won't find ourselves in the situation where some of the state-based systems have worked in such a way that a person's reputation has been destroyed, often by allegations that ultimately prove to be incorrect, and that we should give this new system a chance to work. It's relatively new. It's a couple of years old. I think what's happened in
Senator Pocock, please let the Minister finish.
I think what's happened in the robo-debt case should give the community confidence that the checks and balances worked, and we should give this new system an opportunity to prove itself.
Thanks, thank you, Senator Pocock. I do need to share the call. Senator Van, you're next.
Thank you, Chair. Mr Newnham, thank you very much for appearing today. Just a clarifying question to begin with. The Integrity and International Group and its divisions and branches, does that have a remit over the integrity of the department or other government departments or any of the agencies under the AG's department?
Senator, the answer is broadly no. What it has responsibility for is integrity reform across the system. So I guess it's fair to say that once, for example, whistleblower reforms are undertaken and implemented, they would be taken forward by our group, but they would then apply across the service.
I would add they're responsible for a range of frameworks. So the existing legal framework, so it's not just about reform, it's about administering existing frameworks such as the Foreign Influence Transparency Scheme, the Lobbyist Code of Conduct, and a whole range of other integrity frameworks.
Thank you, and thank you, Secretary. I think that means that this question's probably best directed to you then. Are you aware of correspondence from the Australian Federal Police Association to the Australian Federal Police and a copy of that correspondence forwarded to the Attorney-General?
I would probably just need to ask a follow-up question in terms of the date of that correspondence.
Yes.
I am aware of some correspondence in the past.
29 January it was sent to the Attorney-General.
The 29th of January this year?
This year, yeah.
I haven't seen
Chair,
that.
I'm happy to table this.
Sure.
I'll need to do it by email, so
And I have seen the media reporting related to that.
Van's raised this issue.
This is just some new correspondence. I've sent that to the Secretariat to be tabled. You happy to take some questions on it in the interim, if you're aware of it?
Well, I haven't seen that most recent correspondence. I saw a reference to it in the media, I think this morning or yesterday. I think in terms of any detailed response about it, I would need to take it on notice once I've had the opportunity to look at the correspondence.
I'll just put a question to you and then by all means take it on notice. In the letter to the AFP, which I said was forwarded on to the Attorney-General for his response, one of the senior managers at the AFPA says, and I quote, "I've become aware of an initial criminal investigation and subsequent administrative investigation into the conduct of 4 senior AFP members over the management and production of the body of works, who the AFP believe on reasonable grounds have or may have engaged in conduct that is corrupt or contravenes the AFP professional standards." Are you aware of any such investigations?
No, Senator, I'm not.
Okay, thank you. Thank you, Chair.
Thank you, Senator Van. Senator Waters.
Thanks, Chair. Hello, folks. I still have those same questions from earlier that pertain to both non-disclosure agreements in sexual harassment and assault claims against the Commonwealth, and also to start off with questions about settlements where the workplace is a parliamentary one.
Thanks, Senator. We're just getting the right people. And I just want to note, I think the reason we sent you in the wrong direction with your earlier query was we had thought, I think your set of questions about this last time were focused around children's, what was it, contact centres? And so they went in the wrong direction, so I apologise for that. I think we've got the right people now.
Great. That was a different set of questions, but thank you. Let's let's get on with it. Thanks, folks. So firstly, in relation to parliamentary workplace settlements for sexual assault, harassment, bullying or discrimination, does the Commonwealth or your department in particular have a policy about that?
Thank you, Senator. Broadly, the government's policy is to not seek confidentiality in the settlement of workplace sexual assault or sexual harassment matters, and only to agree to confidentiality when that has been requested by the claimant. And Senator, you'd appreciate that that approach is consistent with the guidelines on the use of confidentiality clauses in the resolution of
Sorry to interrupt
claims.
you, but actually I wasn't speaking per se about confidentiality in this first tranche of questions. It's just generally, do you have a policy on settling matters when it's a parliamentary workplace?
Where the Office of Legal Services might be involved in a matter, then what would apply then would be paragraph 4.5 of the Legal Services Directions.
Mm-hmm.
And that is a paragraph that establishes transparency in the resolution of Commonwealth in matters that are resolved through settlement. And that is the default approach that we take, and where confidentiality is an issue, then confidentiality around the whole agreement will only be sought when necessary to protect the Commonwealth's interests. But it is important to note that the policy that I just mentioned before is that the Commonwealth will not seek to any way prevent the claimant from telling their story.
Thank you. I'm actually trying to get at whether you have a policy about the quantum of settlements. Is there a range of quantum, or is it a case-by-case basis?
Senator,
is there any kind of rule of thumb that you apply?
So the overarching policy is that Commonwealth matters must be settled in accordance with legal principle and practice. There is no policy as to the quantum at a high level. It is determined on a case-by-case basis in accordance with legal principle and practice, informed by advice from counsel.
Okay, when you refer to legal principle and practice, are you talking about case law precedents or something more nebulous?
Senator, it's a phrase used in the Legal Services Directions.
Yep. What does it mean?
That means that that it must be in accordance with legal principles, so in accordance with a range of factors, what the relevant law, for example.
Case law precedent?
That will be part of it. What might the particular legislation and issue, what that might provide, the strengths and weaknesses of the particular evidence provided by the parties to a claim.
Okay. Thank you. And has that policy, particularly as regards the settlement quantum considerations, has that changed at any time in recent times?
Senator, not in any significant way that I am aware of. The Legal Services Directions have been in place now for some time, I think since 2017.
Okay.
Yes.
And perhaps if on notice, could you provide me what they were prior to 2017, if that's the point in time at which they changed? Thank you. And can I now go to the matter that you started helpfully referencing, so the use of non-disclosure agreements or confidentiality clauses in workplace sexual harassment claims against the Commonwealth. I asked about this last estimates, and you had 6 cases on foot at the time. One of them had yet to be resolved. Can I just firstly check, have there been any additional claims made since we last covered this?
I will ask my colleague, Mr Ng, to talk to you about the actual numbers.
Senator Philip Ng, Assistant Secretary of the Office of Legal Services Coordination. If I remember correctly, Senator, you asked us last time to go back the full 10-year period.
I'm still hoping to get that.
And I believe the response to that was provided to the committee yesterday. But that was...
It hasn't found its way to me yet, which is most unfortunate considering here we are now.
Yes. No, if it assists, Senator, I can take you through the figures that we ascertained as a result of those searches. So between the 4th of March 2014 and the 13th of November 2024, there were 14 settlement approvals for matters which involved workplace sexual harassment and sexual assault claims against involving the Commonwealth. Of those, 3 approvals included a condition that the Commonwealth was not to seek confidentiality over the settlement of the claim, but could agree to it if it was requested by the claimant. There were 6 approvals that included express terms that allowed the Commonwealth to proactively seek a confidentiality clause over either the settlement sum only or over the settlement sum and matters relating to the settlement process or previous investigations, and 5 approvals that contain no express terms of confidentiality, which, as indicated last time, allows the entity itself to make its own assessment of what's appropriate. I would add on that the government's policy is as outlined by Ms Haig earlier.
Yes, thank you. So of those 5 where there was no direction expressed, do you know what actually happened then in those 5 instances? Was a confidentiality clause used? So, Senator, I can give you the dates on which those settlement approvals were given. Some of those matters date back, in fact, to 2014, and we were not able to ascertain from our records to confirm what actually occurred in relation to the settlement. As you'd appreciate, Senator, the responsible agency remains the lead for the settlement. These are settlement terms that are approved by the Attorney-General or their delegate. They're terms that are approved, and then the agency is authorised to go and settle on those terms. So what I can say is that 4 of the matters in which there were no express terms on confidentiality were between 1 in 2014, 2 in 2015, 1 in 2017. There was a further, the 5th and further one, the date of the settlement approval was in August of 2024, and my understanding is that matter did not settle. Okay, thank you. Well, so you're saying for those other 4 you mentioned, you're actually not sure whether there was a confidentiality clause included because it wasn't your department that was issuing the agreement as such? That's right. Yeah, and okay. that would... Is it possible to ascertain that on notice for next time? We'll take that one on notice. Thank you. Senator. Thank you very much. Okay, so I'm just basically trying to get an idea of the trend. I understand that there was that decision whereby, in accordance with the Jenkins recommendation, that it only be used when it's in the Commonwealth's interest. So is it the case that the trend is that there's a declining use of NDAs at the behest of the Commonwealth, or is that me being too optimistic?
Senator, I don't know if we would have the data to be able to speak to a trend, but it is a very clear policy in place. The policy that we've outlined, that has been conveyed by this department to heads of legal across the Commonwealth at least twice. Yep. And so I think heads of legal are well seized of the Commonwealth's policy in relation to the approach around confidentiality clauses in the context of workplace sexual harassment or assault matters. Okay, thank you. In that similar vein, when you've done that communication with the heads of other departments, have you made it clear that you believe that workplace sexual harassment and assault matters are significant issues and therefore must be reported to your department? So, Senator, the communication was not with heads of department, it was with heads of legal. In relation to whether we communicated a position on whether workplace sexual harassment or assault matters are significant legal issues, I would have to check I don't know what we would have said, but whether we actually spoke to that issue, but the principle would be that it would be for a matter for each agency to assess based on the nature of the claim as to whether or not that agency considered a description of what is a significant legal issue under paragraph 3.1 of the Legal Services had been triggered.
So it's up to the departments, because when we last spoke, I asked whether workplace sexual assault or harassment claims against the Commonwealth would automatically be considered significant and ergo need to involve your department in the settlement terms. And you at the time said, look, probably, but you couldn't say 100%. And so I wondered, have you since sought to clarify that and to tell that to the other departments?
Senator, what we regularly engage with our colleagues across the Commonwealth on is what is a significant legal issue, and if it's helpful I can take you through that criteria.
Well, does it include harassment and assault is really the only bit I'm interested in.
No, Senator, but it does include things like the nature of the matter, whether it raises sensitive legal, political or policy issues.
Okay, so it's, sorry to interrupt, so it's possible that there might be other settlements of sexual harassment or assault claims that your department wouldn't be aware of then?
That is correct.
Okay, so is there any way that myself or any interested person can track that total number, if not through your department?
Certainly, Senator. We are working to gather the data so that we have got absolute certainty over the number of significant legal issues reported to this department that can properly be categorised as workplace sexual assault or harassment matters. But you're right, in terms of those that don't meet that threshold, that would be a matter for each agency.
So there's no kind of portal, isn't it? There's no one point of accessing that. You'd need to individually ask each
outside
department.
of the scope of the significant legal issues regime.
Which,
yes,
as you
Senator.
say, doesn't automatically include workplace harassment or assault.
The wording in the Legal Services Direction does not include that phrase.
Okay. Can I suggest that that actually might be a useful policy change for the department to track the numbers of workplace sexual harassment and assault claims across the department, even if they're not considered significant, which sounds still a little bit nebulous, although you've pointed me to a paragraph that I'll go away and read later. But I think as a matter of public interest, to be able to see whether or not there is a trend, and one would hope it's going down, but who would know, because we can't access those figures. So I can see the Minister's probably not necessarily hanging off my every word just at the moment, and that's fine, but it's just a suggestion for accessibility of information about the levels of workplace sexual harassment and assault in Commonwealth workplaces, and the need for that to be transparent so that people can track, is it getting better or worse, and survivors have some confidence that, you know, their wishes are being respected.
Thanks, Senator. We'll take that on board.
Yeah, okay, thank you. If I've got just a little bit more time, I've got a few more questions on this. We spoke last time about when confidentiality is only sought to protect the Commonwealth's interests under that Legal Services Directive, but is there a definition of what are the Commonwealth's interests?
In the Legal Services Directions?
Yeah, or anywhere. Like, how do you interpret that phrase?
No, Senator, that is not a defined term, and again, that no, there is flexibility around that term. But what we now have in place is a clear articulation of the policy, so that it would be the lens through which that phrase is now interpreted.
And sorry, where is the lens?
So that now, where we started was that since 2022, there's been a clear articulation that in the approach to settlements, they are not to be...
Yeah, you presume not to use them unless it's in the Commonwealth's interest to use them. But how would you know if it's in the Commonwealth's interest to use them if it's not defined? Where's the guidance on what that means?
So it might be, for example, if there was a cohort of claims that the Commonwealth was seeking to manage, and so you would want to phrase any confidentiality claim in a way that, while enabling a person to tell their story, didn't undermine the Commonwealth's approach to litigation. But you're right, Senator, I'm not aware of anywhere where that is articulated as an approach.
And to be clear, Senator, just on that example given, that confidentiality in that example where there was a larger cohort would be, for example, around the quantum but it wouldn't be around preventing the individuals from speaking to the experience.
Yes, I understand that. Yeah. Thank you. Just out of interest, if the Commonwealth's insurer Comcover steps in to resolve a workplace sexual harassment claim against the Commonwealth, would they need to seek final sign-off from your department as well?
If the matter was a significant issue, then to settle any matter as required under the Legal Services Directions, approval from the Attorney-General or his delegate would be required.
Okay. And thanks for giving me those figures going back those 10 years. Given that this direction was only given in June 2022 to essentially discourage the use of confidentiality except where you feel it's in the Commonwealth's interest, is there any appetite to go back to those previous survivors, those applicants, and ask them if they would like confidentiality provisions that might have been included at the time to be reconsidered? Is that on the table? I know you obviously can't revisit a settlement agreement, but you could ask whether the survivor would in fact like the confidentiality shroud to be lifted. Is that on the cards?
Senator, I think we would need to consider that. I think there might be a range of issues about approaching someone some period of time afterwards. I can see why you would suggest that for some people that would be an important thing to be able to tell their story, but for others it may be problematic. So I just think we wouldn't give an answer right now about that, but I think it's something that we can reflect on.
Okay. Well, thanks for taking that on notice. In those 14 matters that you mentioned, Mr. Ng, were there any new ones since the 5th of November when we last covered that estimates last time?
Thanks, Senator. The 14 records were the 14 settlement approvals were between the 4th of March 2014 and 13th of November 2024. There was one further one on the 19th of December 2024, where confidentiality was approved over specific aspects of the matter, but not in a manner that prevented the claimant from telling their story.
Okay, so over the quantum only or plus extra elements?
If it's all right, Senator, I'll take that one on notice on the specifics of that and to what extent we can answer that question.
And in that response, do you identify which departments those claims have been made against? Or if not, can you do that, please, for the 15?
We can take that on notice. Thanks, Senator.
Yeah, thank you, because I'd be interested if there's a particularly problematic department. Obviously, if so, then I'd want to know what your department is doing to encourage them to be less awful. Chair, I think that's all of my questions.
Great, thank you.
Thanks very much.
Senator Shoebridge, I'm going to hand you the call. Do you? Perhaps if you could give an indication of how much longer you might need. I'm mainly making these comments for our friends in the media who are watching.
Yeah,
you will take us to our next witness, which is ASIO.
All right. I don't know. It depends on the answers, but not an excessive amount of time. Is all I can say.
All right. Well,
I'll attempt to be as efficient as I can.
You have the call, Senator Shoebridge, and the Director General will be not too far away.
He can do a risk assessment as to how long he's going to be. Secretary, I was asking questions earlier about the PID Act reform. Is consideration of a whistleblower protection authority part of that PID Act reform, and if so, where's that up to?
Senator, I'll get my colleagues to assist. Certainly, throughout our consultations, it was something that was raised by various stakeholders and advocated for by various stakeholders, including Transparency International and others. So it's certainly something that we have looked at. And I'll ask Mr Newnham to lead off.
Senator, thanks for the question. And the answer is yes. The establishment of a Whistleblower Protection Authority is under consideration as part of Tranche 2, and whether indeed it is needed. I can say that we're engaging closely both with government but also potentially impacted bodies. I'd note that it was a feature of the consultation paper I mentioned earlier. I'd also note that we're well aware of the various private members' bills that have been introduced and calls from non-government organisations in the past. Senator, it's still under consideration, but what I would say is some of the considerations for government include, the impact on a new entity like that on the existing integrity landscape, whether or not there are alternative ways for the functions being sought for a standalone body to be achieved in other ways, whether there's potential duplication of a new entity with those existing integrity agencies. I'd also note, Senator, for example, there is no other Australian jurisdiction that has an authority. So these are all factors being worked through, but equally we acknowledge that the majority of submissions on the consultation paper did reference the need for an authority. So those issues continue to be worked through.
Well, I mean, you talk about duplication, but this is about, it's focused on the needs of whistleblowers. Has any whistleblower said in the course of the consultation, well, actually, no, I've got too many friends, too many well-resourced friends to come up against this, multi-billion-dollar government agency? Or has the question of duplication ever been raised by a whistleblower in the consultation?
Senator, I take that on notice, although I do recall, I have some recollection of the submissions to that process acknowledging this may in fact be an issue, but I will ask colleagues to confirm that. But I suppose what I would acknowledge, though, is there is a National Anti-Corruption Commission, there is an Ombudsman, there are obligations inside each agency. There are a number of integrity agencies that exist in that space, and whether or not some of the calls for a standalone new authority would mean that some of those roles for that body would cut across other bodies that already exist.
But not one of those agencies is there to help a whistleblower step through the process. Not one of those is there with a clear statutory function to try and even the balance between what can be multi-billion-dollar government agencies and individual whistleblowers who have often just been sacked. That's the purpose of a whistleblower authority, and none of the current integrity agencies come close to fulfilling that function, do they?
Well, Senator, I mean, I would reference here the obligations on various office holders inside agencies, including proactive obligations on them to assist with whistleblower matters. I'd also reference the role of the Commonwealth Ombudsman. Senator, I was really, I suppose, putting it in the landscape of a range of entities that currently exist and a range of responsibilities that exist inside agencies currently, which are factors when you weigh up the need for a standalone new body.
Well, I'd ask you to take on notice whether or not a single whistleblower said that they didn't need a whistleblower protection authority because it was already covered by any existing agency. To go to the other tranche 2 reforms, now the privacy reforms, Secretary, I'll put the question to you first, but seek what assistance you need. I'm assuming we're no closer to having a delivery date for tranche 2 of the privacy reforms.
Thanks, Senator. I think obviously there's been ongoing work, which I think Ms Fitch outlined earlier on. And I think, as I mentioned, it's clearly going to be a matter for the government in the future to determine specifically the timing of the next tranche of privacy reform.
Well, perhaps I'll put the key issues that stakeholders are approaching me about, and I don't think I'm alone in this, that they think are essential for the next tranche, and see if they're going to be included. One is to ensure that the reforms, at a minimum, deliver protections that are at least the level of the GDPR, which in many ways is sort of global minimum standards now for privacy. And as part of that, are they looking to ensure a fair and reasonable test is included in the definition of consent to mirror that EU definition of consent when people are asked to share their personal information?
So Senator, both of those issues have arisen in the course of consultation, but obviously ultimately it's a matter for government as to the final content of any future tranche of privacy legislation.
Well, what is the view? I mean, even large platforms are saying, putting their hand up to GDPR equivalents. There's all.
I think it's a slightly mixed experience for the different platforms. The bulk of
large platforms are putting their hands up to GDPR because they know what it is. They've got rules in place. And, for example, GDPR protections protected European citizens very recently from Meta scraping their Facebook accounts going back over a decade to feed their AI. We didn't have those protections, so all Australian Facebook accounts were scraped by AI and fed into fed into Meta's AI. The absence of those protections has a real impact on Australian citizens. Platforms are saying we'll have some of that. Why aren't we delivering it?
Senator Shoebridge, I think you've heard this from us before, but the second tranche of reforms is really going towards the recommendations from the Privacy Act review that were supported in principle. And what we are working through at the moment is developing those proposals into draft provisions, which is what the government commitment was. I think you've heard Ms Fitch and I give evidence before about the fact that the consultations that we've undertaken, which have been extensive, stakeholders have said to us that they're keen to see the detail of the provisions, and that's what we're working through. The point about fair and reasonable and the definition of consent, we have heard that directly also, and was a key feature, I think, in the Legal and Con Committee inquiry into the Tranche 1 bill. So I'd just say to you, we equally have heard that feedback from stakeholders, and it is part of that broader suite of reforms from the second tranche.
So just to try and wrap this up, what's the intended process for Tranche 2? Are we going to see green papers, white papers, further consultation, draft legislation? What's the next step?
So the commitment from government is targeted consultation on draft provisions in relation to that second tranche of reforms.
All right, so there'll be targeted consultation on draft provisions, which will then find its way into a bill, which will then go through the standard parliamentary process.
That'll then inform government decision-making on next steps.
All right, but not a further public broad consultation on it?
No, I think the government's trying to get the balance right between that consultation process and ensuring that there is movement on the second tranche.
All right, to try and run through the next things. I've got some questions on Hague Convention, some questions on anti-trafficking and anti-slavery commissioner, and the UN Working Group on Arbitrary Detention, just to know, which we can knock over in 5 minutes. In 2022, there were amendments to the Hague Convention abduction laws, allowing family violence and child welfare to be taken into consideration in those cases. But there was a recent, very distressing case about the return of a child to the Belgium/the Netherlands, where the mother had very real concerns about family violence and well-evidenced family violence. There were calls for the Attorney-General to intervene in that case, and the Attorney-General didn't. Has there been any review of either individual cases or whether or not those amendments are actually working?
Senator, that particular Hague Convention and the responsibility for that is in the National Security Criminal Justice Group. I can take that on notice and provide you with a response in the future.
Right. And in doing that, could you also in that case that I'm referring to, where there were calls for the AG to intervene, the mother has now been forced to return to Belgium, the Netherlands, where she has a well-founded fear of family and domestic violence. That was the case she was raising. Do you know if any support is being given by the Australian government to that mum?
I'll take that on notice.
Right. The Anti-Slavery Commissioner's budget, in the course of considering that legislation, pretty much every engaged stakeholder said the Anti-Slavery Commissioner's budget was woefully inadequate for the national role, and indeed it was significantly less than the New South Wales Anti-Slavery Commissioner. And as many witnesses pointed out, the Commonwealth is bigger than New South Wales. Is there an intention to, has the government made a decision to increase the budget for the Anti-Slavery Commissioner?
I'll ask my colleagues to assist.
Senator Frances Finney, Assistant Secretary, Modern Slavery and Human Trafficking Branch. At this point, the funding for the Commissioner has been set over the forward estimates for $2 million per year, and with the advice that government will keep that amount under review.
All right. Have there been calls from the Anti-Slavery Commissioner have there been a request from the Anti-Slavery Commissioner to increase the budget?
To the department?
Not that I'm aware of,
no.
Is that a live issue at the moment?
I would say, obviously, it's only been a couple of months since Mr Evans has been appointed to the role. He's had support from within the department around establishing the office that supports him. He's started pretty enthusiastically in the role, and we will work closely with him, as we do with all portfolio entities, to understand how he is undertaking his responsibilities and any challenges about that. But he hasn't raised anything specifically with me.
Can you provide on notice how many complaints or requests for assistance the Commissioner has received since commencing their duties?
We'll take that on notice.
And, you know, the sector have repeatedly raised concerns when it comes to people who have been held in slave-like conditions either here or overseas, that they're often incredibly marginalised. They have very real concerns about reaching out to authority figures, including police. And the hope of the sector is at some point the Anti-Slavery Commissioner will be funded to be at least a first point of contact. Is there any funding at the moment to allow the Anti-Slavery Commissioner to undertake that role, to be the first point of contact from people who have been hoping to escape or have escaped slave and slave-like conditions?
Senator, I'm sure you would appreciate that as an independent statutory officer, the Commissioner has discretion as to how to allocate the funding.
It's $2 million. If they allocated it to that work, it would disappear in the first month. They'd have to turn the lights off and stop feeding themselves. The $2 million obviously won't touch the sides of that.
Well, Senator, what I would say is, as others have already mentioned, these figures were determined through budget process, and we would consider them commensurate with the role and function set out in legislation. And to your exact question, part of the core functions of the Commissioner include engaging and supporting people with lived experience. It is the early days of the existence of the Commissioner, only the second jurisdiction to implement it. We are already in very close touch with the Commissioner, and as the role develops and we continue that close engagement in future, like any entity, we can review the budget as needed. But at this stage, we can certainly take on notice the complaints point you've raised. I and others are not aware at this point of concerns being raised similar to ones you've raised.
But at this stage, the forward budget for the Anti-Slavery Commissioner, it's projected to decrease in real terms over the course of the first 4 years. As inflation goes up, the nominal figure remains the same, so the budget actually is projected to decrease in real terms. Is that right?
Just to be clear, Senator, you're saying that whilst the figure stays constant, the worth of the Australian dollar diminishes over that period of time.
Yeah, it's the same nominal figure, but reduced real value over time because of the impacts of inflation. The real budget will actually decrease. That's the current projection. Is that right?
Can we take that on notice, Senator?
Right.
I think there's normally some form of indexation that's applied in relation to funding, but we'll take that on notice for you.
All right.
Senator, if I may just add to your question earlier about for people in or at risk of modern slavery and their reluctance to come forward because of fear of engaging with law enforcement or government. One of the other initiatives that has commenced is the additional referral pathway to the Support for Trafficked People program. It's administered under a different portfolio, Department of Social Services, but it does provide another pathway for people to come forward and seek assistance and support. I just thought I'd clarify that as well.
Okay, thank you. Moving on to the final point for this. I have one other point. The UN Working Group on Arbitrary Detention, it noted in its most recent annual report that they were intending to visit in March of this year. That's potentially a week away. Is that still happening? Will the UN Working Group on Arbitrary Detention be visiting Australia in March?
Thanks, Senator. Yes, I heard the question. No, the visit isn't occurring in March. We're working with the UN at the moment and the visit is scheduled for December.
Why is it not occurring in March?
We have just been working with the UN on dates that work for the special mandate holder and the dates that have been decided upon. Do we have dates in December?
Yeah, 1st to the 12th.
The 1st to the 12th of December.
And sorry, the invitation was extended for a visit in March of this year. Are you saying that the decision to move it to December was a decision of the UN Working Group on Arbitrary Detention, or was it a decision of Australian jurisdictions?
I think I'd have to take that on notice. It's been a collaborative process with the UN to work out dates, but I would need to take on notice the detail.
Have states and territories been involved in that process?
We're still working with the UN on a program for the visit, so we certainly will engage with jurisdictions ahead of the visit and with the UN to finalise a program.
Well, I mean, last time the working group visited, they were left standing outside a set of locked doors at a prison in Queanbeyan, just a short here because the New South Wales government refused to cooperate. Last time they visited, they couldn't get access to mental health wards in Queensland, and again were refused access. And are we going to have a repeat of that history?
So that was a visit of the SPT. So it's a different different part of the UN that is visiting. We will engage with the jurisdictions ahead of a visit to finalise a program.
Well, last time the UN came here to look at issues about detention, they were refused access to New South Wales jails, and they were refused access, the UN was refused access to Queensland mental health facilities. Have we learned from that to ensure that states and territories are going to give full and unfettered access to this UN working group?
We have learnt from that last visit. We do continue to engage with the jurisdictions on issues in relation to OPCAT. Queensland has since amended its legislation to enable the SPT to visit. There was a particular issue with the Queensland legislation during the SPT's visit last time, legislation has now been amended to address that, and we will work with all the jurisdictions ahead of a visit to facilitate the UN's program.
So are you saying you have a commitment from all the states and territories that they will give free and unfettered access to the UN Working Group on Arbitrary Detention to places of detention in Australia?
No, I was saying that we will work with the jurisdictions on the program with the UN as we develop it.
Will the program include access to aged care facilities where there are concerns about arbitrary detention?
We don't have details of a program with the UN yet. We will work with them on it.
Secretary, my final question is in relation to requests that came from undercover police for assistance by the Attorney-General, given the failings that they say have happened with the AFP to provide them with new identities. There was a request directed to the Attorney-General, both from the committee that my colleague Senator Polly chairs, as well as from the Australian Federal Police Union, as well as from the individuals themselves. Has the Attorney responded to that request, to any of those requests?
Senator, I think it relates to the same line of questioning from Senator Van just a little bit earlier. He's tabled today the correspondence. I've taken on notice in terms of what steps have been taken in relation to that correspondence.
Well, I think Senator Van has tabled a subset of the correspondence. There was correspondence also directed from the committee that Senator Polly chairs, that I'm a member of, to the Attorney-General, seeking a response from the Attorney-General to the very real concerns, which I won't go into in detail here because they were provided to us in confidential sessions in that committee, but seeking a response to very real concerns that were raised with that committee. Has the Attorney responded to that correspondence that came from the Law Enforcement Oversight Committee?
I'd need to take that on notice, Senator.
Well, the reason I think probably I can't speak for Senator Van, but the reason that I'm asking this is because no undercover police operative would ever volunteer to have to take an entire new identity, to pick up their families, relocate themselves potentially to another country, lose all of their connections, which is what these 4 experienced undercover officers are doing. Nobody would do that voluntarily, and nobody would do that unless they had a genuine and real sense of fear for themselves and their families. And that's all these undercover police officers are asking for. They're not asking for a whack of compensation. They just want themselves and their families protected. And I suppose I can't understand the resistance in the AFP from helping them with this, and I can't understand why the AG hasn't intervened. Is there any explanation?
I'll have to take that on notice, Senator.
Thanks, Chair.
Is that all the questions you have, Senator Shoebridge?
All the questions of the department, yes.
Great, thank you. That's all the questions we have for the department. Ms Jones, were you going to add something there?
I was just going to give the figure that Senator Shoebridge had requested in relation to the McBride matter. The combined Commonwealth external legal costs as at 10 February are $2,676,820.
And sorry, Secretary, is that for the trial and the appeal or just the appeal?
I think that's the trial and the appeal. Yes, it is the trial and the appeal.
And I know this is pushing a friendship, but do you have a breakdown for the appeal costs? Do you have a separate figure for the appeal costs? Maybe Ms Chichi has it?
No, I'm advised we're unable to split the different parts of the proceedings, so we don't have that breakdown.
Right, but $2,676,820 as at the 10th of February, is that right?
Just double check that.
Minister, that's a lot of money to keep a whistleblower in jail, isn't it?
Well, you know, the legal system is an expensive system, Senator.
Particularly when it's delivering unjust outcomes. It tends to be more expensive, doesn't it?
Well, justice is sometimes in the eye of the beholder, Senator Shoebridge.
Perhaps.
Thank you, Senator Shoebridge. That's all the questions we have for the department today. Thank you very much to all the officials. I'm going to call officers from the Australian Security Intelligence Organisation, but I'll just suspend the broadcast briefly to allow changeover of witnesses at the table. Thank you. Hearing. Thank you very much. And I now welcome officers from the Australian Security Intelligence Organisation. Director General, welcome. Would you like to make an opening statement before we go to questions?
Thank you, Chair.
Thank you.
Seeing as I delivered my annual threat assessment just last week, I'll keep my remarks short. Understandably, much of the initial media focused on ASIO's assessment that the security environment is becoming more dynamic, diverse and degraded. However, it's important to note ASIO is well practiced and well placed to respond to emerging threats. Our powers are significant, our capabilities are exceptional, our resolve is resolute, and our people are brilliant. Security is a shared responsibility, and while your security services got this, national security truly is everybody's business. Finally, on staffing matters, since our last hearing, one of my brilliant deputies, Hazel Bennett, has retired. I'd like to acknowledge her significant contribution to national security and thank Hazel for her service. I'm pleased Lisa Alonso-Love has joined ASIO as the Deputy Director General for Enterprise Service Delivery. Lisa's joined me here today with Gus Gilmore, Deputy Director General, Vetting Services Delivery. Thank you. We look forward to your questions.
Thank you very much. Director General, I believe we're starting with Senator Patterson. Thank you.
Thank you, Chair. And let me place on the public record the opposition's appreciation for Ms Bennett's long service in the national interest and to national security. I had many dealings with her over the years in my capacity on the Intelligence Committee, and she's a dedicated public servant who's done great work, not all of which will be always publicly known. So it should, that appreciation should be formally recorded. Director General, how concerned would you be, or how concerned would ASIO be, if you learned that Australians were travelling overseas to participate in an event organised by a listed terrorist organisation?
I would be concerned. I would want to understand the specifics of that travel. In some cases, I recognise the individuals may not know the event is organised by a listed terror organisation, but I'd want to understand that and understood what they knew, what the event was about. I'd need the details.
If there was, absolutely no doubt in their mind from the very nature of the event that it was organised by a listed terrorist organisation, would that increase your concern?
Again, I would be interested in, if not hypothetical, and I'm sure you're going somewhere with that, Senator, I'd still want to understand what the event was and what they thought they were doing. Obviously, I'd also want to make sure if individuals knew they were going to an event organised by a listed terror organisation, they actually were helped to understand, did they know it was a listed terrorist organisation? Do they know that it's unlawful to engage with such groups? So again, I'd want to understand the details.
In your experience with counter-terrorism issues, what are the tools available to the Australian government to either prevent people from travelling to associate with a terrorist organisation, or to protect Australians from that?
Well, there are many tools available to the Australian government. I will focus on ASIO's contribution to those tools. We do have the ability to do security assessments, which would result in seeking the request for an individual's passport to be temporarily cancelled so they could not travel. Obviously, we'd have to have security grounds for that. The fact that an organisation is listed is sending a message to society that's a listed terrorist organisation, and actually there are criminal penalties for engaging with or being a member of such group. You'd have to talk to others about the specifics of that as a security service. I'd be, regardless of whether it's listed or not, if they were going to an event where there were violent extremists or known terrorists, we would be interested as Australia's security service.
And so, as you say, on your recommendation, a passport can be cancelled to prevent someone from departing, and obviously it's ABF that exercises that at the border?
Well, yes, it's a foreign minister authority, and obviously the passport's cancelled. It can be a silent cancellation, and then the individual would discover at the border they can't travel because the Border Force would stop them, or it can be a public cancellation, so the individual knows their passports were cancelled. That depends on the specific circumstances, which one of those it is.
And at the other end of the event, if someone is seeking to return to Australia, the Minister for Home Affairs has powers to temporarily exclude them, don't they?
Well, again, I'm not the expert on the details. There are Australians will have a right to return, but there is temporary exclusion orders that can be applied in some circumstances that would control that return in a manner which was enabled the issue to be managed effectively by authorities, including ASIO.
From my memory, it was in 2019 that the temporary exclusion orders power was introduced, and it allows I think on the basis of a security assessment for a terrorism risk, presumably on ASIO advice, for the Minister for Home Affairs to make an application that someone should be excluded temporarily from Australia.
It wouldn't just be on ASIO's advice. It might be the police have a brief of evidence and there's grounds for something to happen.
Yep. And then obviously the law enforcement component is not ASIO's responsibility, but associating with a terrorist organisation is a crime and someone could be prosecuted for that.
Correct.
And if they are a non-citizen, their association with a terrorist organisation, if they're a visa holder, their visa could be cancelled on the basis of ASIO advice if a qualified or adverse security assessment is furnished.
Correct.
And so ordinarily in the course of events, if ASIO became aware, you would look into a visa holder and provide advice to government, provide that qualified or adverse security assessment to government, and then it's government's responsibility to act.
Correct. The adverse security assessment would be given to the Minister for Home Affairs.
Yep. Okay. Thank you. That's sufficient on that matter for now. I might move on to some other matters. In particular, on your threat assessment speech last week, and I know there's been a lot of attention in the media about your observation in the speech that the anti-Semitism has not yet plateaued in Australia. I saw also a media interview that you conducted with Kieran Gilbert on Sky News afterwards where you expanded on that and said that you don't know whether it's plateaued, you don't know whether it's peaked, you don't know where it's bottomed out. What's the basis of that observation that you think it has not yet plateaued?
So I've said at my threat assessment, I'm concerned it's not yet plateaued. That's not to say it hasn't yet plateaued. I'm just concerned why have I said that. Well, let's go back to the 7th of October 2023. Literally within a couple of days, we saw that terrorist attack generate a whole lot of emotions, which did result in anti-Semitism rearing its ugly head early. Of course, I also said in my remarks, anti-Semitism festered in this country long before the 7th of October 2023. And of course, I've also said that we've seen a transition from harassment and intimidation through to physical targeting of communities, places of worship and prominent Jewish Australians. And we've been dealing with a number of serious anti-Semitic incidents since October last year in particular. That's my agency has been, along in partnership with the police. And that is very concerning, and we're working hard with our police colleagues to get to the bottom of this, given the environment we're in. You know that we've also previously said that when we raised the national terrorism threat level in August last year, that we have seen an increase in politically motivated violence and behaviours have been normalised, and that encourages other people to do similar, if not worse things. The trajectory was such that we've seen this increase. It's alarming, and I'm concerned it's not yet plateaued. Doesn't mean to say it's still on the increase.
Yeah. So you certainly don't have any intelligence that suggests that it's about to decline?
Good question. No, but I'm not sure I would get the intelligence, because our intelligence would be generally an indication that there are problems that we and the police have to deal with. What I can say in terms of observation, there is no doubt that a strong law enforcement response, and both state and territory and the federal police have done exceptionally well, in my view, in this space, actually does drive a signal into society that this behaviour is unaccepted. And there's always a lag between events and response, of course, but this may well be helping, and I'm hoping it is. But of course, we keep an open mind, and when we see potential threats, we will act.
This is probably not for you to comment, but I would observe quite a delay between events and action. It's certainly welcome that New South Wales Police, for example, have made I think over 100 arrests now in Sydney in relation to this, but that's 15 months on from when this started. You said earlier that in your observation that this activity became normalised. How and why do you think it became normalised?
Well, firstly, if I can just give you a perspective on the delay.
Please.
Again, I'm on the public record both for the police and for my agency. I'm not suggesting you're not doing this, Senator, but let us do our job. Sometimes these investigations do take time, and it's not because we're sitting back admiring the problem, but actually getting a grip of the problem actually sometimes does take time and requires some capabilities to be put in place that allows us and the police to do their job. In terms of the issue about why the behaviours have been normalised, well, that's a difficult question to ask. There are many causes, except for anti-Semitism festered in this country before the 7th of October 23. and we saw it raise its ugly head, and we've seen a number of worrying things that were threatening and intimidating. And when that goes left unchecked in society, that may well create an environment where it gives violence more permission. I've said that in my national terrorism threat level raising, so that's definitely a factor. There's also something that I'm on the public record talking about. Again, for me, it defies logic that people can hold Jewish Australians to account for the actions of the Israeli state. It beggars belief, but that's what they're doing. It beggars belief that they hold state and territory and federal government to account for the actions of another sovereign nation. But some people have those views, and they have very strong views. That might drive a small number of those to think that violence is acceptable, especially if you've got this deep-seated view that you're anti-Semitic. And the environment and the conditions has given anti-Semites an excuse to go into the open in ways which we all agree are unacceptable.
What's your assessment about the increase in the level of anti-Semitism that you're seeing compared to other forms of hatred? Is it a significant, disproportionate increase of anti-Semitism compared to other forms?
Well, right now, in terms of my organisation, our threats are faced threats to life, threats to way of life. In terms of threats to life, it's my agency's #1 priority because of the weight of incidents we're seeing play out in this country.
Wow. When would you have ever said before that a form of racism was the #1 concern for ASIO?
I don't believe we've done that in our history, certainly not in my 6 years as Director General.
Right. And that is just because of the volume of incidents or referrals or intelligence that you're seeing?
It's the volume of incidents that we are dealing with. Of course, the terrorism threat level still remains probable, and in the environment you could still have an act of terror done through some other ideology, whether it's religiously motivated or ideologically motivated. That's still a possibility, but anti-Semitism and significant anti-Semitism acts are prominent in our investigation caseload at this point in time.
Yeah, thank you. In that interview with Kieran Gilbert on Sky News, you were talking broadly about a range of incidents targeting the Jewish community, and you said, and I quote, "We don't believe there's one mastermind behind all of this. I'm not expecting one foreign mastermind behind this. We have to consider, and it's highly likely and in fact true, this is homegrown." Could you just expand on that?
Well, I have seen some speculating that this is all driven offshore by a foreign regime or some criminal. No, I don't believe that's the case given what we have before us. Yes, of the number of incidents we're looking at, a couple of them might be connected because they're the same individuals that did the arson on the car, but actually they're not all connected, and all I'm saying is there's not just one plot that's coordinated across the board. Very much believe, because of the environment we've described on the public record, sometimes as it heats up, this generates its own weather and there is copycat actions.
Yeah.
So not connected in that sense.
So you don't have any intelligence that suggests that a foreign government is sponsoring or coordinating these attacks?
I obviously can't talk about what intelligence I might have in a public forum, but I'll stand by my point. I don't believe there's one foreign actor driving all anti-Semitism in this country, and not all the incidents are connected is my public remarks on this matter.
And therefore, you'll be equally limited, but let me ask it for completeness, no intelligence that a foreign terrorist organisation is coordinating or sponsoring these attacks?
I've been on the public record saying that we've got no evidence of that in terms of known incidents that we've investigated that are either an act of terror or we investigated them as an act in preparation of terror, or were they an act of preparation of terror. No foreign terrorist organisations directing such things. Of course, we keep an open mind and we're exploring three lenses here, that there is foreign interference in some of these incidents, as in they're directed offshore by a foreign regime. It is politically motivated violence, or it's promotion of communal violence, and all three of those heads of security are open lines of inquiry on a number of these incidents.
Thank you. The Popular Front for the Liberation of Palestine, do you consider that to be a terrorist organisation?
I would have to take that on notice. I don't have the list of terrorist organisations.
Let me help you. It's not listed as a terrorist organisation under the criminal code in Australia, but it has been sanctioned under the UN financial sanctions framework by the Foreign Minister for over 20 years, and it is sanctioned by it is prescribed by our closest intelligence partners, including the US, Canada and the EU.
Sure, I'll still take that on notice. Some countries prescribe them because they have different laws that allows them to do things that we can't do under our legislation, so I will take that on notice.
There was a flag displayed of the PFLP at a Melbourne rally a number of weeks ago. Is it a concern to you that an organisation listed by our partners as a terrorist organisation has at least one person who thinks it's a good idea to fly their flag at a public event?
Again, it may be of concern, but actually as a matter of law, if it's a listed terrorist organisation, therefore that it would be a problem. But again, I can't really speculate on that until I know the answer to your previous question.
Do you think it's possible that the person displaying that flag did so on the basis that they believed it was not unlawful, given that they're not a listed terrorist organisation? I think it's now clear to people you can't fly a Hezbollah or a Hamas flag. We haven't seen that for a while, but they're now flying this flag instead.
Sure. Yes, that might be one possibility. It might be they know what it is and actually they know what they're doing, or they're just naive and ignorant.
Yes, that's possible. In fact, quite likely, I would suggest. Would it put it beyond doubt that this organisation should not be supported or associated with by listing it under the criminal code?
Again, I'd need to look at the details as we would see it as Australia's security service before I can pass a comment on that.
Fair enough. Moving on to a related question, Hizb ut-Tahrir, as I think we might have discussed before, has been listed for the first time by our UK partners in January 2024, and our Canadian colleagues have now said that they are publicly considering said that they're considering doing so. The Canadian minister made the Minister of Public Safety, Rachel Bendian, said, Hizb ut-Tahrir is a documented history of glorifying violence and promoting anti-Semitism and extremist ideology. Its celebration of attacks on innocent civilians, including October 7th, and its support for banned terrorist groups such as Hamas and Hezbollah are entirely contrary to Canadian values. Do you hold any concerns about the activities of Hizb ut-Tahrir in Australia?
So obviously they're not listed in Australia.
Yep.
And my only comment would be I believe they do not meet the threshold for that.
Yep. But do you think
that's from ASIO's point of view? Are they advocating acts of terrorism? No. Do they have awful views, as my personal view and professional view? Yes.
Is it of concern, the kind of incitement and advocacy that they engage in?
Well, if they're advocating acts of terror, then they would be framed to be listed, but I don't believe they are here in Australia.
They do certainly engage in vilification, particularly of the Jewish community, but not only the Jewish community. And there is a risk that those incite others to commit acts of violence against them, isn't there?
I would acknowledge what they stand for would be a problem for some of us in society, including myself.
Okay.
Patterson, I'll have to share the call in a moment. I'm trying to give you
That's a good segue. I have a couple of other questions, but it's moving on to a different topic.
Okay, thank you. Senator Shoebridge, I assume you have questions?
I do. Thanks, Chair. And thanks, Director General, for your attendance. How concerned would you be if people, including elected representatives from Australia, travelled to an overseas political forum where a keynote speaker performed a Nazi salute on stage during their keynote speak? How concerned would you be about that circumstance?
Again, it depends on the nature of what the event was. I could recognise people could go to a venue and that could be a surprise and they find that damn right offensive. But then they're not, being there, they're entitled to be there. If it was a Nazi rally, I'd be really concerned. If it was just a rally about something in general and someone surprised the audience, then I wouldn't be concerned. I might be concerned about the individual doing it, but that's a different matter.
Well, indeed, we'd be concerned about the individual doing it, but surely you would expect Australian politicians, if they're at such an event, to distance themselves from it and perhaps express their outrage that somebody performed a Nazi salute at a political event they're at. That I think we would expect from our political leaders, wouldn't we?
Well, you're asking me to comment on what our political leaders should do, and I'm required by law to stay out of the politics, so I'll leave that to others.
Well, you're asked by my colleagues about your concerns. Would you be concerned if people didn't seek to distance themselves from somebody who gave a Nazi salute as a keynote speaker and then just came back to Australia and perhaps advocated for policies that keynote speaker had been addressing, having associated it with a Nazi salute.
I would be concerned if someone was siding with neo-Nazis and pushing that propaganda in this country. Beyond that, I have to let people make their own decisions. If it's lawful to be there, and some of the things might be awful but lawful in this country, I can't make any comment or have any investigation into that matter.
Well, the Nazi salute is unlawful in this country, thankfully. It's lawful in the jurisdiction where it happened. But that's another reason, isn't it? You would expect political leaders to call it out and say it's wrong, wouldn't you?
Again, you're asking me to comment on what politicians and political leaders do, and I can't do that.
Or any community leader.
Out of politics.
Any community leader should distance themselves from somebody who did a Nazi salute on stage as part of a political forum. I mean, surely that's what we've got a scourge of anti-Semitism. Surely calling out and distancing yourself from speakers that at events you're attending where they do Nazi salutes is the minimum we should expect.
Senator, with respect, I would distance myself from someone doing a Nazi salute, absolutely, but I can't comment on anyone else because I understand that's how the media would construe my comments.
All right. Well, we're talking about dealing with Nazis and the far-right extremists. What consideration has been given to the listing of the National Socialist Network, particularly given some of the offensive, deeply, appallingly offensive things they've done, not as recently as on the 26th of January, engaging in racist intimidation in the community?
Yeah, certainly first point I should make is ASIO does not need a group to be listed for us to investigate it. I know you understand that, Senator, but that's an important point to be made. We pay very close attention to the Nationalist Socialist Network. My current view would be that they're not doing things that would actually meet the threshold for them being listed. They do not advocate acts of terror. Their principal driver in this country at the moment is to build their brand and recruit more people. And unfortunately, every time there's media around this incident, they get successful in recruiting people. So I'd have to be careful on what else I might say.
Well, they're not careful in what they say. And
correct.
And the head of that nasty, vicious network, speaking about the potential for child protection authorities to potentially intervene if there were child protection issues that cut across any member of the network. He said this: I've made it very clear to ASIO and I made it very clear to the general public that that's when I become a terrorist. That's when I'm going to start killing people. That's just a fact. That's not a threat. Doesn't that meet the threshold for listing? You've got someone here openly stating that they're contemplating becoming a terrorist.
So I'm aware of those comments. ASIO is not law enforcement, but the context, as awful as those comments are, yeah, in that moment, that's what he's saying as the red mist descended. You'll have to ask others whether that meets the threshold for listing.
Well, I'm asking you. Surely that meets the threshold for listing. You've got a leader of a. I'll be clear. My view is I think it's a vile network of race-based hate. Openly stating that there are circumstances where it become a terrorist and start killing people, and apparently they've told you this. Is it true they told you this?
I'm not going to comment on what they've told us. I'm with you. They're a vile group, but I'm not the person who can make the final call of whether they should be listed or not, and I don't need them to be listed because I can assure this committee that ASIO is fully focused on this group and has been for some stage, and our whole purpose there is to understand and identify people who will pull away from the moderation that group applies and actually spins off to conduct violence. In my threat assessment last week, I said that it's the people on the periphery of this group that represent the greatest terrorist threat to this country, one of the greatest terrorist threats to this country at this point in time.
Well, but this group is using social media, right, to crowdfund to obtain resources to continue their vile political activities, and they're referencing, I think, search warrants and actions taken by ASIO that seize some of their equipment as a reason why they're encouraging crowdfunding. They're kind of laughing at us.
Senator Shoebridge, even though your preamble is different, your question is the same, and the Director General has answered it.
Well, I disagree. Chair, they are using the actions of ASIO to actively promote themselves by crowdfunding.
So I don't understand the bit about using the actions of ASIO.
Well, they're saying because ASIO sees some of their equipment, they're using that as a cause, that's what they're saying, a cause celeb to go out there on social media to spread their hate and crowdfund. Is there nothing that can be done to constrain them in this space?
Again, I'm not trying to be unhelpful, Senator. From my perspective, that's not my area of expertise. We're a security intelligence service, and I can assure you're on them. Like you, I'd welcome this group not existing in this country.
Well, one way would be to list them as a terrorist organisation, given one of their heads is openly making threats, potential threats of becoming a terrorist. That I would have thought would tick the box.
Well, and then that's a matter for government and parliament to decide how that law changes to allow that to happen.
You're saying under the current laws, they
My
don't
understanding
meet the
is under
test?
the current laws it can't happen, but of course that's not me for say to speak on, and there are other people who actually would be best placed to answer that.
All right. To go to another matter, there was a decision released last week involving an action that ASIO took to remove the security clearance of an ADF officer who was referred to as HWMW. You'd be familiar with that decision?
I'm familiar with the press reporting, and yes, I'm familiar with the decision because there are elements that are public from the tribunal.
Well, there's a 120 paragraph decision that's been released with large amounts of what ASIO said on the public record. So I'm going to restrict my comments to what's on the public record from the submissions made by ASIO. First of all, was the outcome of that decision to uphold a determination by ASIO to remove the security clearance for the officer? That was the outcome?
The ART upheld our decision.
And what security clearance did they have? I think it's referenced here as a negative vetting 2 clearance, and having held that since 2010. What does a negative vetting 2 clearance entitle people to
In plain
access
language,
to?
it's top secret access, not the highest level of top secret, but it is a level of top secret access.
All right. So that's what classes of information are we talking about?
Highly, by its very nature, highly classified intelligence.
All right. When was the security clearance taken off HWMW?
I don't know if my colleague knows that, otherwise we'd take that question on notice.
If we're prepared to talk about the Gus Gilmore, Deputy Director, Vetting Service Delivery, we wouldn't normally comment on an individual case. The ART decision does record many of those details.
Yeah. Well, they say that on the 8th of April 2021, for example, the applicant completed a written security assessment questionnaire. On the 24th of March 2022, ASIO conducted another assessment interview. 26th of April, the applicant provided additional information. Did the applicant have access did they have the security clearance throughout that process, or was it taken off at an earlier point?
Senator, without speaking about the specifics of this individual, an assessment will involve interviews with the individual at various points, and that's really important for procedural fairness so that an individual has the opportunity to respond and to then inform the assessment. The assessment will be informed by many other inputs as well, but ultimately a judgment will be made whether the individual has an overriding loyalty to Australia, enabling access to our highest level of secrets in the country.
Well, I'm reading now from the Statement of Reasons, and it says that the then Acting Director General issued the adverse security assessment on the 2nd of June 2023. Was that when the security clearance was removed?
It wouldn't, not immediately. And to answer your question, Senator, and I don't know the specifics in this case, but I will take the question on notice. Sometimes it can be that someone is stood down while a review for cause happens, and that includes security assessment. Other times there is something that comes to our hand or someone else's, and we conduct our investigation, which then causes a review, or it's a clearance revalidation time. And during those times, the individuals maintain a clearance.
Senator Shoebridge, just one more minute, and I've got to share the call.
Well, that's what I'm trying to understand in this case, because there were multiple warning bells going off, according to the submissions that ASIO made. And I'm asking, did this individual retain their top secret clearance up until the 2nd of June 2023, notwithstanding the repeated warning bells that went off in interview after interview?
Again, I'm not trying to be unhelpful. We'll take that question on notice and see if we can answer it for you.
Thanks, Director General. Thanks, Senator Shoebridge. Senator Van, you have the call.
Thank you, Chair, and Director General Burgess, thank you very much for appearing and for your annual threat assessment, the speech given last week or recently. As always, it's a very sobering account of what we don't get to see in public very often. I was particularly taken that I think it's the first time, if my memory serves me right, that anti-Semitism featured in your threat assessment. Is that correct?
That's correct.
Thank you. At least in your speech, you say threats are intersecting, boundaries are blurring. Am I right to understand that there is a blurring of religious, political and ideological motivations behind violence we're seeing?
I did say that. When I said that, I wasn't referring to anti-Semitism. That's a specific type of hatred that has festered in our country. What we are seeing, though, particularly in the minors cohort, where people are, but it's not just children, who are picking elements of belief systems and combining them. For youngsters, that typically means, though, they're not really in the ideology, they're caught up in the violence of it. For others, adults, it defies logic that someone can be both neo-Nazi and have some, Al-Qaeda. It just defies logic, but it is what it is, and it's what we're seeing in our society right now.
Thank you. But wouldn't you agree that the anti-Semitism that you noted is in some way joining up of religious, political and ideological factors?
Oh, I'm sure there's a combination. I think it's important to know that to be a Jew is to be part of a culture. It's not just a religion. Some people are Jews and not practicing in the Jewish religion, so there is a broader thing there. Some people who are anti-Semitic are there for a wide range of reasons, not one specific one. It's not just a religious thing for some people. It's an ideological driven thing. You've got neo-Nazis and Islamists and a whole range of other people in between that are actually anti-Semitic.
Thank you for that. You also say in your speech, Jewish Australians were also increasingly conflated with the state of Israel, leading to an increase in anti-Semitic incidents. Director, I think this is a very important observation. The deliberate conflation of Israel and Zionism to target or have an issue with our Jewish Australians. It's being used as an excuse, isn't it, to intimidate and attack those Australian Jews, their schools, their temples, even their childcare centres?
It's a mistake, in my view, to conflate the state of Israel with a Jewish Australian. Of course, the reason why people undertake anti-Semitic acts could be because they're not liking what the Israeli government's doing and prosecuting the Hamas terrorist organisation, or it could just be they're anti-Semitic and they don't like Jews and it's got nothing to do with the state of Israel. So it is broad and complex. What's not acceptable is the hatred that is shown to that element of society and actually how that's playing out in our country right now.
Is there, in your mind, any way to break that nexus or things that your agency can do to either define one or the other, or find some way to break that conflation?
I wish I had the answer to that, and I think that's something that we all Australians need to press into and understand. Why is this happening, and what we could all do about it, or at least do our part to do something about it.
Because, as you say, said in your speech, terrorism is a subset of politically motivated violence, covers acts or threats intended to advance a political, religious or ideological cause through intimidation. And we've seen a lot of that, certainly, as you mentioned before, from the very early days post the October 7 massacre. Is it your opinion that actors, and I won't use a term any more descriptive than that, with an underlying political ideology, are using geopolitics as a cover, an excuse to undertake acts to destroy our social cohesion and that cohesion between one group of Australians, Jews and other parts of the population?
I think what's happened, or the 7th of October and everything else that follows, has given some anti-Semites an excuse, but not all of them. It's far more complicated than that.
Thank you. I'll leave it there, Chair. Thank you.
Thank you. Senator Rennick, I believe you have one question.
Thanks, Chair. I'm not sure if I should ask you or the AFP. Are you involved with the caravan?
Well, we're Australia's security service, so we are involved in investigation and supporting the police, both AFP and New South Wales Police, but I can't talk about incidents that we're investigating.
Oh, okay.
So it depends on your question.
Well, I guess the way it was reported in the press is that it was almost like a foregone conclusion from the get-go, even though subsequently, a few weeks later, it was reported as the explosives were been there for a couple of decades, no detonators, and they didn't seem to think that it was a deliberate, or it didn't appear to be necessarily as bad as what it was first portrayed. I guess, because we often talk about the terror groups themselves, but it seems to me that the media should also have a little bit of the microscope applied to it as well, because they're very good at the moment of whipping up fear or hatred between groups, in my view, because I felt that reporting didn't add to anything at all, and if anything, it seemed exaggerated. Is that a fair comment to make? Have you got a comment to make on that?
You asked me to comment on the media. They have a great responsibility to comment appropriately. They're there to tell the story as they see it, but obviously they have a responsibility beyond that. I won't comment on the specific incident at this stage.
Yeah, sure. Something similar, there was an example a couple of weeks ago where the media tried to bait the owner of a cafe into making a sort of a statement that could, be interpreted as being, racist or prejudiced. Do you have any, that's another example, I guess, where the media, in my view, was stirring trouble. Do you think, no, but it's not your role, so it's not your role. But do you think that the media might need to tone it down?
Well, in that case, if those facts are correct, then that is just mind-blowingly stupid, is it not, and inappropriate that you would do something to generate a headline?
Yeah. Okay.
Entirely unhelpful, and think about the poor person on the receiving end of that.
Yeah. Okay, cheers. Thanks.
Thank you, Senator Rennick. Senator Patterson, noting we're going to an earlier break, you have the call, and hopefully you can get through.
I'll see if I can get through my last two items quickly.
Yep.
Director General, I noticed there was some reporting recently about a purported trip you took to China to meet with your Chinese counterpart. I'm going to anticipate you probably don't want to confirm whether that did in fact happen or not in this forum. But is it, regardless of whether it happened or not, is it a concern at all that it's been reported on publicly for you?
Well, let me focus on the hypothetically. ASIO has relationships with many organisations overseas in 124 countries. Not all of those relationships are equal, but they're incredibly important because those relationships allow us to get intelligence that can protect Australians and Australia's interest wherever we may be or those interests lie. But of course, not all those are equal, and some of those are actually with organisations that may also represent threats to our country. But occasionally we do have threat intelligence that shares that's in our mutual interest, and other times it's because it's important to have that serious conversation even with someone who's a problem, and it's important to have those conversations done in private service to service, so that intelligence back channel is incredibly important. Beyond that, I don't comment on publicly what I do in that regards. Sure, I could say I've been to New Zealand and talked to a counterpart, but would I tell you what I've discussed? No, I wouldn't. So I don't talk about that publicly.
If you had taken a trip like this to meet with a counterpart, would that necessarily be classified, the fact that you'd done so?
Good question. Would it necessarily be classified? Perhaps not, but it depends on the country and the nature of the relationship and actually what you're trying to work through. So again, hypothetically, I might find myself in a conversation with an agency that's actually critical to the outcomes of our country's security interest and the security of individuals that I'm talking about.
It would certainly be sensitive, non-public information though, wouldn't it?
I definitely would call it, it's private, best not shared in public for the protection of the interest we're trying to pursue at that point in time.
The media coverage about this purported trip described the sources of this information as quote unquote political sources on multiple occasions. If it was true that political sources were providing information about your international travel and engagement with partner organisations, would that be of concern to you?
Well, again, I'm not confirming whether I visited that country or not, but if there was such a case and a journalist was saying their sources was X, a good journalist would never say their source was X. I'd be keen to know who their source was, absolutely. I have a problem with sensitive or classified information being leaked to journalists, and I would take that matter seriously and actually have the ability to investigate such matters myself or refer such matters to the Federal Police. So when I see leaks like that, especially those that allegedly impede on ASIO's business, we're quite a capable organisation with capable laws, and it could be a problem. It may not be, though, depending on the circumstances of that.
So is there an investigation into this leak?
Well, you're asking me to confirm whether there was a leak or not, and I won't do that.
Fair enough. Thought I would try. One final matter from me. In questioning to the Department of Home Affairs yesterday, they disclosed that you had briefed the Minister for Home Affairs about mitigations that he should take while driving his Chinese-made electric vehicle. Is that correct?
Minister for Home Affairs and I had a conversation about his car, yes.
And can you disclose what the mitigation advice is for driving a Chinese EV if you're the Minister for Home Affairs?
Oh, I think you appreciate... I don't really want to talk about what advice I give, but let me give the generic sense. Regardless of the manufacturer of the car or the country of origin, let's bring it back to if you're talking classified, I shouldn't be talking in front of this microphone or this device. There are appropriate secure locations to go have that conversation. If they're sensitive conversations, well then you can take a risk-managed exercise, but be wary of everything you say may be recorded. And when it comes to electronic vehicle, it means everything you say may be recorded. It also means, which is not just for Chinese cars, by the way, actually your CarPlay or Android Connect, whatever it's called in Android cars, everyone you've called, everyone you've messaged, it's all in there in the memory and would be open to someone else who had access to that computer in the car. So just exercise caution and be aware of that and mindful of that.
That's certainly true, but as a country we've recognised that some vendors pose a higher risk than others because of their country of origin and their relationship with foreign governments. You were involved in decisions to, for example, exclude Huawei from our 5G network because of its relationship with a foreign government, because it was subject to the laws of that government. So we do recognise that there's different classes of risk based on country of origin, don't we?
Yes, we do, but then there's also different classes of technology. So the 5G example you gave, that was because 5G will be at the top of the critical infrastructure list because everything will be connected. And actually, if the connecting fabric wasn't there, that would impact society greatly.
But the government's also banned TikTok from government devices and DeepSeek from government devices, in part because of their relationship with a particular foreign government, haven't they?
It's true they have been banned from government devices, yes.
So the Home Affairs said that advised the Minister not to plug his official device into the car, not to connect it, but they didn't have advice about whether his personal phone should be connected to the Chinese-made EV that he drives. Do you have any views on whether it's a good idea to connect your personal device to a vehicle like that?
My best advice to anyone would be, it depends on what's on your personal device. If you're entirely comfortable with that and you've got no sensitive information or secrets, and I don't mean classified secrets, I mean things that are deeply private to you, but that's a risk management decision that people will make.
Just finally on this, are foreign intelligence agencies only interested in classified information, or are they interested in other non-public information that politicians might be privy to, like who's powerful within a political party and who's got the numbers and how the caucus or backbench committees work and how decisions are made?
You are correct, Senator. They would not just be interested in classified under the way the government would classify its information. They'll be interested in a whole range of information about who your best buddy is, who you confide in, who you might be doing deals with. Of course, they'll be interested in all of that.
So a minister shouldn't have conversations about those kind of topics if they're driving around in a vehicle like this.
We're not talking about you, Minister.
No, I was just saying Senator Patterson on that criteria doesn't have anything to worry about. They won't be investigating him.
Hilarious.
Sorry, Senator, could you repeat the question?
Yeah. So if a foreign intelligence agency is interested in those non-classified but private information, does that mean it's a risk for someone to be driving around in a car and having phone calls with their political colleagues, given the risk of eavesdropping?
Yes, there can be a risk, but I can tell you the Minister is very aware of that and knows how to manage it effectively from my point of view.
Okay. I hope he doesn't have any conversations with colleagues in the car. Politicians would never do that. Thank you, Chair.
Thanks, Senator Patterson. Now, the committee has agreed to move the dinner break forward to 6 o'clock to facilitate ministerial availability. We'll be back at 6:45 with ASIO because Senator Shoebridge has a few more questions for you, and I will be seeking again for the second time a list of agencies that we can release, because it's quite clear that we won't be getting to the agencies we have listed, but I will endeavour to get an agreement from my colleagues on that. Thank you. We'll resume at 6:45 p.m. its hearing, and before we go back to questions of ASIO, we will be releasing some further agencies, and thank you to colleagues for the cooperation. We're going to release the Australian Law Reform Commission, AUSTRAC, and the Inspector of the National Anti-Corruption Commission. All other agencies we are going to hold at the moment, and hopefully we'll get to them. Depends how our next set of questions go, I assume. So I'm going to go to Senator Shoebridge, and then I think we might be close to finishing with ASIO. So Senator Shoebridge, you have the call.
Thanks very much, Chair. Before the dinner break, I was asking questions about the HWMW case. One of the concerns that was raised by ASIO in its submissions was that the attendance of this ADF officer at training organised by the Community Security Group, or CSG, in Israel, and to quote from part of the submission put by ASIO, the CSG training could be considered a natural recruiting pool for Mossad, as Mossad would likely be aware of the training courses. Now, I think that was a proposition put by HWMW himself and a concession by him, but it was put forward as in the ASIO submissions. Has ASIO undertaken any further investigation of such training?
Senator, you'll understand I won't go into in public what investigations we do or don't do. You're right in terms of the potential concern that the individual raised, and that is a potential concern of us. But I want to be clear here on the public record. There's nothing wrong with the community security groups. They perform a decent function, an important function, especially in times like this. Training that they might provide to help provide security to members of the Jewish community is fine. Of course, there is an element of that in some cases it may be the case that that training done overseas in Israel might present an opportunity, and my best advice to anyone involved in that is to be public and not hide anything, and everything will be fine.
Well, indeed, just to complete that about this is training that happened in Israel through CSG, the submissions by ASIO provided the applicant said he thought that if Mossad saw an individual on one of the CSG training courses in Israel that they wanted or had the skills they wanted, Mossad might offer them a position. ASIO assesses that the applicant understood that Mossad has the capability and intent to recruit or use foreign individuals to pursue Mossad's own objectives. That I assume remains ASIO's position.
So I'm not commenting on the specific of the case. As I said, though, of course, if you're actually doing such training and you're not being honest about that and not sharing that, that can potentially be a problem for you.
But on the proposition that was put to the tribunal in the ASIO submissions, doing this training itself in Israel puts you at risk of being approached and recruited by Mossad. I don't think I'm misreading the submission from ASIO. That's what you put to the tribunal. I'm assuming you don't recant from that.
I'm not recanting from what we said. I'm just making the point that I do not want to comment more broadly on the specifics of this, comment on the specifics of the case, but more broadly I was sharing with you the view that the CSG is absolutely fine, training for individuals, the CSG is absolutely fine, and if you're going to do training by organisations, including overseas, you should be open and transparent about that. That's the point I'm trying to make.
Well, in this case, knowing the risk of being, the open risk that ASIO acknowledges of this being a very real potential recruiting platform for Mossad in Israel, do you say that continuing people with security clearances doing the training with CSG is fine, provided they disclose? Is that really the position?
I'm saying that is actually really helpful if they disclose. That allows us to make proper assessments as opposed to potentially being misled. And when we find individuals that may not disclose fully the cases, that's going to be a problem for them when we start to wonder why they're doing that.
Well, one of the reasons given by HWMW was that he was encouraged not to disclose by people within the CSG training course in Israel. That's a problem itself, isn't it?
Sorry, the bit about being told to disclose.
Being encouraged not to disclose.
Oh, well, sorry. If that's the case, that is a problem for me, yes. But again, I'm not going to comment on the specific case beyond what we put on the public record. I was trying to be helpful more generally about...
I get it. One of the other concerns that ASIO raised was that in this case the ADF officer had attended the first interview with ASIO and made an explicit agreement to maintain confidentiality of the investigation and the interview, but then after that disclosed details about not only the fact of the investigation but details of what occurred in the interview to, and I'll quote, the head of the Sydney CSG, and I'm quoting from ASIO's submissions here, and HMW told Person A, who was the head of Sydney CSG, that he had told ASIO about the Sydney CSG, among other details of the interview. And in the second interview, the applicant confirmed that he breached confidentiality by discussing the first interview with Person A, and further the applicant stated he didn't view it as a breach of confidentiality, etc. Were there any investigations undertaken about what, if any, role that Person A had, either in encouraging the disclosure or knowingly encouraging a disclosure that was in breach of the confidentiality obligations?
So you'd appreciate I'm not going to talk about our investigations in public.
Do you know if HWMW is still still a member of the ADF?
I don't know.
No. The series of exchanges, both in Israel but also in Sydney, where confidential information was disclosed in Sydney and where someone was exposed to recruitment from a foreign agency in Israel, do you see that as grounds for ASIO undertaking a further review of who may have potentially undertaken these courses, particularly in Israel?
Again, Senator, I will not comment on operational investigations or investigations that my agency has in public. It actually would hinder us to do our job properly.
All right. But to be clear, at a minimum, ASIO has an expectation that anyone with a security clearance, if they're attending, whether it's foreign training in Israel or perhaps any third country, they would openly and proactively disclose that to their employer. I assume that's a minimum expectation.
Absolutely. It's my point around transparency is the best here when you're going through a security clearance and holding a security clearance. You should not withhold anything.
Yes. Do you know if the ADF has undertaken any reviews about whether or not other officers have also failed to disclose?
I can't answer that. That's a question you'd have to put to Defence.
And I think I asked you, but I'll just be clear. When was the security, the negative vetting 2 clearance removed? Because I think I've said, and it's been demonstrated, I think, in some of this questioning, there were very real concerns from HMW. When was the security vetting removed? Because I think, as this questioning has demonstrated, the concerns weren't just at the end of the process. I assume that there's if you like, a sort of protective approach taken to national security interest, top secret material, where you take a kind of preemptive protection action rather than wait for procedural fairness to conclude.
So firstly on the when did the security clearance end, we have taken that question on notice. Again, not to comment on a specific case, but obviously when we're doing security assessments on individuals, that can happen for a number of reasons. It could be something happens that we're aware of or we get told about that actually kicks off, we need to do a review here. It could be the natural revalidation life cycle of someone with security clearance, and in the 7 to 10 year mark they're up for a revalidation. Could be for a number of reasons. Of course, depending on the reasons, in some cases it can be people are stood down while that review is underway.
Well, even if they're not stood down from their position, surely a precautionary principle in cases such as this, where very real concerns are raised about whether or not access to top secret information is potentially letting a foreign country have access to that. Isn't there a precautionary principle that's adopted? Okay. Even if you don't stand someone down for their employment, removing their security clearance would seem a pretty obvious precautionary step.
So again, I'm not commenting on the specific case, but it does depend, and it should depend, because it could be that we have something that we need to investigate. That investigation could lead to, is there divided loyalties here? And we may well find there are divided loyalties, but that does not mean they have betrayed their country at this point in time. And if we have nothing before us that says they have, it may be what we then do and what the employer does actually depends on the circumstances we have before us. It's a case-by-case basis.
But security vetting isn't a perfect art. It's a risk assessment.
Sure, but we don't.
You don't have to wait for someone to breach their obligations to remove their security clearance. It's a risk appetite.
Sure, it's a risk appetite either way, absolutely, and we don't knowingly let highly classified information go out the door. If we had those concerns, access to that information would be stopped immediately. But it's a case-by-case basis.
I've asked you questions about this one incident because it's the one incident that's been made clear to us through the decision that was handed down last week. Are there other jurisdictions around the country that potentially offer similar training and place either members of the ADF or other people with security clearance at a similar or commensurate risk?
I'm not aware of such, but I'm happy to take that question on notice.
All right. Thanks, Director General. You were asked some questions by my colleague about the, I suppose we call it the Daily Terror sting attack, the Daily Telegraph sting attack that happened on the streets of my hometown of Sydney, in I think it was on Enmore Road in Sydney. You remember? I'm sure you remember those questions, Director General.
I do.
And I think you described it as mind-blowingly stupid. And I'd agree with you to an extent, although I think the concerns that many people have is this wasn't an act of stupidity. This was a planned, resourced, approved sting operation to try and sow division on the streets of Sydney. It didn't appear to be stupid. It appeared to be venal and planned and nasty and divisive. And I wonder if you want to reflect upon your characterisation of mind-blowingly stupid, given the degree of planning that media outlet applied to it.
I stand by my comments insofar as the context of which I was answering. The question was along the line of, and my answer was related to, if a media organisation is going to set something up to provoke, to get a headline, that is mind-blowingly stupid. Of course, if there's some sinister, well-planned, plotted, approved from the top of the organisation to do that, I think that is completely wrong, should not happen, and I'm hoping there is something law enforcement can do to deal with matters like that.
Well,
but that's a personal view.
Yeah. Well, in this case, there was photographers, there was multiple efforts to record it, there was a camera person, there was a relatively senior reporter that had been approved by the powers that be in the newsroom. This wasn't an accidental moment of stupidity. This was a planned act of division on the streets of Sydney, wasn't it? And that is more troubling than something just mind-blowingly stupid. A planned act of division by one of the principal media outlets in Sydney is even more troubling than something that's mind-blowingly stupid.
Without having the full details of that case before me, I can't comment. You're asking me to speculate on something that you've drawn a conclusion on. I do not have the full facts in front of me, so I'm not going to speculate.
But I assume part of what ASIO is doing is looking at what is causing division and causing the division that you've highlighted in your recent address. When you have one of the principal media outlets in the country actively causing the division, I assume that would have come to the attention of ASIO.
It came to the attention of ASIO, but do I have multiple media agencies doing such things? No. So in terms of the way we need to make priority decisions to put the effort of my organisation, this isn't one of them.
But this is the largest media organisation in the country doing it. This is the largest media organisation in the country doing it.
I don't have the data to tell you which is the largest.
Well, I mean, let's be clear, it was a News Corp. It's not a minnow. It's not like the, you know, this is not the Ballarat Times. This is News Corp doing it. Doesn't that raise the level of concern?
I was concerned by the incident. I think it's totally inappropriate, but in terms of what more ASIO will do at this point, I have nothing before me that says it should get the weight of my agency's attention.
All right. Could I ask you about some of the comments you made about the potential for division having been sourced by overseas actors? I think you've indicated in questions, in answers earlier today that I think you indicated, as I understood your answers, that there were 2 occasions in Sydney linked where petty criminals had been used to do appalling acts on the face of it, anti-Semitic acts. Are they matters where there is concern about, does the ASIO hold concern that foreign actors or a foreign actor may have been behind those 2 events committed by petty criminals who appear on the face of it not to hold known extremist political opinions?
So again, I won't comment on specific incidents. The 2 that I mentioned that were connected was in relation to the question from Senator Patterson about previously saying that not all of the major incidents we've looked at we believe are connected and driven by the one person, but I made example 2 were. So that's that. The other aspect of my answer was we have open lines of inquiry about motivations behind these attacks and whether it's a promotion of communal violence, politically motivated violence, or foreign interference. And foreign interference, open line of inquiry, is looking at the question of, is there intelligence that suggests that a foreign nation is driving any of these incidents? That's an open line of investigation for us. Beyond that, I can't comment any further in public.
All right. And is it one jurisdiction or is it more than one jurisdiction that's the subject of investigation?
Our investigations are across multiple jurisdictions.
Often people assume that these threats can come only from countries that are sort of acknowledged as our global geopolitical opponents. Yet we saw from incidents that countries such as India have, for example, engaged in quite vicious attacks on our Five Eyes partners, and I know you haven't confirmed it, but they appear to be the source of some deeply unfriendly acts on shore here. Would people be right to speculate that that the foreign influence is only those countries that are seen as objectively our opponents, or should we be looking also to our people who we might have assumed have been our friends?
From my point of view, it is correct to say that actually foreign interference has come from multiple nations, and some of those nations we consider or are friendly with.
I think one of the concerns you've raised in that regard is a potential foreign government or governments wanting to get access to material acquired by Australia through the AUKUS arrangements, and particularly the nuclear submarine arrangements. Is that a genuine and ongoing threat?
AUKUS is definitely a high priority intelligence requirement for multiple nations. Some of them we consider friendly.
There has been significant speculation that one of the countries targeting Australia for information related to AUKUS is indeed again India. Are you in a position to confirm or deny that?
I won't comment on which countries, other than say there are multiple countries. I can also assure you when we see the action, we take swift action to stop it ourselves or with defence or defence industry partners to prevent that information from being stolen.
All right. And have there been instances of actual espionage or access to confidential AUKUS information that have been brought to your attention? I'm not asking you to identify any of them, but is this just a theoretical threat, or is it a fact that's happening?
So it's a real threat, and we have intelligence to see at the intelligence requirements of these foreign intelligence services and specifically what they're after. So that demonstrates there is active espionage being planned and attempted. Of course, whether or not we've caught it all, because we're not all seeing and all knowing, but no one would be surprised that AUKUS is a priority target for foreign intelligence services, and there are active steps underway to acquire information.
All right. And I assume you're working with the ADF and the Australian Submarine Agency closely to ensure that they are taking all necessary and reasonable steps to protect that information?
It is a priority for my organisation. I have staff working inside Defence and the Submarine Agency, and we will continue to do our part to make sure AUKUS is delivered without compromise.
All right. And have you been alerted to any breaches by the ASA?
I'm not going to comment on real or operational activity. I just can't do that.
All right. Thanks, Director General.
Thank you.
Thank you, Senator Shoebridge. That's all the questions that we have for you, Director General. Thank you for your attendance. We're going to invite the AFP to come into the room, but I'll suspend the hearing broadcast so that we can allow that to happen. Thank you very much. Thank you very much. I now call officers from the Australian Federal Police. Welcome, Commissioner. Would you like to make an opening statement before we go to questions today?
Thank you, Chair. Yes, I would.
Thank you.
Good evening, committee members. Global instability, geopolitical contests and technological advancements have changed dramatically since I was appointed AFP Commissioner 5 years ago. The volume and complexity in federal crime is altering the shape of the AFP as we counter a two-tiered system of crime. We are still focused on the business as usual, disrupting illicit drug trafficking, terrorism, online child exploitation and fraud. But the AFP is more than ever policing grey zone warfare, which includes cyber attacks, espionage and foreign interference. The shadowy hands pulling the strings to achieve political objectives are a direct threat to Australia's national security, our democracy and our democratic institutions. Investigating crimes committed in the shadows takes more resources, skill and time. It also takes diplomacy, partnerships and trust. Every day we share crucial information and resources with like-minded countries to help defend our countries and citizens from those who want to do us harm. Our partnerships with other law enforcement agencies throughout the world have never been so important. An example is our large footprint in the Pacific today. For the AFP, this is non-negotiable. With our shared democratic values, we remain the partner of choice for Pacific Island Police. Through several programs, forums and investment, the AFP works closely with our Pacific neighbours to provide security and training uplift in the region. We are also working closely with the US and the UK as the AFP finalises planning and preparation for the essential and significant capability build for the new protection model for AUKUS submarines. This will take expertise and new skills for our protective service officers and ensure one of Australia's key lines of defence are appropriately safeguarded. This new capability requirement comes as we continue to build our intelligence and capability, especially as we continue to combat transnational serious organised crime, which the AFP has described as a national security threat. Organised crime will expand its criminal enterprise whenever there is vulnerability and profitability. Organised crime groups are growing and diversifying, and many targeting Australia remain offshore. Australian criminals often meet in offshore resort locations to discuss and plan their criminality, while at the same time stockpiling illicit drugs in nearby vulnerable countries. These drugs are often destined for Australia. However, some are also making their way into the communities of those vulnerable countries, creating a new criminal ecosystem. We work closely with partners to disrupt this criminality, and it is a great shame that this is impacting on the safety and security of some other nations. We also remain concerned that some organised criminals continue to support the families of offenders incarcerated in Australia, mitigating deterrence. It is an example of how difficult it can be to break criminal tribalism, which is why the AFP continues to invest resources and time in dismantling organised crime. And in a message to organised crime, I'm warning them today that we will continue to target their offending, regardless of our other priorities, including the upcoming federal election. The AFP has established Operation Australis 25 to ensure the safety, security and dignity of Australian high office holders, federal parliamentarians and candidates for the election. It will be supported by the Commonwealth agencies and state and territory law enforcement partners to enable a coordinated rapid response for triaging, assessing and acting upon threats and reports of crime. An Incident Coordination Centre, as we call it, an ICC, will operate 7 days a week and will be the centralised hub for management of all operations and information related to the federal election. All of the matters I raised today reflect our new normal and highlight our core duties. There is no greater priority for the AFP than protecting Australians and protecting Australia's interests. We do this every day. Finally, I expect you will want to ask the AFP questions about Operation Kissinger, which is our investigation into a caravan found in January in New South Wales, and Operation Hillfield, the investigation into the arson of the Adass Israel Synagogue in Melbourne last year. I understand there is great interest in these investigations. However, I will not provide updates in public forums. Detail provided, whether it seems innocuous or not, can have an impact on investigations, including giving suspects an insight about what we knew and when, and what processes triggered expected tasks. We are unapologetic that our main priority remains on identifying the offenders and bringing them before the courts. The AFP and partners will provide an update at an appropriate time. Thank you, and we're happy to take questions.
Thank you, Commissioner. We will have questions. Senator Patterson, you have the call.
Thank you, Chair. Commissioner, in your absence at the last round of Senate estimates, I asked your colleagues to reflect whether or not, with the benefit of hindsight, they felt the AFP had moved quickly enough and put enough resources behind the growing anti-Semitism problem. This is in November last year, and it was before the firebombing of the Adass Synagogue. It was before the targeting of Mr. Rivchin's home, former home. It was before the targeting of a childcare centre. It was before the discovery of the caravan at Dural. I wanted to give you the opportunity to reflect on that and whether you think over the last 15 or 16 months since the 7th of October, the AFP moved quickly enough and firmly enough on this problem.
Yeah, I think, as you're aware, Senator, we have I think a world-class joint counter-terrorism team structure that is in every state and territory. And that's the lens that we look through. And that joint counter-terrorism team has been in operation for many years and been very successful at being able to counter terrorist threats. So I think from a structural point of view, certainly we have the infrastructure in place. And I think also, and I've said this statement in the public as well, around the fact that we're now getting in behind some of these entities which are linking to organised crime. And I've said crime as a service has become a serious threat in this country. And I'm happy to explain that and have others explain, which I think you're aware of what crime as a service is. So, and as you know, the complexity of the world we live in now, a lot of our high harm targets are not in Australia. So this presents a real challenge for us onshore and both offshore, especially if you're based yourself in countries that are hostile to Australia. So more and more we're having to work out innovative ways of how do we go after a target that's living in a hostile country that we don't have any agreement with to work with. To be able to achieve those objectives. And what I would say is we have had some success in some of those countries that traditionally were hostile, using different techniques and also a different methodology of how we're deploying our people overseas. So I don't want to go into all those operational details, but what the message we're trying to send is to organised crime in particular is we're not going to stop and we'll hunt you down. If you're posing a threat to our citizens and our country, we'll come after you, and we've proven that with some of Australia's most serious threats where we're able to push into different countries and actually successfully arrest, one of Australia's top targets. I don't want to mention his name, but you probably would know who I'm talking about. I think the other thing, if I can just quickly say, is the threat of outlaw motorcycle gangs has continued and, if anything, got stronger globally. And they are a global enterprise that are now involved in any illicit activity that generates profit for them, and that they don't have to pay tax and like normal citizens. So that continues to be a threat, and that's why we do most of our operations now done jointly, either Commonwealth or with state as well.
That's interesting context, but it doesn't directly address the question that I asked, which is, did the AFP act early enough and firmly enough on the anti-Semitism crisis? And let me give you some specific examples to illustrate it. I and others have welcomed the establishment of Operation Advana. I think it had a deterrent effect almost immediately, the week in, week out display of listed terrorist symbols like Hezbollah flags and Hamas flags virtually stopped after Advana and after AFP made that statement. But by that point, it had been happening for months. So shouldn't something like Operation Advana have been launched earlier when I and others have been urging you to act on this crime type?
Senator, perhaps if I could take us back to just after October 7, 2023, where the AFP did stand up Operation Larimar in the days after, and that ran through for a number of months, and that was a 24/7 incident coordination centre with Intel Cell, Operation Cell, Investigation Cell attached to it to address what we expected to come out of that conflict. Operation Larimar was then rolled into our business as usual counter-terrorism and special investigations command. You're then aware, and we were obviously investigating matters through our CTSI command. You've obviously mentioned now Operation Advana, which you are aware was created to particularly address the protest activity in Melbourne on the 29th of September, but not just that activity, but that was the majority of it. And then, of course, we now have Operation Avalite, which was commenced in December.
I'll come to that in a minute, but I just want to finish on Advana first. I mean, the 29th of September was a particularly shocking instance of so many Hezbollah flags, but it was not the first instance of terrorist flags being displayed at these rallies. In fact, I think it was in July or August that year that I tabled documents in the Senate which showed examples of Hamas and Al-Qassam brigades logos that were displayed at rallies, and I think actually some of those people have subsequently been charged, which is very welcome. But why wasn't Operation Advana started earlier in response to those first displays of terrorist symbols? It's really a question for the Commissioner who's responsible for leading the organisation, directing resources.
Senator, what I would say to that, as I've explained, our CTSI command is very well structured and positioned to investigate those matters. You're right, we did stand up Operation Advana in response to that protest, but we were investigating similar matters prior to that. You will also be aware that we were working with new legislation and within the legislation that we've been provided and some of the challenges that we've been on the record talking through, but we have had some good results in relation to prohibited symbols specifically.
I hesitate to interrupt, Deputy Commissioner, but we're running way over time tonight, and I'm concerned our time will be limited. So I do understand those points you make. I just reiterate that the first charges for prohibited hate symbols did not occur until after Operation Advana was stood up, and had it been stood up earlier, perhaps that wouldn't have been the case. On the other example which you cited, and again I direct this to the Commissioner, Operation Avalite was a very welcome response to the Adas Israel synagogue bombing, but it should not have required the bombing and firebombing of a synagogue to stand up a special task force. It was already clear anti-Semitism was out of control, and the Jewish community had been crying out for stronger law enforcement prior to that. With the benefit of hindsight, don't you think it would have been a good thing to have that in place earlier?
No, I think we acted appropriately, and I think our results have shown that. You've also got to understand we operate in a two-tiered system, which is what I was talking about. The state police have certain responsibility, and that there's at times where they may want to investigate certain matters, and they can even lay Commonwealth charges, which I think they've been doing as well. So I think it's probably not as easy as what most people think about just going out and arresting someone. First of all, you're taking their liberty away. Second of all, you have to have evidence and reasonable grounds to believe that they've committed an offence. And that sometimes has meant we have had to obtain that video footage. What's the source of that video footage? We have to go through our forensics procedures. There's a lot there that you have to do. Yes, you can make decisions on the spot, but that's also what we call the Office of Constable, where that's independent of me. The only time that I, as Commissioner, can direct any of my officers to arrest anyone is actually in a public order situation where there's a riot, for example. And even that is you have to be very careful with that. So there are independent decision makers, and some you will get. We are a broad church, Sometimes some officers may not think the threshold has been met. Some others would say, yes, it has been. It's not as easy as perhaps what's portrayed on television.
No one should suggest that your job is easy, and I'm certainly not suggesting that. But I'm just interested to know if there's been any reflection. If you can honestly say, with the benefit of hindsight, saying how out of control this problem has become in our country and how distressing it's been for Australians, that there's nothing that you would have done differently.
I think the challenge we've had was we've had to respect those state jurisdictions and what their needs and wishes are and their strategies, and then we've had to work with every state differently.
Okay. All right. Moving on. I heard your evidence in your opening statement about the caravan incident and your reluctance on commenting on the investigation, and I respect that, and I will not ask you to comment on the investigation or anything that is operationally sensitive. But I would like to ask about the AFP's briefing to the government, including ministers and the Prime Minister, about that incident. So can you tell me when the AFP first briefed either a minister or the Prime Minister or their officers on the discovery of the caravan?
What I can say is this, and this is the truth, of course, is that I briefed ministers at the appropriate time. And that is often led by my operational arm and done in an appropriate way.
Was the appropriate time immediately before a Daily Telegraph article was about to be published?
I'm not going to speculate because it's not helpful. We have, as I said in my opening statement, we're still investigating quite a few matters, and they'll be watching this. So it's not helpful to our investigation for me to disclose that. As much as I'd like to assist and help you, Senator, my operational arm would never forgive me.
Prejudice to an investigation is an acceptable grounds for declining to answer a question from the Senate under the Senate standing orders, but it requires that you specify the specific harm that would be caused by a disclosure. And so what I'd be asking you to do if you are refusing to provide that information is how it would harm an investigation to say when a politician or a government department or an office was first briefed.
Well, and also, Senator Patterson, as you are fully aware, if you are insisting on an answer, the Commissioner is entitled to take it on notice to then consider whether a PII claim needs to be made. And if you are asking the Commissioner to go down that route, for every question that you are planning on asking, then that is something that is available to him. I would probably suggest he has better things to do, but if you want to go down that route, he also can take that line of questioning in that way.
Thank you, Chair. And in response to that, and just before the Commissioner does answer the question, in anticipating that possibility, Senator Cash and I wrote to the Commissioner in advance of Senate estimates advising that we would have questions on this matter so that he could seek advice and come prepared to specify whether a public interest immunity claim would need to be made, and if so, on what grounds.
No, I think I wrote back to both of you, so you have my reply on that. I think in regards to your current question, I will need to take that on notice.
Okay. Without speaking specifically about this incident, how could it prejudice any investigation to say when a politician was briefed about the awareness of the investigation?
Well, again, I'd like to seek my general counsel, so I'll have to take this on notice. Because there's many, I could probably talk for 30 minutes just on that answer alone.
Well, I invite you to do so.
I don't think you'd be happy with me, but I'll take that on notice, Senator. Thank you.
Well, as you know, Commissioner, the New South Wales Premier was asked this question at the press conference where New South Wales Police disclosed their knowledge of the events in response to the Daily Telegraph reporting, and the New South Wales Premier, without hesitation, told the media and the public the day in which he was briefed by New South Wales Police. Has he jeopardised the investigation by doing that? As
I said, we worry about our investigation and what we're doing. That's a matter for New South Wales.
It's a joint investigation.
That's right.
So has it jeopardised the joint investigation?
All I can say is that, again, that's a matter for New South Wales. I think there was a period of time there where there was cross purpose. We were moving into, I can't go into depth about the status of our investigation, but all I say is ours continues, and more speculation on our current investigation, the more harm it's going to do to our investigation.
So on the 6th of December last year, after the Adass Israel synagogue firebombing, the Prime Minister said, and I quote, "I have been briefed this morning by the AFP Commissioner Reece Kershaw." Why was the Prime Minister able to disclose when he was briefed by you on that ongoing investigation, but neither you or the Prime Minister can disclose it in relation to this ongoing investigation?
Yeah, part of it relates again to the operational arm being able to provide advice to me or senior officers. I've got Assistant Commissioner Nutt here, who is a counter-terrorism expert, and he can probably assist you with how that process works. There is a formal process that actually is undertaken on this.
Thanks, Commissioner. Senator, it's Steve Nutt, Assistant Commissioner for Counter-Terrorism and Special Investigations for the AFP. As the Commissioner's already mentioned, we do have significant experience at managing complex and sensitive counter-terrorism investigations. Those investigations and the responses, of course, are bound by robust arrangements, joint arrangements, to govern when we say and do things, and with various levels of senior oversight. And to back our experience up, going back to 2014, Senator, 177 people have been charged as a result of counter-terrorism operations, 102 counter-terrorism operations in Australia. We've had 14 attacks and 26 major disruptions over that period, Senator, into potential acts in preparation and imminent acts in preparation offences and planning in Australia. In 2024 alone, we've arrested 17 people for offences as a result of 12 counter-terrorism operations. So I want to say there's very mature processes on how we manage the counter-terrorism operations, and the governance themselves are contained in the Australian New Zealand Counter-Terrorism Committee framework, and we have extra specific governance around the leadership and management strategies. We have an operations coordination group which is made up of superintendents mostly, and that group is charged with analysing investigative strategies, coming up with proposals and essentially developing strategies that maximise the capabilities of all the joint counter-terrorism agencies. That committee reports to a joint management committee, that's assistant commissioner level. I sit on every JMC in Australia. The intent of doing that is to ensure national consistency, coordination and interoperability, so the same standards no matter what the jurisdiction. And as my role in the Joint Management Committee and others is that we provide strategic direction on the investigations and identify the main mitigations for threats and opportunities, and also identify what the trigger situations are.
And also, Commissioner, I'm grateful for you providing this detail, but it's a very long answer and I will be wrapped up for time soon. So I just want to clarify those complex and involved and detailed processes that you say is necessary to go through before a disclosure can be made. Are you saying that all of that happened on the morning of the 6th of December between the discovery of the Adass Israel firebombing and the Prime Minister's disclosure about his briefing, and that the operational arm of the AFP provided advice to the Prime Minister that it was okay for him to disclose that?
So what I will say is the JMC are responsible for managing those media triggers or strategies and determining what should happen and when as it relates to the investigation as it is. We're the closest to the investigation, Senator.
So that wasn't an answer to my question. Assistant Commissioner, thank you, Chair. That didn't answer my question. On the morning of the Adass Israel synagogue firebombing, in the couple of hours between that incident becoming public and the Prime Minister saying he was briefed, are you saying the JMC met, made a decision and advised the Prime Minister that he could disclose that briefing?
I'll refer back to the Commissioner's statements in the opening remarks about what we can say around those specific investigations, and so that position applies to what you're asking. I can't answer because of the similar grounds that have already been made at the moment, Senator. I'm sorry I can't help you on this occasion.
And Senator, just to make the point that obviously every matter is different, every investigative strategy is going to be different, so it is very difficult to compare one matter to another, even if they appear to the public to be similar. The intricacies and particularly the investigative strategies that we want to leave open to ourselves have to be forefront in terms of the OCG and the JMC when they're making those decisions or providing that advice.
We'll come back to you, Senator Payson.
Thank you, Chair.
Senator Polley.
Thank you very much, Chair, and thank you, Commissioner, and your team for coming before us. I want to follow up on questions I've asked over a long period of time around child exploitation, and I wondered if you could give me an update about challenges and the success that we read in the media, unfortunately, every other day.
Senator, Deputy Commissioner Ian McCartney, Deputy Commissioner of Crime, and firstly let me say we appreciate your strong interest and your passion in this area, Senator, that's been fairly long lasting, so we do appreciate that. I think the work that we do in this space is the crucial aspect is the partnerships that we have, both domestic and international. I think a really good example of the international partnerships we have is through the Virtual Global Task Force. The VGT is a law enforcement-led strategic forum that includes 15 international law enforcement agencies, and we're honoured and proud to be part of that construct. It was established a number of years ago as a direct response to the rise in offenders targeting children all over the world through online social interactions and travelling overseas to commit contact sexual abuse. The most recent Virtual Global Task Force meeting was held last October in London, and it was co-chaired by the AFP and the National Crime Agency. And the AFP commenced as chair of the VGT in November of 2024. We're very honoured to hold this role, this important role, and as founding members of the VGT, chairing is an opportunity to showcase the work that the AFP does in this space, but leverage off our international partners in terms of the fight against this heinous crime. So in terms of key priorities that we'll drive in relation to this work and very topical to the current threat environment in relation to this crime type, firstly will be statistic online exploitation, that unfortunately we're seeing an increased prevalence on that, impacting particularly on the younger generation in Australia. The issue of financial sextortion, which again, unfortunately, we're seeing an increased prevalence. The real issue of artificial intelligence, in terms of artificial intelligence being utilised to generate CAM material, we're getting to the stage where it's incredibly difficult for us to determine whether the image is real or it's been generated. And technology solutions, because I think a key threat in this area is technology in terms of the challenges we have. But that also provides law enforcement with, I think, some small advantage that we can use that technology in terms of combating this crime. A really important component, I think it's fair to say that the 15 countries involved in this has been generally focused mainly on Europe, the Five Eyes, the US and Canada. The work that Deputy Commissioner Gale is doing, particularly at the minute, in terms of that outreach and engagement through the Pacific, through our chair of the VGT, we're placing significant importance in terms of building those relationships in the Pacific with our Pacific policing partners to combat that crime in that area. Thanks.
Thank you. I can say that in a recent visit that I had overseas, the reputation of the AFP in this area goes beyond our borders, but there are some challenges in relation to social media platforms and end-to-end encryption. What's the response been with your engagement with social media platforms like Meta and Snapchat? And are there other ways that you can collaborate with other law enforcements globally to try and address these challenges?
Well, I think it's a team approach, Senator, in terms of working with agencies in Australia. This includes the Attorney General's Department, a range of other agencies that have pivot points into particularly the US, because the majority of these companies are based in the US in terms of that engagement. So it's very much leveraging off the support we receive from the other agencies. I think on the issue of end-to-end encryption, we've been on the record to say we're concerned in terms of the ability, in terms of receiving, particularly from companies such as Facebook, if they move to a full end-to-end encryption, the ability for them to refer matters to the AFP where they identify online child exploitation. We have some real concerns and we voice those concerns. I think these companies have acknowledged that they're going to move to end-to-end encryption, but they've highlighted the fact they still have a focus on an ability to work with law enforcement. Going back to the VGT, the power of those 15 international law enforcement agencies, so it's just not the AFP engaging with these countries, we can force multiply, and it's effectively 15 different countries and law enforcement agencies that will continue to engage these companies. In some respects, hold them to account in terms of the promises that have been made in terms of the ongoing support to law enforcement.
Thank you for that. Are there any gaps in the current legal legislative framework that you would see that if there were changes made there, are there any recommendations on what more can be done?
Well, I think the real challenge for us is technology is changing so quickly. The Commissioner's heard me say this before. When I joined the AFP 35 years ago, we had a typing pool, Senator, and that's not to show my age, although I think it does. But it highlighted...
Typing pool. It's only a number. It's only a number.
It highlighted when I joined the organisation all the crimes that I investigated was in the real world. The majority of crimes we investigate now in the AFP and child online exploitation is a perfect example, is fully online, or our other crime types have a strong connection to the online construct. So I think there's three broad issues or challenges we face. Firstly is big data, the amount of data that's actually out there, the amount of data that I can store on my phone compared with, I think in 2 or 3 or 4 years' time will exponentially increase. So that'll be a challenge for law enforcement. AI, in terms of the real concern for us, and the Commissioner has been on the record on this, that the opportunity cost, our focus is obviously focusing on high priority matters where we believe a child is at risk. But if that child is an AI image and not a real child, we could spend 6, 12 months investigating that matter. So the ability for us to counteract that. And then the issue of encryption in terms of what we do with this space. What I can say, we have a very productive relationship with the AGD, with the Attorney General's Department in terms of legislative reform, because the environment's changing so quickly. We continue to work with AGDs, and there's been recent legislative reform in relation to this area, particularly in relation to AI and deep fakes. We'll continue to be incredibly proactive in terms of identifying the changing environment and working with our partners.
So if we look at the increase in sextortion, we're looking at the challenges around AI, we're looking at end-to-end encryption, the speed of technology. There's some huge challenges there. How many staff do you have in your department that is dealing with child exploitation?
We have a lot, and we haven't been funded by government in terms of increases over the last couple of years. I think every senior officer that would sit here, Senator, if you said, would you like more resources, you know what the response is going to be. I think we've been effectively funded. The challenge for us is being effective and efficient in that environment. The crime threat environment is changing so quickly, and so how do we respond to that? So I think my answer to that is, I think we've got the right building blocks in place. I think you've had the pleasure of attending the ACE in Brisbane, and I do note Deputy Commissioner Gale was the forerunner of that in terms of establishing the ACE in Brisbane. I think we've got the building blocks in place. It is an incredibly challenging environment and will continue to be challenging.
So how many officers do you have working in this area?
Yeah, I'll take that on notice, Senator. I'll try and get back to you before the end of this hearing.
So the challenges are great. The technology is moving very quickly. You have to have qualified expert officers working this area. Not everyone can work in this area. So I appreciate the fact that you say you've been well-resourced and supported. But the reality is, if there's a cut to those resources, that's going to have a direct impact on our community and the challenges that you fight every single day. Would that be a fair assessment? I'm not asking you for an opinion on the 20% that's going to come your way, but I'm just asking, any cut is going to have an impact.
Yeah, of course. I mean, it means that we'd have to reprioritise our resources, and that could lead to children being sexually abused that we can't get to. So for us, that particular crime type, and having worked in it myself, you have incredibly passionate and committed people who, I don't even know how they do it in today's world, because the volume that our people have to watch, see, understand, and then have real victims. And you've seen some of our operations, like Operation Tenterfield and others, nationwide and global operations that we're running. It's quite incredible what our people do and what they have to go through. If you haven't ever seen this is not what people think it is. And that's why we call it child abuse, not child pornography, because it's way worse than what you realise. And I think it's remarkable the work that our people do, and if anything, we need to increase our resources in that area.
So my final question.
Yes, thank you.
If we just take AI and the amount of time and the expertise, and hopefully develop technology that can actually identify whether it's fake or not, the reality is, if people are actually using AI material and that is being shared, that is still a crime.
Correct.
And still has to stop. So my question is, are there people working on detection of AI?
Yes. I think, and I noted the work of the VGT. I think, I like to think we're world leading, and we've got some people sitting in this room that have been instrumental in that. But that ability to work through the Virtual Global Task Force and leverage off the capabilities of other agencies. So again, the issue of AI is a threat, but it's also an opportunity for law enforcement to utilise AI. We very much acknowledge that we need to be responsible, and we've got strict guidelines in place, but we need to embrace AI in terms of the work they do, the investigative work. But I think even from a welfare perspective, I don't like looking at those images. I can't look at those images, Senator, and I think our people have to look at those images on a daily basis. So the work we're doing at the minute in terms of using AI and technology to reduce our investigators to looking at those images is incredibly important work, and will continue to be innovative in driving that space.
If I know time, sorry, Chair. If it's okay, really quickly, just to assist with the Senator's question. One of the ways we are addressing the issue of AI is partnerships. not just partnerships with law enforcement, but ethical partnerships with universities and other academia, specifically looking at AI and how we, in an ethical context, can utilise it to counter some of the challenges that we're currently seeing in that space.
Thank you.
Thanks very
Chair.
much. Thank you. We're going to try to work through this very long list. Senator David Pocock, you have the call.
Much, Chair. Thank you for your time here this evening. I continue to be concerned about cultural issues that I'm hearing from people in the AFP and the number of officers who are having to seek Comcare, and acknowledge that Comcare is another issue in and of itself. But just looking at some of the things that we've discussed here over the last few years, in 2022, less than half of the AFP surveyed had faith in senior leadership. That question was then omitted in 2023, and I remember Senator Shoebridge asking a lot of questions about that. You said that it would be part of your 2024 In Focus staff survey, but I haven't been able to find that published anywhere. Has that been published?
I'm happy to give an update on that, Senator. Thank you for the question. Catherine Van Gert, Chief Operating Officer. Yes, we are very committed to creating a safe and psychological safe workplace. As you know, we've talked about it before. In terms of our survey, we didn't omit it from the 2023 survey. As we've talked about in this forum previously, we conducted a deep dive that year around psychological safety to better understand some of the feedback that our staff had given us in that 2022 survey. We are committed to hearing from our workforce. That's what we want to hear. We want to hear what's going on, how we can fix things. We currently have the staff survey out to our workforce. It closes next Sunday after being open for 3 weeks.
Sorry, Ms Van Gert, can I just confirm that's the 2024 staff survey?
We don't label it by year, but that's our full staff census survey that we're currently out to market. We're currently out to survey.
Previous estimates, you told Senator Shoebridge that would be part of your 2024 survey.
Correct. That is correct, Senator. We did.
What happened last year?
So last year, the plan was, when I answered that question at Senate estimates earlier last year, that we would run the survey late last year. As you'd be aware from our previous appearances last year, we were undertaking a protracted industrial relations enterprise bargaining process. We made a decision as an agency that it would be too much of a burden to ask, and insensitive really, to ask our staff questions around their perceptions of in the workplace when they're undergoing these protracted discussions and negotiations. So the decision was made to run it this year, but it has gone out to, as I said, it's currently out. It closes this Sunday, and as previously, we'll be publishing the results.
And so there was no look at. There was no survey last year at all?
There were multiple surveys, including a survey that we undertook of our entire workforce post our first EA vote to understand their sentiments at the time and why they voted the way they did at that time. So yes, we did do surveys, not on the questions you're going to, correct.
That's what I'm asking.
Not a full staff census survey, that's correct.
Okay. I mean, I accept your explanation about the negotiations, but I think for an agency that's clearly struggling with culture, maybe I'll move on. The AFP Health and Wellbeing Strategy.
Yes.
What's the update there?
So I'd just first like to correct the statement that we're struggling with culture. I don't agree with that. I think we've got a very strong culture. I think the surveys that we do have, the people do like working for us. They value the goals that the AFP have, and they feel a real commitment to that. In terms of our health and wellbeing strategy, you'll be pleased to know that has been signed off. Our board endorsed that strategy earlier this month, our new health and wellbeing strategy beyond 2024. We're currently in the process of developing the communications for that, and that will be launched in the coming weeks to our workforce.
Are you able to table that strategy?
I'll take that on notice. I don't have a copy with me, but more than happy to table that on notice.
And how much funding has the AFP allocated to implementing the strategy?
So the strategy is delivered and implemented within our team. We have a dedicated team within our People Command. In addition to that, as I've talked previously about, we have an ongoing relationship with the Australian Human Rights Commission that we've had in place for over 5 years. We're in negotiations with them at the moment to continue that partnership for an extended period of time, but over the last 5 years we have invested $3.4 million to the AHRC in that important partnership that we have with them. We're currently working on developing a cultural framework with them, and part of that we are re-looking at a refresh of our AFP values, and we'll be undertaking consultation across our workforce on that as well.
I think, Senator, to explain that a little bit deeper, we actually have and have had the AHRC embedded actually into our organisation, who are assisting us with the strategies on how we can improve the culture. Okay. So that's really important to highlight, because we've opened up our entire organisation, and we have for the last 5 years, and that seems to get misunderstood, that we're not trying to actually improve our culture. We are actively, but as you know, in any team sport, you do have cultural issues that sometimes you have to work it out. And one of the things that we've been doing is, what are the programs that we can offer different people? Because not everyone wants the same program of support or need the same program of support. Sure. If we listed off the numbers of things that we provide our members, I think that would actually help you assist a better viewpoint.
Thank you, Commissioner. We're really tight on time. Sorry. So I'm interested, how will you be measuring progress and outcomes of this new strategy? And just want to highlight, I think it was over a year ago that the old strategy lapsed, and we've had a year where there's just kind of been this interim while the strategy still holds, but it's not actually the strategy. So now that we have this new strategy, how are you actually going to be measuring, is this thing working?
Yep, thank you, Senator. Thank you for the question. So just to confirm that the previous strategy did stay in force until we launched the new one. In terms of evaluation of our former strategy, we reviewed that strategy as part of the development of our new strategy.
But sorry, can I just, there was nothing measurable in your last health and wellbeing strategy. So you've just evaluated it after the fact.
No, so the last strategy had 42 actions, 37 of those were completed and 5 remain in progress and have carried on to the next strategy as well. They're longer term actions. What the evaluation did show, though, is that there are limitations on the data set. We're one of the world leading, certainly Australia leading agencies in terms of the SHIELD program, health and wellbeing program that we've rolled out across our agencies. So we really are building data sets as we go.
Can I ask on that, in questions on notice, you wouldn't tell me how many current and former employees have accessed SHIELD. How many have?
Have accessed SHIELD?
Yes.
I'll have to take that on notice, Senator.
Okay. And then just, I guess I hear what you're saying, but it seems like there's this big disconnect in the AFP where you turn up, you tell me one thing, and then I literally have people crying in my office about the way they've been treated and their mates have been treated. And so I'm interested, like, what is actually going on? I mean, your Comcare claims are going up. They're at 33.1 per 1,000 FTE compared to 27.3 2 years ago.
That's not such a bad thing. That means that you can look at it in different ways, that there's more confidence in the system for people who are struggling mentally, and it may not be at work, it's always at work. You know, I don't want to go into further detail on this because we could talk all day about it, but it may be worthwhile that you sitting down with our people that help administer some of these programs, our SHIELD people, to understand have a deeper viewpoint and data points on what we actually are doing.
But Commissioner, how are we meant to know that if you won't even tell me how many people have accessed your SHIELD program?
So what I can say...
I've asked that on notice before, and I get donuts from you.
Okay, we'll take that on notice. Again, I don't have that in front of me today, Senator, but what I can advise is that since 2020-21, when SHIELD was introduced, we have had a 24% increase in the uptake of people, our members accessing early intervention services, which is key to us bringing down those Comcare claims. We've also had a 23% reduction in accepted workers' compensation claims during that time since the introduction of SHIELD. So we're seeing some benefits. We continue to drive that strong focus on safety culture, introducing a compliance and regulatory engagement role. We're continuing to focus on our collaboration with Comcare. I'm aware of media articles. I'm aware of the stories that members are telling and the not positive interactions that they're having, and we want to help with that. So we are working with Comcare to fast-track claims as much as we can, and so the ongoing implementation of our strategy is what we can do at our end, but we're keen to hear those stories from members so that we can improve.
Okay, and can I ask about exit interviews? In May 2023, you told me that you were refreshing your exit survey process so you could, and I'll quote, get more robust data.
Yep.
Essentially actually asking officers why they're leaving. And then on notice you told me the timeline for implementing a refresh AFP exit survey is December 2023.
Yep.
But I've had people telling me that that's not happening. What is happening?
Thank you for the question, Senator. So to clarify previous evidence I may have given, we have always had an exit interview. It just wasn't a formal process in the system. So since July last year, it is now a formal process in the system that is more automated. So it allows us to get greater access to the data. So we do have about 7 months worth of that data available. What we are seeing is, in terms of our sworn departures, approximately 38% of those are due to retirements. One of the main reasons that people say they want to leave is work-life balance in terms of our sworn members. So it's giving an avenue for us to collate that data to understand how we can best support our members to increase retention where we need to.
Ms Van Gerb, could I get that data on notice?
Yes.
What percentage of
Senator.
I beg your pardon?
Maybe if you have 2 more minutes and then I'll
Great, thank you. I'll go quickly. What percentage of people leaving the AFP are having had an exit interview since you've instigated a more robust data collection?
I'll have to take that one on notice, Senator.
Okay. We
certainly have had more responses than previously when it was quite informal and was done by supervisors.
Great, thank you. And then just finally, thank you for responding to some of my questions on notice in relation to travel. However, you're one of the very few agencies who refuse to answer questions about SES travel on Qantas versus Virgin versus other airlines. And I'm just wondering why you can't provide this data, but basically all the other departments and agencies can.
So, Senator, I believe in response to the question on notice, we have provided data in terms of our entire agency's travel on domestic flights.
After SES.
Qantas, yeah, in terms of SES, from what I'm advised, our system doesn't allow us to pull the data in that way.
But everyone else does?
Yes, so the AFP system hasn't allowed us to pull that data. Is that an issue? With the system, that you can't just search that way? Pardon?
Is that an issue with your system that you can't search that way?
Well, we have a very robust travel policy in place that defines the fact that members are expected to undertake the best fare of the day, whether that be Qantas, Virgin or another carrier. Our policy also dictates that it's against policy to receive an upgrade. I know that's an area of interest for you. So we wouldn't be able to take the upgrade, and if that happened to be given and not able to be declined, then it would have to be declared as a gift and benefit. So I'm quite comfortable that the AFP's governance around this in terms of the process that we put in place for people to have travel approval is sound.
Mm-hmm. Okay, so... Okay. I guess just on that, I'm interested, if you can't take flight upgrades, why did the answer just say the AFP does not have access to flight upgrade data?
So we can't pull that from our system because that's information that would sit with an airline system, but what I can say is our policy dictates that members cannot accept an upgrade. So if they did, they would have to declare it.
And have any been declared?
No, not that I'm aware of, but I'll take that on notice to confirm.
Yeah. Thanks, Senator. Senator Van.
Thank you, Chair. And Commissioner and team, thank you very much for appearing again before us. Much appreciated, and sorry we're running so late into the evening. Commissioner, earlier in the day I tabled some correspondence, in particular a letter to you dated 20 January 2025 from the Australian Federal Police Association's Chief Legal Counsel, Giles Snedker. You received that correspondence?
No, Senator Van, you tabled it earlier with the Attorney General's portfolio. But
isn't that tabling it for the committee?
No, but that doesn't mean that the Commissioner would have seen that document. The document would have been circulated to committee members like myself and other members at the table, but they might have knowledge of the document otherwise.
Thank you, Senator. I forgot to introduce myself before. Lisa Gale, Deputy Commissioner. I am aware of the correspondence that you're referring to.
Thank you, Ms Giles. But Commissioner, you're not aware of it, even though it was addressed to you? And at that point I might ask the Secretariat to circulate it.
I think I am, yes.
Terrific. Thank you for confirming that. Commissioner, in that correspondence, it talks about that Mr Snedker had become aware of the initial criminal investigation into the conduct of 4 senior AFP members over the management and production of the body of works. This was for Bulwark 58 operatives. Can you tell us the nature of that investigation, please, Commissioner?
Senator, I will take that question as the head of unit for professional standards, and I do refer you to previous evidence, both in hearings and questions on notice in relation to these questions, and that I won't be answering questions about PRS investigations in a public hearing.
Not even general ones, these aren't specific ones.
I won't be answering questions about ongoing PRS investigations.
So you've just confirmed one of my next questions, that it's ongoing?
That's on the record, yes, I've confirmed that previously.
And can you tell the committee who is conducting the inquiry or the investigation?
I've confirmed it's a PRS investigation, so sitting within our Professional Standards Command.
So AFP are investigating AFP senior members?
It's our Professional Standards Command. We have a very robust integrity framework, which is overseen by the Ombudsman.
Thank you, Ms Barrett. The correspondence was responded to by you, Ms Gale, is that right?
That's correct, Senator.
In your response, you say that the AFP is, and Chair, would you like me to table this letter, knowing that the witness wrote the letter?
Only if the Commissioner needs a copy, we don't need it.
I'll be putting my questions to Scale if that assists. I left mine on the printer, but I can forward it.
I have a copy of it.
Great.
So you're comfortable?
Yes.
Thank you. In your letter, you state the AFP is satisfied it has in place appropriate risk and threat mitigation strategies and is well placed to manage any security issues. There is no identified direct or implied threat to the safety of B58 members. Is that a fair reflection of what you wrote?
That's correct.
You talk about direct and implied threats.
Yes.
Are they the only types of threats that can arise to an undercover operative or an ex-undercover operative?
Can you perhaps be a bit more specific?
To me, in that language, it is stating that there is a positive action that you can see and measure, whereas a threat, as we all know, can arise without notice, without being implied or having some grounding in something that you could investigate or see in a physical or data sense.
Senator, I would just reinforce the views that or the position conveyed in the response to the AFPA, in that there is no perceived or direct threat. We continue through a robust structure and architecture for how we assess risk and threats, and remain open to reviewing and revisiting any concerns by members if they are, prepared to raise any new concerns that they may have in relation to what they perceive as threats to themselves. I've said that repeatedly. I've corresponded on 4 separate occasions indicating this, that I remain open to continuing to review the concerns of the members if they provide new, and I just restate, there has not been anything new to warrant any new response to the concerns. But if the members can bring forward something, we remain open and will, I encourage anyone, I will review any new information.
And Senator, I might just add that we did undertake a review. We had an external person undertake a review of the Project Bulwark capability, which, as you would be aware, is the capability that is responsible for addressing threats of harm to current and former members. There was a review undertaken in 2023 to ensure that it remains fit for purpose. That review found that the structure, the resourcing and the processes of Project Bulwark are adequate. It did identify some opportunities for ongoing enhancement. All of those recommendations have been implemented.
And Senator, if I just could add, the AFP spends thousands upon thousands of hours ensuring that the identity of our undercover operatives is protected. The safety and well-being of our undercover operatives, both in the past and in the present, is of paramount importance to us. And certainly for me personally, as the Deputy Commissioner in charge of the undercover program at the moment, it is my #1 priority.
And Ms Gale, I don't doubt that, but you weren't in charge at the time that these operatives were undercover or exited the undercover program, were you?
No.
No. And we've heard many times that there is glaring holes in the threat assessments that were done on them, particularly the revised one. There was one that said that threats were probable, if not certain, and then all of a sudden there was a revised one that said no threats perceived, perceived being the operative word. In that revised threat assessment, why were why was organised crime and outlaw motorcycle gangs removed as threat vectors?
Senator, I'll refer you back to my comment earlier. We have given previous evidence in relation to this matter, both in hearings and questions on notice. And I have repeatedly said that I am uncomfortable discussing these matters in a public hearing for 2 reasons. One is it goes to the methodology of a very sensitive capability, which is charged with protecting our members both now and into the future. Second, it goes to an ongoing PRS investigation, and my responsibility with the PRS investigation is to the complainants who have made the complaint to the AFP and have trusted us to investigate it with integrity, and that's what we're doing. So I'm not comfortable having anything further on the public record for those 2 reasons.
Ms Barrett, firstly, I haven't asked this question before, so you cannot claim that. Secondly, the investigation started well after I started asking questions of the organisation about this. So on both those legs, your claim falls over. Now, at the time when these operatives exited, there was no meaningful exit strategy, was there?
Senator, my position remains the same. I'm not comfortable answering these questions in a public hearing for the reasons that I've outlined.
Ms Barrett, I know you're not comfortable. This must be a very uncomfortable situation for the AFP. You're investigating your own people over a failure to keep your own members safe. That would be very uncomfortable.
Senator, that's your categorisation, that's not mine, but my position remains for reasons that I think I've fairly clearly outlined as to why it's not appropriate in this forum.
No, you think it's not appropriate, but this committee has a right to investigate these matters, and you must allow us to do that or put forward a PII.
Senator, the PRS investigation needs to continue unheeded and unimpeded so that we can, as I said, fulfil the obligation to the complainants who have come to us and trusted us to undertake the investigation.
But they don't trust you. That's the problem. And any future undercover operatives are going to struggle to feel that they can trust you to look after their safety and well-being. And as I said before, I've been asking these questions well before the PRS investigation started, and my questions weren't answered then. So I don't believe that you've got a strong case to say that you won't answer them now.
Senator, if I could just add, in relation to your comments regarding future undercover operatives, I can say to you that we have a very robust system in place to provide support to both current and looking forward future operatives, utilising SHIELD, utilising psychologists. We also undertake regular assessments on our operatives to ensure that we are monitoring and we continue to reassess their well-being, and we have psychologists embedded in place within our program specifically to ensure that we are maintaining the well-being of our operatives. Can I also
Ms. Garr, sorry, no, I'm going to lose a call soon, so can I cut you off there? Hopefully not rudely. Isn't the fact that you need to have psychologists on hand testimony that the process isn't robust, because people are only going to have psychological impacts from their undercover work if they can't exit safely?
No, Senator, I don't agree with that. What
Really?
I would say what I would say to you is there are a number of high-risk areas across our organisation. We're a policing agency, and a number of activities that our officers undertake, not just in the undercover operations space.
And for general members, I think it's a wonderful thing, and you should be congratulated for that. But we are talking about a very small cohort of your members, and there was no exit strategy in place. There continues to be no exit strategy in place. Even the most basic things that you would expect to be given to an exiting member in terms of what might happen, for example, we talked about direct and indirect or implied threats. What happens if they bump into an ex-POI out the street? How is that taken into account? Please.
And I'm not every police officer in Australia has that fear.
But it's a different level if you've been undercover and deceiving these people. Well, there are organised crime that would have their own mottos about that.
I understand that, but you think about it, police officers, we don't often go to places because we don't want to be identified. And I understand that. So I understand that our undercovers, and I understand what you're saying, but we all carry that.
Commissioner,
including for when you have to go on holidays, when you have to do all of that, it can be challenging. And I think the two deputies are handling this the best that we can with the issues that we have. And they are looking at the human side of it and how can we resolve this.
Senator Van, I need to rotate the call. So you've got one more question, and I'll do that.
Commissioner, that effectively, it says to me, and I agree, it's a dangerous job, we all accept
it.
It
is.
And no question about that. But undercover is particularly dangerous. And the fact that you say, and bundle everyone up together, sort of screams that, that there is not specific treatment or exit strategies in place for undercover operatives, and there certainly wasn't for these people. And I still today cannot understand why you or the Attorney General have not taken steps to ensure their safety. I'll leave it there, Chair. Thank you.
Thank you. Yeah, I think we've traversed these questions a number of times. We do need to move on. Senator Faruqi has a couple of questions, and then we'll hand the call to Senator Patterson after that. And then get around. So, Senator Faruqi.
Thank you, Chair. Good evening, everyone. Thanks for being here tonight. On the AFP website, if you go to the page Report a Crime, you can select a number of crimes. And anti-Semitism is on that list of crimes, but there is no mention of Islamophobia or any other sort of hate crimes. If you go to the AFP page, which says crimes we are combating, it's the same story. A number of crimes, anti-Semitism is on there, Islamophobia is not. If you search the site with the word Islamophobia, it says no content on our website matched your search. We know that Islamophobia is on the rise. The Islamophobia Register has, in their latest report, says that there has been an increase of 540% in Islamophobic incidents reported to the Register over the last 16 months. So why doesn't this website include Islamophobia? What's the reason for that? Or is the AFP of the same view as Senator Sharma, who says that Islamophobia is fictitious, or Senator Henderson, who thinks that there is no issue with Islamophobia in this country?
Sorry, Chair, I just want to take a point of order.
What is the point of order?
I just think it's grossly unfair for Senator Faruqi to refer to some of our colleagues in that way in their absence. I just think it's unnecessary for the legitimate question Senator Faruqi raises.
No, it's a legitimate question. Senator Scarr, you should probably review the comments of your own colleagues in another committee today and reflect on that before we get into a tit for tat about who said what about different colleagues. Senator Faruqi, I'll let you put your question and then we can get an answer from the Commissioner for you.
Thank you, Chair. So my question is there a reason for not including Islamophobia anywhere on your website as a crime? And what is the reason?
Senator, can I just provide assurance? Obviously, the AFP, we target criminality regardless of race, religion, ideology. So that's the first point that I want to make very clear. And we do have a range of investigations specific to a range of communities, religions, races. The configuration of the website that you're referring to is partly to assist us to triage for Operation Avalite, which is the operation, as you would be aware, that was commenced in December last year, in order for us to facilitate a quick triage to that task force. But Assistant Commissioner Nutt will provide a few additional points as well.
That's not a reason, though, not to include Islamophobia in there.
I think I can assist, Senator. And I don't want to exactly share everything. We have been working on a protocol with the Islamic community. I'm not going to say which community. There's a number of those communities, and I've been personally in contact with those communities, and they're working through that process and what does it look like for them. And I can reassure you that we put as much emphasis on any of these crimes, no matter what your background is and what your religious beliefs are. We don't discriminate. And I don't want to talk about this particular thing because it's still ongoing and it's very sensitive because we're actually trying to break some new ground on information sharing between law enforcement and the community in a new framework.
So is it something separate? So I guess my question is, it still doesn't answer my question, sorry, why Islamophobia or any other sorts of hate crimes are not included here, even a broad category of hate crimes. would be useful for the community. Yeah. I mean, I come from that same community.
I understand.
Yeah. Okay. Just another question. Does the AFP conduct anti-racism training for all its staff?
In terms of Senator, in terms of specific anti-racism training, in our foundational training, and I'm sure there's others at the table can comment as well, obligations, legal obligations in the respectful workplace, obviously in relation to the Racial Discrimination Act requirements, and of course in operational police officers are involved in identifying and assessing what is described as hate crimes, and also particularly in the Counter-Terrorism Command, the cultural and awareness training that we do in support of our community engagement activities and identifying what is obvious and veiled hate speech and hate crimes is part of our work. We work very closely with community to identify those issues, and if I may just circle back briefly on your previous question, the Deputy correctly identified around the website and relating to the Special Operation Avalite, but I can assure, and I engage the community on these issues as well, is that Islamophobia and other hate crimes are given equal priority in terms of investigative response, the same criteria that we consider with the nuance around Commonwealth nexus, focusing on known hate mongerers, if I can use that term. It's not a technical one, but to identify those who need to be disrupted is maintained as a focus of the Counter-Terrorism Special Investigations Command, and it's something that we deal with our state and territory partners as well, Senator.
You didn't answer my question though. Does the AFP conduct anti-racism training for all its staff?
Well, I thought I did to the extent there was...
But cultural awareness training is not anti-racism training.
Yeah, Senator, we have a range of mandatory online training that our staff have to do across a range of different legislation. I believe that the Discrimination Act and responsibilities under that is part of it, but I will take it on notice, the exact training course that we do and the extent of that, and come back to you.
Thanks, Chair.
Thank you, Senator. Senator Patterson, we're back to you.
Thank you, Chair. Mr Barrett, your final answer to my previous bracket of questions highlighted a fair point, which is there are differences between different cases, even if they may seem similar on the face of it, and that may explain why a different response is warranted to public comments. As we've explored, the Prime Minister did make public comments about when he was briefed in relation to the Adus synagogue, even though it was an ongoing investigation and remains an ongoing investigation. What are the differences between the Adus incident and the Dural Caravan incident that explain the necessity of that different approach?
Thank you, Senator, and I will refer you back to some of the language that the Commissioner used in his opening statement, specifically that providing detail, whether it may seem innocuous to others or not, can have a critical impact on investigations, including giving suspects an insight about what we knew, when we knew it, what we were doing with it, what that triggered. So hence, I know it is frustrating that it may seem like an innocuous detail, but in actual fact, we are gravely concerned for the integrity of the operation if we were to provide detail along those lines.
You're gravely concerned about the integrity of the operation if you tell me when ministers or the Prime Minister was briefed about it.
That's correct.
You have to explain why. That makes no sense to any kind of normal independent observer who's watching this. They would think that makes no sense. Why?
And Senator, I understand that for people who don't have the knowledge and the details of the investigation, how we're progressing that investigation, what sort of tools and strategies we're using in that investigation. So I do understand, as I've said to people in the community and members of the public, and indeed yourself, that you would take that view, but you don't have the information that we have in terms of the investigation.
Okay, let's go to another example then. Following the Waverley church stabbing incident, the following morning the Prime Minister went on ABC Radio Melbourne and he said, and I quote, "We will have a meeting of the National Security Committee this morning. I was briefed by the head of the Australian Federal Police, Commissioner Kershaw, and the Director General of ASIO early this morning, and we'll be having that meeting." That was a live terrorism investigation at that time. I think it was declared a terrorism incident by New South Wales Police at 1:30 or so in the morning. So why could the Prime Minister disclose in that instance the timing of his briefings, but not in this one?
Senator, I'll take you back to my previous point about it's a case-by-case scenario and no two matters are the same. The matter you're referring to there is quite different to the matter, the other matter that you're seeking information on, but I'm not comfortable providing any further detail around as to why, because if I was to do that, it would put information into the public that would impact our investigation.
Also, I know it's a matter of framing the question in a different way, but the AFP can't answer questions about what the Prime Minister has said or what he didn't say. That's a question for PM&C, I think. The AFP can answer questions to you about their conduct and otherwise. I think they've...
Thank you. I'm testing the proposition that the AFP has advanced that the public disclosure of the timing of briefing of a politician is prejudicial to investigations, and I'm citing some other examples, and I want to move on to another one. The AFP was involved with your partners at ASIO in arresting alleged Russian spies who are serving in the ADF, and following those media reports on the 12th of July last year, the Prime Minister said, "Well, I've been briefed extensively by our security agencies, including the AFP, including as late as this morning, but also previously I spoke to Commissioner Kershaw prior to the press conference. They've outlined the details." This seems like yet another case where no harm has been done to an investigation, unless you correct me, by a disclosure of the timing of a briefing. Is that the case?
Senator, again, I'll refer you back to my previous comment about every matter is different and we have different considerations that we need to take into account. And to reinforce the Commissioner's opening statement, we won't apologise that we're prioritising the investigation because our job is to put offenders before the court. That's what we're focused on doing.
Okay, so the information I'm seeking is the timing of when a politician was briefed. Commissioner, I want to point you to your statement on the 21st of January about anti-Semitism. There's very welcome sentiment in that about the way in which you and the AFP abhor anti-Semitism and will act on it. But also in that press release, you said, and I quote, "All lines of inquiry are open to investigations, including what anonymising technology, such as dedicated encrypted communications devices, have been used to commit these crimes. We are looking into whether overseas actors or individuals have paid local criminals in Australia to carry out some of these crimes in our suburbs. We are looking at if or how they have been paid, for example, in cryptocurrency, which can take longer to identify. We are looking into whether any young people are involved in carrying out some of these crimes and if they've been radicalised online and encouraged to commit anti-Semitic acts." That's a lot more information about ongoing investigations than I'm seeking. It goes to the motivations, it goes to the communications, it goes to the payment, it goes to criminal associations. It's a highly detailed statement about active investigations. I'm not seeking that, just when a politician was briefed. Why was your comment, your press release, not prejudicial, but telling me about a politician's briefing would be?
I mean, I could talk all day about this, Senator.
Please do.
You know, it goes back to our operational strategy, and that's all I'll say to keep it succinct.
It's certainly succinct, but it doesn't answer the question.
Well, it does. From our point of view, how we operate, it does. And I, as respectfully as I say this, you're not a police officer investigating these crimes. Maybe we could bring you along one day, and we do ride-alongs and other things like that, to probably show you a bit deeper about the thinking that goes into how deep we go into our thinking about operational strategies and how we actually gather the evidence to be able to prosecute someone down the track, not just disrupt them. So there's a lot of effort that goes into our operational strategies.
I don't doubt that, but I find it difficult to accept that putting into the public domain uncorroborated potential lines of inquiry is in no way prejudicial to investigations, but simply sharing the fact of when a politician was briefed would be prejudicial. I don't think any fair observer, including, by the way, much more experienced national security experts than me, including former police officers who've been involved in this, who've publicly commented about their scepticism about the reason why this needs to be kept secret.
Yeah. There is no scepticism. It's pretty simple, and I just sort of also can see your point from where you're sitting, that you would see it that way, and you've just got to, it's a bit corny, but you've just got to trust us on this one, Senator.
Okay. Let me ask you, let's set the caravan incident specifically aside. Since the public commentary about this issue and the reporting about this issue, have either the Minister or the Prime Minister expressed any dissatisfaction to you about the timeliness of AFP briefings?
I've not had a nasty phone call or anything like that.
Text message, an email, a meeting, the PMO, the Attorney General's office?
I don't know what happens behind the scenes. You know, when I walk out of the room, maybe they do say something.
No, I mean to you or to your senior officers?
My team do that.
To you or your senior officers, or through the DLO in their offices, has anyone expressed dissatisfaction about the timeliness of AFP briefings?
Not to my knowledge.
To the knowledge of anyone else at the table?
Not to my knowledge.
No? Okay. Well, have there been any changes made or any consideration given to the thresholds for reporting incidents to ministers?
No, because we have a very flexible system, I think, as Assistant Commissioner Nutt and Deputy Commissioner Barrett explained, and there's reasons for that, and I think we explained those as well.
Okay. Well, I fear I'm not going to get much further here, and I do look forward to police getting to the bottom of this incident, and when you are free to do so, after those charges have been laid, understanding your thinking about why this timing can't be disclosed when it has been on so many other occasions. But I will move on to some other topics now, if I still have the call.
Okay, if I hand the call to
Yes.
Senator Pocock, and then we can always come back to
That's fair.
Thank you.
Senator Barbara Pocock. You have the call.
I have questions that relate to Operation Alicia. I think Mr Nutt has dealt with them historically.
That's correct, Senator.
So,
question, of course.
Mr Nutt, last estimates...
You just have to change your name.
You're not Ms Lisa Gale, I'm assuming.
You're not.
What they do is they go undercover.
Thank you.
So, Mr Nutt, last estimates you gave us details of the AFP investigation into PwC, also known as Operation Alicia. At the time, the AFP had just raided the Sydney offices of PwC. Can you provide the Parliament with an update on that investigation?
First of all, Senator, the AFP doesn't raid. We execute search warrants in furtherance of criminal investigations. I can say that we obviously completed that search. We have undertaken other search warrant activity in furtherance of that investigation. The investigation is ongoing, and I can say that it's not a good time for us to talk into specific details of an ongoing investigation. Needless to say, as a reinforcement to you, Senator, that it is ongoing and progressing.
Do you have a sense of when we might expect finalisation or a public statement about outcomes?
At an appropriate time, we'll certainly do so. We're obviously as keen as you are, Senator, but we're progressing.
You're progressing?
Yes.
Have you undertaken any other, or exercised any other search warrants since you were here last?
Yes, I have. Not me personally, our team.
How many?
I won't go into those sort of details, but I will say that we have executed additional search warrants, yes.
At the office of PwC or elsewhere?
Again, that's a detail on an ongoing operation. What point of difference to my last briefing is that by the time I appeared, Senator, our activity was already in the public domain through media reporting, so I felt comfortable to be able to explain it. Those other actions that we have taken are not in the public domain, so I'm uncomfortable in discussing at this point in time.
We know that whether it's the Senate, the ATO, the Tax Practitioners Board or the AFP, PwC have tried to obscure and conceal vital information at every step. You previously have said that PwC were cooperating with authorities, at least initially. Is that still the case?
That's still a fair assessment, Senator, and note that we had taken, and we're aware of those other activities that you described, and we've taken that into account in terms of our strategy and engagement with.
How has it
PwC.
affected your strategy?
Well, being aware of it, of course. We are the due diligence that we apply to how we engage with both individuals under investigation and witnesses and others. We're aware of that.
Last estimates, you said that PwC had not yet claimed any professional privilege. Is that still correct?
It is still accurate, but I don't know whether I actually said any. So I will take that on notice, Senator. I still think it's accurate.
You believe they have not as yet, either before last estimates or since to today, claimed any professional legal privilege?
Correct. I'll just take that on notice to be sure. I don't want to mislead you in any way, Senator.
Thank you. I previously asked you about what the penalty is for destroying evidence. You advised in question on notice response SBE 24051 that it's an offence under Section 39 of the Crimes Act for a person to destroy evidence. The penalty for this is, I understand, imprisonment for 5 years.
Correct.
Have you had any indication that PwC has attempted to destroy or withdraw evidence from the AFP?
Not that I'm aware of, Senator.
Thank you. Last estimates you revealed that Operation Alicia is examining whether former PwC partners breached Section 70 and 135 of the Crimes Act. And you said there were multiple offences on the warrant, including disclosure of information by Commonwealth officials, general dishonesty causing risk of loss, conspiracy to defraud dishonesty causing loss or risk of loss, and criminal conspiracy to defraud dishonesty causing loss. The maximum penalty for these offences ranges, I understand, from 2 to 10 years. These are clearly serious crimes. Generally speaking, how many prosecutions has the AFP launched for white-collar crime?
I don't have that information, Senator.
Can you recollect any, or can anyone at the table recollect any in, say, the last 5 years?
I think we've had, Senator, a long history in terms of the work that we've done in this space, in terms of white-collar crime and fraud and anti-corruption. I think I know a couple, particularly the last couple of years, and I'm happy to provide more detail on notice, but Operation Borderline, which was a very...
Sorry, I didn't catch the word.
Operation Borderline, which was a complex tax investigation as part of the Serious Financial Crimes Task Force. Five offenders convicted of conspiracy to defraud the Commonwealth and dealing in proceeds of crime. In relation to a multi-million-dollar fraud against the ATO, Operation Albus was also a very complex fraud investigation. In March 23, the core group for 5 of the 15 offenders were found guilty and convicted of participating in a $100 million fraud against the Commonwealth. And then there's a range of investigations involving, successful investigations involving the NDAs. I think if you step back and look at it, I think there's been 2 significant constructs in our work in this space. The original Project Wickenby, which was a joint task force with a range of agencies, including tax, focusing on high-end tax evasion, and with that concluded in 2015. It netted $2.29 billion in tax liabilities, and we successfully convicted 46 individuals, criminal individuals, as part of that task force. And I alluded to the current task force that took over from Wickenby, the Serious Financial Crimes Task Force, which again is focused on white-collar crime, focused on high-end tax evasion. And as of the 31st of December 24, 67 individuals have been convicted and $2.8 billion in liabilities raised, and more than $1 billion in revenue collected. So, but again, Senator, I could speak for a very long time on this one. I'm happy to take on notice and provide more granular detail. I think everyone
would be relieved if you didn't, but would you mind taking on notice?
I'd be relieved if I didn't either, Senator. Happy to take on notice.
I'm interested in both the prosecutions and the successful convictions, and exactly the material you provided on the outcomes in terms of income and... revenue generated?
Yeah, we can provide a lot more granular detail on that, Senator.
Thank you. A quick last question. I wanted to refer to David Ross's article in The Australian dated the 11th of February this year. He stated that the AFP investigation into PwC has, to quote, assembled just 3 documents almost 2 years after the matter was first raised. Is that accurate?
No, Senator.
Can you tell us how many documents you have raised, ballpark?
Not off the top of my head, but you can appreciate that search warrants on PwC, there's the large number of documents that have been obtained, and not only physical but also electronic. That is not accurate.
So a large number of documents have now been obtained by the AFP. Do they include the Linklaters report?
I won't make a specific comment on that, Senator. We're still reviewing the evidence at this stage, so I couldn't be as definitive.
Can you give us any further information about the nature of the documents? You won't tell us how many.
All I can say, they fell within the conditions of the search warrant, Senator.
There have been many senators in our Senate who would like to know whether the Linklaters report has hit our shores and whether it is under examination by the proper authorities, as it should be. You're not willing to give any indication on that because it is a matter of significant public interest.
It's, again, that's evidence review is still underway, so I couldn't be definitive at this stage, Senator.
Okay, thank you. Thanks for your answers and for being here at this ungodly hour.
This is early for estimates, Senator Pocock. I just have a couple of questions about the Pacific, please. I'll keep them as brief as I can. Dinesh, Deputy Commissioner, thank you. While you're coming to the table, I have to say thank you to you because I met with the President of Palau recently, and of course I was very well briefed by officials, but I realised quite quickly into the conversation how big an issue policing was for him and had all of these random facts in my brain because of all of our exchanges. So thank you very much. I noticed in your opening statement, Commissioner, you said that for the AFP, the footprint of the Pacific is non-negotiable. It's been a big part of your uplift over the last a couple of years. I was wondering what the next iteration is on the next event that you're preparing for, and what thinking are you doing, if any, about the preparation for the PIF in September in the Solomons?
Thank you, Senator.
I'm trying to condense as many questions as I could into one.
In fact, I'm not sure if the Commissioner wants to touch on in terms of